So we have like 4 other PowerPoints or something?
Mm-hmm.
Okay. But there's no way to.
It's either
So it makes it seem like you're really smart. That looks good.
the parts of it are
No. It's just say all that. So.
These are reserved speakers. Is there a specific one over there? General election.
Yeah, but so we have one spot for the timekeeper,
Okay.
and then just one for anywhere speaker.
Is anywhere with a flag? Can someone, can we do it?
Jury of 6 of That looks good. So we got the. We're looking at really last.
Testing. 1, 2, 3. Testing. 1, 2, 3, 4, 5. Testing.
Yeah, I mean, for the moderators, for the moderators who are here for a long time, they like to sit on a stool.
So yeah, no, we had a second stool to sit the wall.
Oh, that's what that was? Yeah. It's right here. That's the water stool? Yes. Okay, well, we can,
I'll
just
switch
want
it
to
out
put
as
it,
needed.
I see.
He was quite a participant.
Let's put it like right there? Okay. There you go. We got a water stool. We're all stooled up.
In the back of the room, it is 9 o'clock, and we have a tendency of making our trains run on time here at Case Western. The person who does that is the dean of our law school, who's been absolutely transformative. If you've been reading the newspapers over the summer, our law faculty has developed an entirely new curriculum, which is now being called the Case Western Reserve Model of Law. And so the man who is responsible for all of that and who is a great supporter of our international law program is Larry Mitchell. Please come on down and kick us off.
Thank you, Michael. I'd say you're entirely too kind, although being known as the guy who makes the trains run on time in some quarters may not qualify you for a lot of applause, but thanks. One of the privileges I have of my position is to welcome you to conferences like this. It's something I look forward to every year, and this conference in particular is one I haven't missed and have no intention of missing. Our International Law Conference is part of an ambitious and innovative international law program, and to return the favor, built by Associate Dean for Global Legal Studies, Michael Scharf, who really I could talk about, but it would take me hours, actually, to list all of the things that Michael does. And as a result of Michael's work and the work of his colleagues, we are consistently ranked among the very best international law programs in the nation. In fact, I usually don't do this sort of thing because you live by U.S. News, you die by U.S. News. We're tied with Stanford. That's pretty good. We have a lot to be proud of this year. We launched the world's first international law MOOC, Massive Open Online Course. In fact, when our vice president for IT approached me and asked if somebody in the law school would do it, I said, well, I've got just the person. And Michael managed to attract over 25,000 students. He only did that because he didn't have to grade the final exams. We're the only law school with its own international law talk radio program, again, Michael's initiative, broadcast by Cleveland's national public radio station. We will be the first law school in the nation in January to launch an all-online foreign international business law LLM degree. And we have increased over the past 2 years our student exchange and concurrent degree programs from 3 to 26. In fact, as we sit here, between our graduate students, our exchange students, and our JD population, approximately 20% of our student body is foreign. That is a truly national law school. This annual conference is made possible by a generous grant from the Wolf Family Foundation, and I would like to personally express my gratitude to Jim Wolf, who I believe is with us this morning, for his many years of support of the program. Jim, are you here? He'll be coming in a few minutes. Let's applaud for him anyway. Jim, thank you. In 1806, Thomas Jefferson signed the Treaty of 1805, which was to put an end, at least for the United States, to the scourge of Barbary pirates who had been plaguing Mediterranean shipping for decades. While Jefferson sent warships, I think the real key was he threatened to send John Adams. In any event, in an echo of contemporary international events, Jefferson had spent years from his time as Secretary of State trying to convince the European powers, who were equally plagued, to go in with him militarily, and they said no. So he did alone. Well, his actions stopped piracy for a while, piracy being then a state-sponsored activity. But now the coast has shifted, and the problem is no less real. The World Bank recently estimated that piracy will cost the global economy $18 billion this year. A U.S. jury just handed down life sentences in a piracy case involving the murder of 4 Americans who were hijacked by Somali pirates. And in an undeniable indication of the magnitude of the issue, Somali piracy is the subject of an upcoming movie starring Tom Hanks. Some think maritime piracy is on the decline, but we will hear today that we're on the verge of a new, far more violent phase of piracy due to renewed political turmoil in Somalia and Yemen, and the inevitable drawdown of international anti-piracy fleets from the Indian Ocean. We have brought together 24 of the leading experts in this area to analyze and discuss the best legal responses to this new phase of maritime piracy. Among them, we're extremely fortunate to have as our luncheon speaker General Romeo Dallaire, who will be receiving the Cox Center Humanitarian Award for advancing global justice for his work addressing the problem of child soldiers and child pirates. Thank you, General Dallaire. We also have among our distinguished speakers the Chief Judge of the Kenyan Piracy Court, Rosamel Mutoka, class of 2012, LLM class of 2012, who served also as our distinguished jurist in residence. This conference is a culmination of a 3-year project in partnership with the Public Interest International Law and Policy Group. Michael organized this event and serves as chair of that group's high-level piracy working group. In that capacity, he's organized a series of expert meetings on piracy in Washington. He's set up an academic and law firm consortium that's prepared over 50 research memos on issues relating to prosecuting pirates. Our students' research memos have been cited by the Seychelles Supreme Court and have been circulated by the chairman of the UN Contact Group on Somali Piracy. And Michael himself has addressed the UN Contact Group on Somali Piracy in Copenhagen and traveled to Kenya, the Seychelles, and Mauritius to assist authorities involved in piracy prosecutions. I think Michael only travels to warm places. In any event, this conference kicks off an extraordinarily exciting year of events at our law school, and I just want to take a minute to talk a little bit more about what we do. The conference is a special part of what we do, and annually it begins our international cycle of programming. But largely as a result of what we do here, our students, faculty, and alumni scatter across the globe, working for peace and justice, and helping to promote the growth of commerce and economic welfare. From this small law school in Cleveland, go forth so many people who work so hard to make the world a much better place. That is the kind of student that we admit, that's the kind of student we teach, that's the kind of student we graduate, and that's the kind of program Michael runs. Thank you all for being here. Enjoy the conference, and I hope you come back again.
Thank you so much, Dean Mitchell, for starting this conference off with such a rousing speech, and we are very excited to get things started. Before we do, let me just tell you a little bit about some of our co-sponsors. We've already heard that this conference was made possible by a generous grant from the Wolf Family Foundation. It's also co-sponsored by our own Frederick K. Cox International Law Center, the American Society of International Law, the Public International Law and Policy Group, the Inamori International Center for Ethics and Excellence, the Cleveland Council on World Affairs, the American branch of the International Law Association, and the International Association of Penal Law, and the International Criminal Law Network. That so many very world-class organizations wanted to be part of this event tells you a little bit about the high quality of the speakers that we've brought in and the discourse that we anticipate. You're in for a very exciting day. You've heard from our dean that piracy is in the news. It's having an economic effect. There is an estimate that it is the equivalent of a 1% sales tax for all of world trade because of the cost of combating piracy. That's something that means it affects all of us. And we are excited today to be part of a conference that looks at the end game, the final phase of combating this new version of modern day piracy. Our first panel is going to assess current trends and efforts to combat piracy. And I would invite the panelists to come up, and I will turn the program over to our chair of this panel. And our chair is Michael Kelly. He's the president of the International Association of Penal Law's American National Section. He's been with us for almost every conference that we've had over the last decade, and we're very pleased to have you back again, Mike.
Well, I'm happy to be here, and this is my 10th consecutive year in Cleveland in September, so I know that the trains have to run on time. So we will go ahead and get started. Before I introduce the panelists today, I want to just speak for a few minutes about one of the co-sponsor organizations, l'Association Internationale de Droit Pénal, the International Penal Law Association, of which I'm president and Michael is former president of the U.S. National Chapter. This is a group of international criminal law jurists and lawyers that was founded in 1924 in Paris, still headquartered there. It has consultative status with the United Nations. And it is the preeminent organization if you're interested in international criminal law, genocide, war crimes, piracy, crimes against humanity, aggression, etc. Each country has a national chapter. I would encourage you to check out our website and sign up on the sheet that's going around to learn more about our organization. If you're a professor or if you're students at any American law school, you can participate in our summer school program in Nuremberg, Germany every July. We take students to Nuremberg, right where the Nazi war crimes trials happened, and you learn from day one what war crimes are. We go to crime scenes like Auschwitz. We take you up to The Hague to sit in on current war crimes trials, and we run a moot court in old courtroom number 600, where the Nazis were tried. So it's a blend of history and law. So I encourage you to learn more about that if you're interested in pursuing these kinds of subjects that drew you here today. And we're always grateful to Case Western to keep inviting us again and again to co-sponsor these September conferences. Let me tell you a little bit about the panelists that you'll hear from today. I'm not going to read through their bios. You have those in your materials. Just by way of introduction and a few highlights. Sandy Hodgkin is Vice President and Chief of Staff at DRS Technologies. Prior to that, she was at the U.S. Department of Defense, where she served as the Chief of Staff to Deputy Secretary of Defense William Lynn for detainee affairs. Before that, she was a Distinguished Visiting Research Fellow at the National Defense University. She was previously at the State Department as the Deputy to the Ambassador at Large for War Crimes issues, and before that, she served as Director for International Justice on the National Security Council at the White House. And if that's not enough, she was a JAG officer on top. So Sandy was quite busy before entering private practice. Sulakshina Bakari is the Principal State Counsel at the Office of the Director of Public Prosecutions in the country of Mauritius. She also heads the piracy unit at her office, and she participated in the negotiations having led to the signature in 2011 of the agreement between Mauritius and the European Union for the transfer and prosecution of suspected pirates. She prepared the handover guidance setting out the rules to be followed by Navy personnel apprehending suspected pirates at sea, and she regularly advises on piracy matters. Next, we have the Honorable Rosamel Mutoka, the Chief Piracy Judge from the Kenyan Judiciary. She actually received her LLM in International Criminal Law here at Case Western. So she's a proud alumnus. She has served as a judicial officer within the Kenyan Judiciary for 26 years. She is a council member of the Commonwealth Magistrates and Judges Association, and she also served as a temporary member of the prosecution team in the Charles Taylor trial while she was completing her LLM at Case. Next, we have Ashley Roach, who is a former Navy JAG officer. He was attorney advisor for many years in the Office of Legal Counsel at the U.S. Department of State. He was responsible at the State Department for law of the sea matters. He's taught, advised, and published extensively on national maritime claims and other law of the sea issues, including piracy and armed robbery at sea. Ashley and I will be appearing together in 2 weeks in St. Louis at the Washington University Symposium. And then finally, Ved Nanda. We always save the best for last. Ved is the John Evans University Professor at the University of Denver and the Thompson G. Marsh Professor of Law and Director of the Nanda Center for International Comparative Law. You know you've made it if you have a center named after you. Ved, from 1994 to 2008, served as Vice Provost for Internationalization at the university. He is an honorary president of the World Jurist Association, as well as an elected member of the American Law Institute. Professor Nanda has received the Gandhi King Aikida Award for Peace Building from Soka Gakkai International and Morehouse College. He's received the Lifetime Best Teacher Award from the Indian Law Teachers Association. He was awarded the World Jurist Association Highest Order of Justice, and before that, the World Legal Scholar Award. And he was also the recipient of the United Nations Association's Human Rights Award and the Anti-Defamation League's Civil Rights Award. In fact, if Ved actually wore all of his awards, he would look like a Soviet general. But seriously, Ved is widely recognized as the father of the International Legal Academy, and those of us who are in it look to him as a leader, and we would be lost without him. So we're happy to have him here from Denver. Our charge today, leading off this symposium, is to assess the current trends in piracy. But before we get to that in kind of a roundtable way, I want to nail down a little bit about the definition of piracy so that we can have a bit of a framework today for our discussions going forward. Piracy, as you know, is an ancient crime. It was the first international crime. It was recognized as far back as 800 to 900 BC in the Rhodian Sea Laws. Indeed, the Rhodian Sea Laws were the laws that were in effect when Julius Caesar was captured by pirates as a young boy in 78 BC and then later ransomed. Cicero in Rome declared pirates enemies of all mankind. But legal definition is what we need to wrestle with today if we're going to successfully prosecute pirates. And this definition can be narrow or broad. And the wrangling over a narrow or broad definition to piracy is not a recent phenomenon, although it certainly haunts us today. You go back to the 17th century and the mid-1600s, and you find an argument between Gentili and Grotius over whether the definition should be narrow or broad. Does it include privateers or not? They obviously had different things on their minds, but the elasticity of this definition was never really settled. Just as recently as 2010 and 2011, we had a split in the United States in Virginia, in the Fourth Circuit. Two federal district courts in Norfolk, Virginia, came out differently. The first court, who was prosecuting Somali pirates for attacking the U.S. warship Ashland, came out with the definition robbery at sea. And they acquitted the pirates because there was no boarding of the ship or stealing of merchandise. They were overruled later by the Fourth Circuit. But before that, not the same court, different judge in the district court, applied the definition that was used in the United Nations of violent attacks at sea and convicted those Somali pirates that attacked the U.S. warship Nicholas. So the Nicholas decision and the Ashland decision were in direct conflict, and it really kind of mirrored the old debate from the 17th century between Gentili and Grotius. In the Ninth Circuit, very recently, in the Ali case, we had an adoption of the UN definition, which was broader, and then added to that was the idea of conspiracy to commit piracy. Now, as you know, conspiracy can be a very broad net. And as a policy matter, you kind of have to decide whether you're going to cast this net as broad as conspiracy will allow. In that case, the question was whether the environmental group Sea Shepherd could be considered pirates, right? Because there's a question of violence at sea. So let's talk a little bit about the definition first before we get to current trends, and I'll call on Sandy Hodgson to lead the discussion on that.
Good morning. Thank you, and I'm happy to lead this first discussion. First, I have to at least mention that I'm tremendously honored to be on this particular panel with so many incredible colleagues. Professor Nanda was one of my mentors going through law school, and so I'm always just delighted when I can be near him in a conference, have the opportunity to share thoughts with him. But I'd like to start this part following up a little bit on some of the remarks that Professor Kelly made starting out. The definitional aspects are important to piracy, and the reality is, as attorneys, we often get caught up in what are we going to apply definitionally, what are the elements of the offense, how are we going to get a conviction, what is the most broadly applicable way, and there's a lot of good debate over that, particularly in the area of piracy. And one of the reasons is, piracy does go back a long time, as Professor Kelly mentioned, and, with the traditional robbery at sea definition is what most people still think of as piracy. There are just so many other acts that occur at sea in the process of pirating that to prove the element of a theft at sea can actually be a little bit harder, as we saw in the U.S. beginning on the piracy cases. The definition is evolving, but at the same time, it's splintering in some ways too. I mean, I think there's been at different times a push to try to get everybody on one definition or everybody to join consensus around either the UN Convention on the Law of the Sea definition from Article 101 or whether you go towards the SUA Convention's way of treating piracy. And I'll give you sort of the definitions of each of them just so that we have those for purposes of this discussion. But the reality is there's a bit of a mixed bag because countries implement into their domestic legislation those laws they find the easiest to prosecute, the most convenient, and based on the circumstances at the time that you're trying to implement them. And so I'll mention a few with respect to Somalia in particular. So starting first with the UN Convention on the Law of the Sea definition from Article 101, much broader than robbery at sea. This one specifically goes on to say, any illegal act of violence or detention or any act of depredation committed for private ends, so private ends are critical, by the crew or passengers of a private ship or private aircraft on the high seas or against a ship or outside the jurisdiction of any state. So the high seas element of the UN Convention on the Law of the Sea definition is another important one to note, because if you use UNCLOS definition, UNCLOS being the UN Convention on the Law of the Sea, then you are limited to the high seas unless something else happens to change that. In the case of Somalia piracy, the UN Security Council, based on a request by the transitional federal government in Somalia, based on their basically consent by requesting assistance from the UN Security Council, applied the UN Convention on the Law of the Sea definition to the territorial seas. And so they closed a gap that's there inherent in the UNCLOS definition, but it's one that when you go beyond Somalia, you need to make sure you do gap closing if you're going to use this definition going forward. And so while many countries are adopting this definition, as it's broad and good for the purposes of sort of a catch-all, it has a big territorial limitation. And so that has to be addressed. Another way of addressing that, besides on a case-by-case basis, would be the idea of developing more customary international law on the actual use of this definition within the territorial sea, but that would be extremely controversial at present because it was specifically excluded in the UN Security Council resolution. The UN Security Council specifically said that our application in this case to the territorial seas of Somalia of the UN Convention on the Law of the Sea definition will not be used as development for customary international law. So I don't think that trend will actually happen, but that would be another way to get around this limitation of the UN Convention on the Law of the Sea definition. The SUA Convention similarly has a very broad provision. The definition in the SUA Convention that's most generally been used to deal with the issue of piracy is the seizing or exercising control over a ship by force or threat of force. So here it's very broad. There's, again, no robbery, but here it's actually the seizing or exercising control over a ship by force or threat of force, or performing an act of violence against persons on a ship. So there's another fairly broad category, and again, most of the recent piracy cases you can easily apply here. In fact, the U.S. has successfully had several cases use the SUA definition as it's been implemented by domestic legislation into U.S. law, the Muse case, the Li Shi case. So there have been a few where this has also been a legitimate basis for criminal prosecutions. And one of the advantages of SUA is that while it does have a somewhat confusing territorial application when you actually read it facially, it's been interpreted broadly enough to include the territorial sea for a ship that's transiting through the territorial seas. So you have a broader applicability using SUA, which would be an advantage to using the SUA Convention over the UN Convention on the Law of the Sea. But the UN Convention on the Law of the Sea is also incorporated into many domestic laws of states that prosecute pirates. As we move forward and we look to the future of what is the definition that's going to work, when we look beyond Somalia piracy, which when we talk about, you'll hear a lot about the trends and where piracy may be moving, if not Somalia, we need to look closely at the, territorial limitations of the UN Convention on the Law of the Sea definition and/or how to address that, and/or encourage countries to simultaneously make sure they have domestic legislation implementing the SUA Convention, while the UNCLOS may be preferred in some areas. So that's one of these education issues as we do judicial training, as we do training of judges, prosecutors, and investigators for potential piracy cases. And I'll come back on some other comments about prosecutions after we've heard from others on trends.
Anyone else want to chime in on the definitional problem of piracy on the panel? Ashley?
I just wanted to add that although the U.S. is not a party to the 82 Law of the Sea Convention, we are a party to the 1958 High Seas Convention, which has virtually the same language. So it is the rules that are international recognized, we're a party to, it's just we're not in the same instrument.
Ved?
Just want to add that 101C of the 1982 convention does permit facilitation as a basis for prosecution. And our own court, as you were talking about, the District of Columbia case came before the circuit, and the circuit court talked about it, and at the present time what has happened is Fourth Circuit or DC circuit, and you look at facilitation permitting the court to go after those who have committed acts only on land. And these are the people who might have given money, these are the people who might have been involved in negotiations for ransom, and even that can be permitted then under the 101C. And then that is going back to the 1958 convention, because 1982 convention, as rightly said, simply had the same language as the earlier convention. So it can be used even to go on land and not on the high seas and not even on the territorial waters if permitted by the country, coastal state.
Yeah, that's raised this euphemism, dry land pirates. I'll give you a minute to wrap your mind around that. Dry land pirates. Ashley?
I just wanted to add another technical point. The word high seas, which you find in the 82 convention, is actually imported into the EEZ regime. So the piracy regime under the 82 convention applies seaward of the territorial sea, not just in the high seas, which is seaward of the EEZ.
Anybody else? Yeah.
Maybe just one note. I mean, as far as we are concerned, when we had to think of legislation which could actually provide for all of this, what we did in drafting legislation was to take UNCLOS because we thought it was too entrenched to play with the definitions, but also combine SUA provisions in the same piece of legislation so that you have a wider range of offenses to choose from if you want to go ahead.
So when Mauritius took that decision, Sulakshna, I mean, did they just lay all the definitions that were available out on the table and pick the best provisions?
As widely as we could. We took UNCLOS Articles 100 to 107 verbatim. We didn't play with that at all. We put it in the schedule to the Act and said this is the definition we'd go for, but also understood that there could be other things. If it's not high seas, if it's territorial waters, what kind of offense could you provide for? So then the offense of maritime attack in case it happens within the territorial waters. We tried to cover as many scenarios as possible, but the legislation remains to be tested.
Well, and of course, all of the prosecutions that happen for pirates are national prosecutions.
Yes.
We don't have international prosecutions, even though we've got a pretty vibrant international definition. Is this something ripe to be added to the ICC's jurisdiction, do you think? Ashley's shaking his head
No.
no.
And there's at least one good policy reason for that. Remember, piracy is ordinary criminal conduct, and that's not really what the ICC was formed for. You're dealing with much more serious kinds of crimes, and it's because of the ICC's sort of track record in terms of time, and the number of pirates we're dealing with. We've got over 1,000 pirates that are already either in prosecution or in jail or awaiting trial. That would be an unbelievably difficult workload for the ICC to take into account.
But you know, ICC goes such glacial speed that we should give piracy to them.
Well, and of course, the most famous national court recently to prosecute pirates has been Kenya. So, I mean, you know, Rosamel, your country has been deputized by the world community as the International Court for Piracy. Did you feel pressure to just adopt the UNCLOS definition without any alterations when you were first cast into this role?
Thank you. Well, for Kenya, I think it was a little easy for Kenya because piracy was provided for in the penal code. But we had a problem when we started prosecuting piracy under that provision because we did not have the UNCLOS definition until much later when we had the Maritime Act that was that was enacted maybe about 3 or 2 years after we started the prosecutions. And then at some point while we were continuing with the trials, one of the cases that was before us was they challenged the issue of jurisdiction, and because the trials were done at the first instant courts, and so they went to the High Court and said that the magistrates courts that were trying piracy cases did not have jurisdiction. And the judge actually did uphold that, that argument, and so stopped all the prosecutions that were going on. But then the matter went to the Court of Appeal, actually last year when I was here, just about the time I went back home, the Court of Appeal gave a decision after about 2 years, because we had some upheavals. And one of the things the judges of the Court of Appeal said about this judge who had this matter and now was appointed and was in the Supreme Court was that he based his decision on conference arguments and not the law. And that because then by the time he made that decision, we had a new constitution that had domesticated all the treaties that were ratified, and of course one of them being UNCLOS. And so the court argued that we were going to rely on the definition of piracy under UNCLOS, and that is what was going to guide the question of jurisdiction. Thank you.
Well, okay, that's, we are unresolved on the definition, which exactly mirrors the situation. So let's move to our topic for our panel, the current trends. And Sulukshna, do you want to begin the discussion on current trends? And we'll just move right down the line.
Yep, I have a PowerPoint, is it?
You have a PowerPoint, okay. This one? No.
Well, thank you very much. Michael, you've been very kind and gracious with the introduction. And Michael, thank you for having me. I've been here before. And you really set a model, first for parties, and second, and second for conference, and both of them are great. And I want to thank you very much. I've been here before and I've enjoyed it. And it's wonderful hospitality. I think I would suggest that anyone who is going to have a conference talk with Michael and talk with Nancy Pratt and take their advice. I was just a few days ago giving a talk somewhere, and as I was walking in, someone showed me a little piece of paper saying, "Friends don't let friends do PowerPoint." So I'll just simply talk. And my title of the paper tells what I'm going to say. And the title is Moving from Crisis Management to Sustainable Solution for Somali Piracy, Selected Initiatives and the Role of International Law. You'll have to read this dull paper later on, so I won't go through it, but I'll make a few points pertaining to these initiatives. First, I do want to say that this crisis management has succeeded to some extent. I won't take you through all the numbers. Our paper goes back from 2009 to 2013, and how the IMB, International Maritime Bureau, their piracy, they follow all these pirates and piracy numbers. And similarly, IMO, International Maritime Organization, does it. Their numbers differ a little bit, but the trend is pretty clear. And that trend is because of these forces that are naval efforts in the Gulf of Aden, off the Horn of Africa, and off the coast of Somalia, whether it's the European Union's efforts, along with NATO, along with the United States-led efforts. And you find today almost 40 countries involved in these kind of efforts. And combined with all that, today most of these ships, although initially there was a great deal of resistance, but they are having these armed forces on it. And these are people who are contracted, and they are providing a great deal of resistance to pirates, and they are succeeding. But the point simply is that these measures alone are not going to do the trick. And a recent study by the World Bank in March 2013, NATO Secretary General's comments, almost all who have been watching, observing this area, tell us that the long-term solution is not going to be simply sustainable, this temporary efforts on our part. Sooner or later, at the present time, European Union has said 2014 is the time. Many others might, these naval vessels not be there. And how long and how much money are you going to be spending on these security forces? And security forces are not accountable at times. There have been unintended kind of consequences, fishermen killed. So today, this effort, these trends that we see, short-term kind of efforts to have crisis management, is not going to lead to permanent solution. And the fact also is that maritime piracy, it continues to be an ongoing threat, obviously, to international navigation, to trade, to maritime and regional security. And this scourge of piracy, then, is going to demand long-term and persistent efforts to prevent, deter, and combat this ongoing threat. In this paper, I started looking at all these actors, from the Secretary General of the United Nations, General Assembly, Security Council, And then you can go on to all these regional kind of settings, special initiatives taken by countries in concert with each other. And if you look at all of them, you come to a conclusion that, again, this short-term effort has succeeded. Let's look at the Secretary General's recent couple statements I want to bring to your attention. June 26, 2013, Ban Ki-moon welcomed the successful conclusion of the summit of the Gulf of Guinea heads of state and government on maritime safety and security, and the adoption by the summit leaders of the regional strategy against piracy of West Central Africa. Because as you found that off the coast of Somalia, piracy incidents had declined, coincidentally on the west coast, you found that those incidents had increased, and increased in a fashion that was not off the coast of Somalia, because here they are simply stealing the cargo. They are simply going after, not ransom, they don't take the ship, they simply steal everything, valuables, and they are not trying to keep hostages. So it's a different kind of setting. And then you look at the Southeast Asia, and the numbers there have arisen. And I looked at, there are other statements by him, but on the Security Council, as you know, they have almost passed 13 resolutions, starting in 2008 when piracy began its kind of ugly head all over. At that time, they had looked at a Somali case, and they had permitted, as you recall, for the nations to be able to go in the territorial waters with the assistance of, with the approval of the government of Somalia. And after that, the resolutions keep on. Let me just mention two resolutions to you. The point also has been, what do you do with these pirates? Many of these pirates are simply let go. People don't want to, countries don't want to take them to their own places to try. Evidence is lacking at times, it's very costly. And once you have prosecuted the pirate, alleged pirate, and you have given a sentence, and the likelihood is that that person doesn't want to go back, is going to seek asylum. And so there are all kinds of problems, and therefore, in many instances, they simply let them go because pirates, the alleged pirates, they have thrown their weapons out in the sea, and you can't have credible evidence to be presented to a court thousands of miles away. And that is why at the present time you find that many countries that don't have in their own laws implemented this universality principle. And that is the reason today that you don't find many countries willing to do that. And I am deeply grateful, as all of us are, to Kenya, to Mauritius, to Seychelles, to be able to assist the world community in taking on that burden. I want to simply mention one more Security Council resolution, and here the contact group and its working group 2 had done a whole lot of work initially, and they had presented 7 possibilities of the way to perhaps prosecute. Let me just mention them to you to briefly. UN to enhance assistance to build the capacity of regional states to prosecute and imprison suspected pirates. Establishing of a Somali court sitting extraterritorially. You remember the case of Libya and those Libyans that were prosecuted in The Hague because not in Libya, extraterritorially under Libyan, under the Irish law? No. Scottish law, yes. Establishment of a special chamber within the national jurisdiction of a state or states in the region without UN participation. Fourth, the same with UN participation. A regional tribunal not embedded in national jurisdiction established on the basis of a multilateral agreement among regional states with a UN participation. The same thing without UN participation. And finally, an international tribunal established by a Security Council resolution under Chapter 7 of the UN Charter. The President, the Security Council had asked the Secretary General to have a special representative look into all this. A great deal of effort has been going on, but finally, as you probably know, no possibility of under Chapter 7 a new tribunal to be created, no possibility of international tribunal. So at the present time, the thought always has been that let us build the capacity, let us have these special tribunals created by these states, and regional bodies might help out. And then therefore at the present time, Kenya, Seychelles, and Mauritius have been very, very gracious in undertaking all that. I was going to walk you through International Maritime Organization and what it does, because they have all been, if you look at the initiatives and current trends, they have all been making a great deal of effort. NATO, European Union, I won't take you into any of them, but their working groups, and this is an amazing, amazing setting. Those people who have worked with them tell me, but I haven't gone to any of them. But as I read it, as I hear from people, they tell that this contact group, very informal, but very, very successful, proactively, effectively working, notwithstanding it's being an informal, ad hoc forum. It has no budget, no secretariat, costs little to function, but the strength lies in flexibility, its coordinating role, and trying to bring about that cooperation among so many actors. Combined Task Force 151, this is under the US leadership, and its mission again is to disrupt piracy. I was going to mention to you very special work that the United Nations Office on Drugs and Crime does. And they are absolutely amazing, because as you look at the current trends and how many international organizations, how many regional groups, how many countries all have put in their own resources, and in a concerted fashion, they have been trying to find an end to this scourge. US response, I think, has been mentioned in these two cases. In this paper, I go through those two cases very carefully, but we have talked about the definition, and there's a whole lot in these cases, but it simply gives you an indication of how diverse all these efforts can be. We just heard about Mauritius, you can hear about Kenya, and you can find again the difficulties. There's a whole lot that you can talk about the private maritime security companies, and this paper goes through thoroughly into where at the present time we are, how many different standards are being used, international efforts, national regulation, efforts by NGOs, and I think if I have to just summarize it, their criminal jurisdiction at sea, and in some cases, criminal law in a case of mistaken identity at sea. And I think if I have got to sum up, I would say that although many have suggested that private maritime security companies exist in a legal of gray area or vacuum, this is not the case as it relates to prosecuting a case of mistaken identity. Many states possess the required jurisdictional, substantive provisions to prosecute such a case, which they may exercise concurrently. Thus, in the situations as they are, any lack of deterrence is not the result of inadequate codified regulation, but rather a lack of incident reporting and law enforcement at sea. There is an issue, a major one, about Somalia to have exclusive economic zone. The Security Council has asked, the Secretary General has asked, and recent attempts have been made in order to see that they have an exclusive economic zone. The difficulty in this is that they have competing, conflicting laws. They had a law that declared that Somalia is going to have 200 miles territorial sea. Now that's not possible, that's not permissible. And then they had another law saying that we have accepted UNCLOS definition. And then later on, again, their utterances have been in conflict. I'm going to do that pretty soon. Let me just complete them. All kinds of difficulties. I told them, the editor told me, he said, they are the enforcers, and they are going to tell you. I said, I'm hard of hearing. Then he said, they'll tell you and you can read it. I said, I don't look at them. I look at the audience. So in any event, I'm going to stop, but let me just finish it by saying one thing, and that is my conclusion. And I do need to make that conclusion in terms of recommendation that there is uncertainty and an important aspect of the transition from crisis management at sea to a sustainable situation on shore is to continue cost-effective suppression at sea while capacity is built within Somalia in that region. At this stage, it appears that private armed security will be a major part of that interim suppression, making the regulatory efforts, particularly improved incident reporting, critical to a sustainable transition. So what major elements are needed for capacity building? I won't go into them, but these twin aims of improving law enforcement capacity, creating economic opportunities along the Somali coast will require a comprehensive strategy that takes into account Somalia's complex politics. And some leaders, financiers of these piracy groups who constitute part of the land-based criminal network reside outside Somalia. Hence, to disrupt these pirate money flows, they need to be apprehended, they need to be prosecuted, their operations must be shut down. And for this to happen, let me just simply say at the end that to work with the FBI, Europol, Interpol, international community must make an effort to shut down these networks. And therefore, I know that there are many of my colleagues who don't like 101C to be applied in facilitation and going on land, and they obviously point you to many risks involved in it, but I personally feel that that's very important that we do as a policy matter, and I want to thank you for your kind attention.
Thank you, Ved. Sandy, what do you have to offer us on current trends?
Okay, well, since we've just heard two excellent sets of views on the current trends, I'll try to pick up in a few areas, give a few perspectives on it, and continue to move down the line. I do note, though, that, Michael, you should be very flattered that Professor Nanda has acknowledged your party-throwing abilities with your conferences, as he was the original professor to coin the phrase international law through wine and cheese. And so we would, every single event always involved wine and cheese. And I have kept that with me through my own diplomatic career, found it actually worked in most parts of the world. But to pick up on a few of these trends. So, I thought one of the more interesting facts we've heard all about, Somalia going down. We can credit to a number of things we've been talking about. One of my favorite facts of the year was when the notorious pirate leader, Mohammed Hassan, officially declared his retirement from piracy. As though this were a profession that you can officially retire from.
He is not pension funds.
I know. And that it made world news. And obviously it was a lucrative employment. And so, we need to be noticing the fact that, yes, we're doing some of the right things in Somalia, and we should pick up on all the best parts of those trends, and then look at where we have to modify them for other areas. And so, his retirement, because he's perhaps financially lucrative, or perhaps because he realized that, as I think Ambassador Winkler put it from the legal committee of the contact group, when there are, 3,000 or so active pirates out there, and 1,000 of them are in jail, and another 300 have been killed at sea, it starts becoming a little bit less lucrative of a game, because it becomes a little more a game of odds. And so, by triaging in all the different ways that we've attacked this problem as a world community, we've actually been tightening the noose in that area. Like the drug trade, though, it'll move, and it is moving, and the tactics change and adapt. And that's one of the things that we have to be mindful of, is complacency over what we've accomplished so far. But to echo the point about how effective the international naval patrols have been, extremely costly, ending up at the end of 2014. I doubt they'll be renewed in that area unless there's another rise. And we'll need to look to the future. That may be the one thing that's the most difficult to sustain because of the cost and because of all of the political will you need to get. You need to have a problem in order to do it. And so the consciousness grew in Somalia over time, and getting ahead of it with these naval patrols would take time and a lot of resources. You may start to see, though, national navies take this on as part of their roles, though. When they look at some of the missions they provide through their own domestic law enforcement, this may be something they continue to look at, but it may be much less of these grandiose international naval patrol than what we've seen. But we're certainly appreciative for what we've received over the past several years. The trend towards the armed guards on vessels, which has really gone up, and I think you'll have a panel discussion where you get to talk a little bit about the rules for the use of force, which have been probably the most significant legal issue of privately arming these guards on the commercial vessels. But that trend, it is costly. The average ship has had 4 or so guards put on it, commercial vessel, and there still remains the fact that not one commercial vessel with these private security guards has been hijacked yet. And so it's a great statistic. And so I'm not sure that trend will change. I mean, that may be a continuing tax that goes on commercial shipping as this continues to move around the world. I mean, it's hard to imagine the first ship owner who's going to say, I'm going to leave the guards behind, and how his crew will feel about it. And so I don't know what the standard will become, but that's something to watch. Along with, the armed guards, which is one of the sort of best management practices, there have been a number of other ones that I think probably will continue wherever this goes. Sort of the higher training of the crew, moving through at faster speeds. One of the problems was that they had been slowing down the ships going through certain areas, and now they're speeding up, higher cruising speeds, positioning lookouts, rerouting in certain cases. I mean, all of those practices that have been developed within the shipping industry probably won't be abandoned, and they'll probably migrate as the piracy issue migrates. So it leaves us with this question as lawyers about how does this trend towards regional prosecutions migrate with the piracy problem. I'm a personal advocate that the way that this has developed is exactly the model that you would want to continue to replicate. There's a lot of advantages to it. One, you do get to strengthen capacity for investigations, prosecutions, wherever you do it, which is always a good thing. Never hurts, always might help. And at the same time, it's been proven to be much more cost effective than the standalone tribunal. Everybody's agreed, I think, on this panel so far that the International Piracy Tribunal idea, at least for now, is abandoned. I think it probably will remain abandoned just because of all the tribunal fatigue and the high costs of these standalone courts. Even when, the special advisor Jack Lang had proposed at one point looking even at a specialized tribunal outside of Somalia, there was some challenges on the extraterritorial jurisdiction aspects. And so having something closer to the scene with willing, interested states, with UN support and other country funding through a pool of funding is a great model, and I think has brought us a lot of success here, as it has in other parts. And it does seem to have a deterrent value. I mean, the biggest question that I think we've had from these prosecutions has been whether or not the people we are actually prosecuting are the people who are carrying out the crimes at the highest level. And I think to date our answer is no. I mean, we don't think we've gotten most of the higher ups, the financiers, the real ringleaders. We forced one into retirement, but we haven't actually prosecuted him. And so the deterrent value of that is something we need to continue to sort of sharpen our pencils on, making sure we have every tool that we can possibly have on going after the higher ups. Because you can go after lots and lots of foot soldiers, but it's not going to solve the problem. And we've seen it with the drug trade, we've seen it with other organized crime, and we should learn those lessons. But I'm an optimist. I really believe that, compared to what we thought as academics over the last couple years, could we really get an effort in place that successfully was prosecuting in a number of places? There's been a tremendous amount of political will from several regional countries, and a lot of hard work in trying to make the most broad and most expansive jurisdictional bases and opportunities for prosecutions. And I think those success stories will have to carry to the next region. So I'll pass for now, and we'll come back for questions.
Okay, Ashley, your PowerPoint is already up.
Yeah, but I need to come up and look at it because I can't turn around and talk. Oh, there are too many people.
You can man the podium if you
If I
like.
could, yes.
Yeah.
Perhaps easier. And besides, you get to sit down. On the bridge. All right, yes, indeed. Now, let's see, this is just like my computer. All right. First off, Michael, thank you. Thank you for having me here. Thank you for having a great party. It is the way you make friends, and you do it in an informal setting. For all of you in the audience here, I'm going to talk about the solutions in part to what my colleagues have put forward. Because what you don't hear about in discussions of piracy is the fact that there's a whole bunch of other international treaties that are absolutely useful, absolutely applicable, and in the context of East Africa and the Horn of Africa, most of those states have actually ratified them and have, one way or another, some form of domestic legislation. And and I'll go through three of them in a few minutes. The paper's much longer, and hopefully you'll get a chance to read it in due course. But the central message I'm trying to get across is, if all you think about is pirates, and you don't think about the people who were financing the pirates, who were organizing the pirates, who were facilitating, I'll use that 101C word, their success, and you rely solely on the customary international law, the treaty law of piracy, you've given up the opportunity to use so many more tools that are available. All right, now you know what I'm going to talk about. Here's the outline. I'm going to focus on hostage taking. We haven't heard much about that yet. And the SUA conventions in the context of the Djibouti Code of Conduct. A little bit on criminal jurisdiction at sea, the obligations of states parties to these treaties, what the offenses are, who's liable, and then how it applies in the context of piracy and armed robbery at sea. And then a little bit of just very summary of the provisions in these other conventions with regard to arrest, prosecution, and law enforcement cooperation. And then a little bit of conclusions, and then the last slide lists a whole bunch more treaties that I didn't go through that are also available and need to be used. And that's because you've got a dozen or more UN conventions which establish a cooperative regime to combat specific offenses by making them, quote, international crimes, unquote, among the states parties. 3 of them at least can be used with regard to the offenses we're dealing with here: hostage taking, the current 2008 1988 SUA Convention, and then the revision, which has a whole bunch of useful things in it. But the point is that each one of these conventions establishes a similar cooperative scheme among states parties. Quickly, the hostage-taking convention goes back to 1979. It's been in force since 1983. There are 171 parties. There are actually more parties to the hostage convention than there are at UNCLOS. And in the context of the Djibouti Code of Conduct, all of the participants are party except Eritrea, the Maldives, and Somalia. And Somalia is the one theme that goes through all of this because they're not a party to any of them. And that's one of, I think, the major challenges as they develop a maritime strategy and begin to cooperate and do that. They need to come on board the rest of it, because if you're focused on keeping the acts of piracy at sea off Somalia down, you've got to make sure that the situation ashore in Somalia distinctly improves. And that's the big challenge. There's in fact a conference in Dubai next week that's going to focus on that. And that's where the future, I think, is what can you do to sustain the growth of a viable government and of viable businesses in Somalia. In terms of the SUA Convention from 1988, that, of course, was created after the Achille Lauro incident, when they decided that the acts of the Palestinians that were on that Italian cruise ship didn't amount to piracy under the traditional rules, but yet you needed to have some legal regime for dealing with people that interfered with the safety of maritime navigation. And that's how you came up with this, that's why we came up with the SUA Convention. It's now broadly enforced, and again, you find all of the participants in East Africa, except Eritrea, Ethiopia, the Maldives, and Somalia are party. And it seems, from what I can tell, and I'm no student of this, but it would be worth, I think, a very exhaustive study, is to look at what, for example, UNODC has put up on their website and see what the domestic legislations are in enforcing all that. Are they good enough? Do they need more? I simply don't know. There's clearly something there for most of them, because you just look at the website and it's by country, and it's got links to all of the laws. But having observed a similar process in ASEAN about 2 years ago, dealing with the piracy issue there were some very good studies that were done of the national domestic legislations in each, and there's a lot of differences that came out, a lot of holes, but it was very productive. The SUA Protocol of 2005 is one of those instruments that developed after 9/11. It is actually in force, but there are not very many parties yet, and none of the Djibouti Code of Conduct countries are parties. Why would they care? Well, there are two things I think that they would care. One, it updates the cooperative texts that are involved in that, which I think is an important move, so that it's sort of uniform across that. And second, it provides a uniform boarding provision that had previously not appeared in any multilateral other than the Caribbean counter-narcotics agreement on how you go about boarding ships. And as a diversion, but let me just make this point so you just be aware of it. In the context of piracy, perhaps the single most unique factor of that is that in the at-sea context, if you're a warship and you come across somebody who's suspected of piracy, you don't have to get flag state consent to board. All the other treaties maintain the flag state consent regime. But my own sense, and I spent 20 years working this issue, most flag states now understand what they have to do to be able to respond promptly and quickly to requests for assistance in the boarding. So I don't see that the fact that any of the terrorism conventions don't have a waiver, if you will, or pre-authorization of the flag state consent is really not a bar to that. And these more modern conventions, as you'll see shortly, have so much more in them to facilitate in the law enforcement mode. Just briefly, criminal jurisdiction at sea depends on where you are. As I just mentioned, flag state permission is required, other than in the piracy context. And in the territorial sea, no foreign state can board or arrest without coastal state. So you have the same kind of communications requirements to be able to deal with whoever is the law enforcement at sea wanting to be able to operate in the territorial sea and assist. And you have the same communication situations in the context of the Caribbean maritime law enforcement agreements. We set up structures to do that, and it's worked very well. Now, this is perhaps the key, one of the key slides, I think, because just because you ratified a treaty, oftentimes they say, oh, we're all in compliance now and we feel good. Well, unless you've met the obligations to take national steps, you really haven't helped the world. You have to make offenses that are listed in the convention a crime under your national law. And that's what Mauritius has just most recently done. There are bits more to that, of course. It's not just making them a crime. You need jurisdiction provisions. Found in jurisdiction, for example, is one of the ways where those who otherwise normally would not be involved, nevertheless, can be given authority to deal with a foreigner who's present in their territory. They all have prosecute or extradite provisions, and that's, of course, key to the whole mechanism of moving the process forward. And then each one of these conventions has a whole series of measures on how to provide assistance in connection with criminal proceedings. Complicated, but nevertheless very, very important. Briefly, under the Hostages Convention, the offense is the seizure or detention or threat to kill, injure, or continue to detain a hostage in order to compel a state or a person or a group of persons to do or abstain from doing any act as an explicit or implicit condition for the release of hostages. Who's liable if you have that factual predicate? Well, obviously any person who commits hostage taking, but you have an attempts provision included in there, and this is back in 1979. And then you have an accomplice provision, which is in there. Now, bear that in mind when you see how that's evolved, because there are broader bases that have come forward. Under the SUA Convention that we've heard, if you seize or exercise control over a ship by force or threat of force, any form of intimidation or perform an act of violence. That's the key there is, one, does it endanger the safety of navigation of the ship? And two is the territorial provision that you mentioned with regard to navigating internationally is basically the simplest way to describe that. Under the SUA Protocol of 2005, they've added a whole bunch of new offenses, primarily post-9/11 driven. The use of weapons of mass destruction, the transport of WMD, but more importantly for what we're talking about here, accomplice provisions, aiding and abetting, which are not in the 88 SUA Convention. So you're bringing forward to older treaties the modern concepts of international criminal cooperation. Liability, and you see it here. Obviously you commit or attempt to commit, or you participate as an accomplice. You've seen those before. But then you've got explicit statements. Organize or direct others. Now these are the big guys. Or contribute to the commission offense by a group with a common purpose. So again, you've expressly expanded the group of individuals who are criminally liable under these treaties. As I told you, that the shipboarding hasn't really changed. In the context of Somali piracy, it seems to me that it's perfectly acceptable if the prosecutors wish to do that and there's adequate domestic legislation to go with it, that you can apply to the Somali piracy business model, if I can use that in quotation marks. Clearly, the Hostage Convention applies because that's their business model. They want money for ransom. And so you've also got a SUA 88 offense because all of these vessels are, one, in international navigation, and two, the ship has been seized by force. So you've got, it seems to me at least, clear violations of both the Hostages Convention and the 88 SUA Convention, assuming from a national prosecution point of view, you've got adequate domestic criminal law to carry out your international legal obligations to make them crime. Now, just quickly to go over the other items, in terms of arrest and prosecution, we've already described about what those rules are, but you've got found in and you've got prosecutor extradite. You have the master in the SUA Convention and the things which he can do. And in the Kenya context, Kenya is a party to the 88 SUA and the 79 Hostages Convention. So they have an international law obligation to do what they have been doing. As you heard, there were some difficulties with regard to the domestic legislation and how it was interpreted. But that's where it's important to understand. There's an international legal framework that will help very much. But you can't get to first base unless you can hit the ball, and you can't hit the ball if you don't have the domestic legislation to deal with that. Same thing here with that. Just briefly on law enforcement cooperation, there are provisions on extradition, mutual legal assistance, both in those three conventions. So it seems to me, in conclusion, the hostage-taking convention and the SUA conventions, in fact, do fill many of the limitations that people have identified in the international legal framework of the law of the sea. And as you've heard us say many times, and we'll probably hear for the rest of the day, if the states in the region ratify and effectively implement these treaties and others, you have so many more tools for the toolbox to deal with that. And then just to mention, because I didn't have time to do it, there are these other conventions which also are helpful in particular piracy contexts, and particularly the first three. The first three are most important for dealing with the guys who are making the money, the pirates ashore. And there's just now, I think, beginning to be a focus on that. And we'll hear from our Interpol colleague later, where I think he's going to give us a whole lot more understanding of how we're going after the financing side of the house. And that's it. Thank you very much.
Okay, finally, Rosamel, you are the anchor on the morning panel, so please go ahead.
Thank you very much, Michael. Let me take this opportunity, first of all, to sincerely thank Michael and for inviting me here again. This time coming in this capacity and not as a student, not sitting on that side, and my stomach churning every time they talk about assignments. Something very bad when you're at my age, sitting with people younger than your children in class, and wondering whether you'll even pass. Forget about do well. So thank you very much, Michael, and also take this opportunity to thank Nancy Pratt I think on behalf of all the speakers for facilitating coming here and making it very smooth. So anyway, I think I'm the only one in this room who's entitled to sit back and sort of say, been there, done that, you know, coming from Kenya, where we've had, you know, all these cases tried. We've gone through all these challenges. And I think it's become almost, from my experience, and the fact that we've convicted so many of them. In fact, I think there's only one acquittal, and that was for a technical reason. And you know, when you deal with this, who we are calling pirates, because these are the foot soldiers basically, you realize that perhaps the prosecution, okay, it's a good thing, but at the end of the day, perhaps it's not, does not address the problem. And I think because the speakers that have gone before me have very eloquently stated what is needed to be done to, you know, to deal with piracy, I will only talk about 2 or 3 areas. And the first one is addressing the root cause. And the root cause, actually, particularly from my perspective and experience, is, you know, really the problem we've been having is we've been dealing with these young people who've been used to go out there as foot soldiers to go and hijack the ships. But these are plenty in Somalia. Somalia having, of course, no government at that time. And I'm glad that Sandra talked about the retired pirate. Actually, the UN has declared him the most dangerous pirate the world has ever seen. And the interesting thing is that he has been given a diplomatic passport by his country. You know, I don't know whether he can dare leave his country with it, but he's actually been given by the former president. And his work is to, you know, reach out to the youth who are in Somalia and discourage them from, you know, getting into piratical ventures. But he said something I think that is very important for us to reflect upon. And he said that there are hundreds of young men wanting a future. And he said that a young, hungry man can do anything. So, of course, they take advantage of these young men. And, you know, it is important, therefore, to appreciate the fact that there's a steady supply of individuals who will undertake pirate operations despite quick trials, harsh penalties, or even loss of life. It doesn't matter to them because it's a business like any other. So, you know, it's important that we deal with that. And of course, Somalia having now been given the support it's being given, I think piracy, I was just talking to Beccari and I was telling her that I think it will be a thing of the past, really, if you think about it. And it's not there have not been any recent attacks that I know of, or if they've been, I think it's not as widespread as it was before. And I think it's easier to deal with it now that Somalia, the government is now getting steady. And so I think but for me, I think what we need to do, and if we were to address this problem, is to go for what I call the land pirates. And I think that is so important because for us, especially in Kenya, it has really, the proceeds of piracy has really affected our economy very adversely. In the short term, it looks like it's helped because there's a lot of investment, especially in real estate. But then the long-term effects, because of course this is money that is not accounted for, and so it has affected us negatively, particularly in the areas of corruption. I was talking to Shefali yesterday and Rachel. We had a very interesting discussion about how this has affected and is going to affect our economy very, very adversely. And yesterday when we had a discussion, when we had the teleconferencing discussion, we were talking about, someone mentioned about how, what is happening in Mexico because of the narcotics trade. And I think Kenya may just find itself in a situation like that because of piracy soon, because there's very heavy investment by this, the proceeds of piracy have been invested heavily in Kenya, and it has affected our economy adversely. And in fact, this has been recognized by the government, and recently, the judiciary, the Chief Justice set up a division known as the International Crimes Division of the High Court that is going to deal with international crimes. And when he was launching that division, he said that the reason why it was imperative that we have that division is because Kenya's economy had been mortally affected by international crime. And particularly, of course, if you think about it right now, we are not certainly talking about what is happening with our president and the vice president going to the ICC. Certainly, when you're talking about international crime, the first thing that comes to your mind is piracy. So Kenya is going to be dealing with it in that respect. And I think, having, one of the things that has, is increasingly coming to our attention is the fact that even if you give them long sentences, it doesn't make that much of a difference. And so, in fact, the sentences, those that had been sentenced to serve more than 5 years, the High Court has reduced the sentence. In fact, last week when I was coming, one of the cases that was determined last year, the sentence was reduced from 20 years, their sentences was reduced from 20 years to 5 years. And it's because I think that there's a recognition that you must deal with these land pirates. And that is the way to address piracy. So I believe that if we pursue these land pirates, there are quite a number, for example, in Kenya, and it's an open secret. Everybody talks about them. We even know their names. Most of them are lawyers, unfortunately. And we know them, and occasionally we throw barbs at them when they try to talk loyally out there. And, and if we went for them, I think that perhaps would address the problem much more effectively. And then also, of course, there's one last thing I'd like to talk about, I think, the issue of funding, support, because Kenya, I think, was the only country at that time. Mauritius is just coming in now, and like I was telling Beckery, I'm not too sure they're going to have too much work to do anymore. But when, it was sort of like the baby was dumped at the doorstep of Kenya, and we took up that responsibility on behalf of the international community. But I think we were left, first of all, we were not prepared. And then, even though we had MOUs with several countries, I think there was a problem with the terms, and so it was eventually, of course, we did not renew them. But there is very serious need to give support to the countries that have, willingly come forward to try piracy cases, especially if they have nothing to do with it. Because, like for example, Kenya, we have none of our ships have ever been affected, none of our, our citizens. But one of the biggest problems we've had is that because of lack of serious support, especially financial support, we've not been able to, to deal effectively and treat these pirates as we should. especially since they've committed international crimes. So it's important that we are given that support, and that if we have those agreements, those MOUs, those memoranda of understanding, that they actually are upheld to the letter. I think those are the three areas that I wanted to highlight. Thank you very much.
Well, I was just handed a note from our conference organizer that one of the panelists on the next panel couldn't make it. I don't know if they've been abducted by pirates. And so 15 minutes has been added back into our panel so we have time for audience questions. So I'd direct you to either microphone, and I'd encourage you to come with your questions. This is an incredible panel with a national court judge, a national prosecutor, a former state attorney, a former Defense Department attorney, and the dean of the International Academy. So please come take advantage of this. Come down to the microphone if you have a question, and we'll proceed to Q&A. Well, for recording purposes, everything's being recorded, and there's another room where people are watching.
Now, this is the proverbial dumb question. What on earth is a SUA treaty?
I think that's directed at you, Ashley.
The SUA Convention is the acronym for Suppression of Unlawful Acts Against the Safety of Maritime Navigation. First negotiated and opened in 1988 in Rome, after, as I said, the Achille Lauro incident, and then revised at the IMO in 2005. Sorry for talking in acronyms.
And the convention initially was, as you know, just against terrorism, because that is the Achille Lauro issue, but then obviously its provisions can be very, very aptly applicable to the piracy issue.
And that's an important point that Ved had made, because all of the treaties that I made reference to, including this one, are not necessarily usefully, but are nevertheless characterized as being sort of the UN terrorism conventions. The interesting thing is that in all of them, there's no terrorist motive required for the crime to be committed. There are some mens rea issues associated with certain acts, but there's no terrorist motive in them. So it tends to make it much more difficult when you're talking. It's sort of like, what are we talking about when we're talking about piracy? I mean, what are you talking about when you're talking about the terrorism conventions? You're not talking about terrorism per se. You're talking about acts which have facilitated the kinds of, or committed the kinds of acts which we now label as terrorism.
Okay, next question. Mark.
I have a question that I'd like to tie the conversation on piracy to some broader developments in international criminal law. I find very interesting this model that all of you have spoken of national courts developing expertise in prosecuting terrorism, and the development of that expertise has been bolstered by international support. Yeah, for piracy, I'm sorry, wrong word. What I'm interested in is your thoughts on whether you could see that model working for other international crimes. That's why I guess I was thinking of terrorism, but also international crimes that are, for example, within the framework of the Rome Statute as a competing model to the ICC.
So I'll go first, but I'm sure everybody wants to jump in. I mean, I would say yes. I mean, it doesn't necessarily need to compete, but the point is there is only limited resources with the Rome Statute, and so anything that's complementary to the international justice regime we should welcome. And frankly, the regional courts have been less politicized in some ways, the way that they have been implemented here. I mean, granted, war crimes may be generally a more political type of crime than piracy, so it's a little apples and oranges, but this model of helping strengthen local capacity has really proven to be much more cost-effective, much quicker. I mean, the amount and the level of justice we were more able to easily facilitate in the Seychelles, and now Mauritius and in Kenya, with support and advisors who can quickly deploy and help, review statutes quickly, do some quick training, is a lot faster than this model of, first standalone ad hoc tribunals, which take a long time, and even some of the hurdles that we've seen with court cases trying to get to the ICC. So I wouldn't say that, you're necessarily competing, but while there's a complementarity principle in the Rome Statute that certainly has always afforded domestic courts the ability to act first, not as a last resort, but as a first resort, this helps complement the ability of domestic states to take on the crimes that occur in their territory. And for the areas, the crimes that occur within their regions, this would only complement that even further. So I've been more of a fan of that concept.
I am a card-carrying supporter of ICC, but its glacial speed does tell me that Sandy has got a wonderful idea. I agree with her.
Let me just add a couple of sort of more detail to answer your question. And that is the support that's being provided to countries is, I think, both widespread and deep across the spectrum. Perhaps the leader, at least in the world that I've been observing, is the UN Office of Drugs and Crime, UNODC. I mean, it is unbelievable how they have moved from a relatively small organization that now has really taken on, I think, the leadership role. And there's a research institute it's separate, but provides data support. They're now running a database of all the piracy trials. So you've got that, and then you have tremendous amounts of either national funds or EU funds that are being applied, perhaps not by as many countries as one would wish, but there's still a lot of money that's been put into it. And I think very, very good results. It's not one of those black holes that money goes in and you don't see anything come out of it.
Follow-up about capacity, as we still on here. All right, so in the first prosecutions in Kenya and the Seychelles, the defense counsel were not very active. The defendants did not take the stand, and there was only one defense counsel for a group of defendants. Now, in Mauritius, I understand things have changed. You have a dozen defense counsel for a dozen defendants, and they're pretty sophisticated members of the bar. Can you tell us a little bit about the challenges that that's presenting you, and whether the model works as well once the defense counsel have become organized as it seemed to work when the defense counsel were pretty dormant?
I mean, I wouldn't go as far as saying they've been dormant, really, but they've been pretty well behaved, from what I understand from the Seychelles prosecutors. And there have been cases where the prosecution side thought, oh, you could take so many points, but they were not taken. So to date, it's all gone pretty well, I think, in the Seychelles at least. But for us, it started everyone seems to be very keen, very excited, and the court found it important to give 12 counsel to 12 suspects, and that is bringing in lots of challenges, because they all have their own way of looking at things, a series of motions, one after the other. That's presenting a challenge, which I think Seychelles hasn't had, luckily, so far. So I'm not sure how it's going to evolve. But the court is very keen on making sure that the case is completed within a reasonable time. And what a reasonable time is going to be with 12 counsel involved, we're going to have to see.
It's interesting. One of the themes that everybody keeps bringing up, both in the audience and on the panel, is the difficulties of modern legal process and the requirements of modern legal process actually getting in the way of prosecuting pirates. Evidence problems, witness problems, defense problems, these kinds of things. And of course, 300 years ago, you would be tried on the ship that seized you, where all of the evidence was and all of the witnesses were present, and then you'd be hung by the yardarms. And there was no incarceration. So there's got to be something in between those two extremes. What it is, I don't know. We do have a student question over here.
This is mostly directed towards Ms. Hodgkinson, but anybody in the panel, about shipboard practice with deterring pirates. You mentioned about the increased use of armed guards and armed personnel on the ships. There was actually a student note that was published in the journal last year which advocated for that, but noted a significant problem that not only does the IMO deter this on the grounds that it's gun running, but also that certain states, it's a capital offense. And she gave an example. It was either Indonesia or Malaysia where there was a ship captain. It was a private yacht, but he was held in detention for 6 weeks on suspicion that it could be gun running, which would have been a capital offense. Do you know if there's been any effort to try to alter this situation given the sort of whether or not it's coincidence leads to causation and correlation that increased armed guards would yield fewer attacks?
There has been a competing debate about this in a number of countries, including our own, about whether or not having armed guards on board escalates the level of violence very quickly. And many will argue that it does. I'm not sure the practice we've seen in the piracy case has demonstrated that it does, in fact. In these cases, none of the ships have been hijacked yet, though. So, we do have a little bit to learn on this. And this has gone back and forth in our Congress. It's gone back and forth in the legislative branches of the countries that are facing this as a problem as one of the competing concerns. And ultimately, the political powers in each area comes up with what they believe is the best case for them as far as domestic legislation, but it has become increasingly a practice by ships. And so I would say the trend is moving away from the old fear of this in favor of now having these armed guards, but with much better practices. And so the rules for the use of force have been clarified through working groups and trying to find ways to minimize an escalation of force and make sure that self-defense is only used any kind of physical force in the case of a real self-defense emergency. And so with better rules and better practices, I think we'll get more and more away from this old concern.
And I mean, frankly, that's one of the issues. What are the rules of engagement? As Sandy said, these are coming into focus, but still, I mean, you could, if your armed guards are paid for and provided by your insurance company, they could be applying the Lloyd's of London rules of engagement. Or if it's from a private security firm that's hired by the captain, it could be the Blackwater rules of engagement. And so these could vary. They could be more aggressive or less aggressive. Ashley, I think you wanted to chime in.
Well, I wanted to put it on sort of a note of caution in the sense that focusing on use of force issues in the context of counter-piracy, it's interesting. It makes lawyers happy because it's a lot of good work. But the most important thing that we all should be aware of is that the industry has created a series of what's called best management practices. BMP is the acronym for it. It's in the 4th edition now. And my understanding of the situation is no ship which has complied with BMP 4 without guards has been pirated. And there are many more ships that are following the BMP rule that are having either government guards on or private security guards. So I think it's important to keep this in perspective, because really the private armed security guards is a potential issue of liability in terms of where they are now, and that's what's being worked out. And it's worth a lot. The attention is being paid. But in my own judgment, and I'm on the outside looking in, I think the focus ought to be making sure that BMP is followed, and to the extent that you can make it even mandatory in one way or another, that's the way to go, because it's the ship owners and the ship masters who are the first lines of defense. And if it's known and you behave in such a way, the pirates can't get near you, so you don't need to worry about them.
We have a question up here in the back.
Yeah, I have a question about what kinds of concerns, trepidation, or objections have been expressed by sovereignties whose coastal waters are being infringed on when jurisdiction is transferred to someplace else, and who's listening to those concerns?
Okay. Sovereignty issues.
Well, hey, having lived through the Straits of Malacca issue, people may recall that there was a period of time in the I guess, middle 1990s, when the then commander of the U.S. 7th Fleet was testifying before the House Armed Services Committee with a suggestion that the U.S. Navy would be in a position to assist the other countries in dealing with what was then a rising piracy problem in the Straits of Malacca and Singapore. And he went so far as to suggest that, you know, the U.S. Navy ships could be there. A firestorm erupted from the countries that were most concerned about sovereignty, and that's Indonesia and Malaysia. There wasn't any intention to do this, it's just what happened. But that then, put, and this is me speaking, but it's what I observed, Indonesia very much in the forefront of the sovereignty protectors. And so in the context of the Somali's Security Council resolutions, it was Indonesia that required the insertion of that text, which has been in all of them now, that what we're doing in Somalia is unique and it cannot be used to create any new forms of customary law. My own sense in reading a little bit in the Gulf of Guinea context, most of those acts, of course, are in national waters. They're not yet, you know, farther at sea. And so the same sovereignty concerns are in play there as still remain in the Straits of Malacca, which leads me to a very short point that there are not all of the lessons learned in the Somali context will transfer to the Gulf of Guinea. I think you need to think more in the context of how did we deal with it in the Straits of Malacca and Singapore.
Just briefly, that regional attempts in order to find a smooth sailing in this area is probably the best solution, and they are doing it.
Yes, that's right.
Okay, we have time for one more question. Yeah.
I think, Mr. Roche, you mentioned that it was important not to go after only the pirates, but also the financial backers and the facilitators. Is it easy to identify who those people are, and do we fully understand their motives behind it?
In the latter part, I don't know the answer, whether we fully understand, other than that of greed. That seems to be a common theme in that regard. I do know that a number of them are well known. Certainly the ones in Kenya are, I mean, they're obvious. I mean, they're the ones driving around Mercedes and living in these, 20-room large new homes. I mean, it's clear that, they've got ill-gotten gains. Our Interpol guy is going to talk some more about that, because it's not just identifying them, but dealing with it. And that's, we're still in the process of sorting that out, I think.
But I think I would caution it that don't go after everyone who has a mansion.
Except in Kenya.
Please join me in thanking our panel. Okay.
Thank you, Michael, and our Blue Ribbon panel. As Mike said, we have Judge Gazwaga, who wasn't able to come here, so we took 15 minutes out of the last panel, added it to this panel. We're going to have a break from now to about 10 after, and then we'll start our next panel. Before we take our break, I have one other announcement. Dean Mitchell mentioned that this conference would not have been possible but for a very generous contribution from one of the foundations in the Cleveland area. And a leader who is the head of that foundation is Jim Wolf, and he's now joined us, and I just want to have some recognition for Jim Wolf. All right, so see you in 15 minutes.
Thank you for making it easy for me to make my presentation.
Just lost Melina.
Oh,
Shelly? She's right behind you at the door. Nancy? There we go. Connecting.
Yes.
Oh, they hadn't. So- You taking off already? Thank you for that. Fantastic, as always. I'll see you soon.
He's going back to the right.
No, he's here. That's my mom.
Are you serious?
Hey, Mom.
Oh my gosh.
Joan Sharp. Oh.
Anyway, that's what he's going to return. It's a series of six.
I don't really know. Okay, so who do we have here?
Shelly,
yeah.
She's here.
So Mark and
Melina are right here.
Okay.
You want to go let them Shelly?
Yeah, probably a good idea. Mark and Melina, if you guys sit up front, that would encourage people to take their places. You could continue to chat. How are you, Melina?
How are you? Good seeing you.
You're there? So is he able to take some time off?
Yes.
Oh gosh, that's perfect. What's his business?
It's basically a remodel.
Oh wow, cool.
There's a lot of, so he's working now, but, he wasn't from
The time is worth the money. I mean, no kidding. You know, we had. I totally agree with that. I know my wife's also a law professor, so yeah, we're both on the same faculty. We're both tenure. She does tax. Same last name, yeah, first name Michelle.
All right, we're going to begin in 1 minute, so if you'll take your seats, please.
So when we did we can sort of coordinate our sabbatical.
Sure.
But we also, with last month we've done, it's been for half a year as well. You know what, I don't know, maybe it's going to be different for the next one that we have because of the kids. And that's the thing, yeah, you know, the last one we did, the kids were still not yet in the formal school system.
We homeschool, just as an FYI, we homeschool our kids here in Boston, and it ended up working out great. Not that I would homeschool like long term, but for,
No, I totally understand.
You know what I mean? So it worked out fine, you know, it wasn't.
I totally
And
understand.
especially now with many schools, they have online curriculums and like online things they can do. So I mean, it really wasn't, you know.
Yeah, I don't know what.
All right, ladies and gentlemen.
You're right.
Let me introduce you to the moderator and chair of this panel. If we can have your attention.
It can be dislocating, not.
Thank you.
Not just to go into the.
All right. Professor Waters from Washington University could not be with us today, and we're very fortunate because one of the people who play a huge role in our international law program, my colleague, Professor Tim Webster, has learned enough about deterring the use of child pirates to be able to really manage these experts well, and we're going to hear a very exciting panel. I now turn it over to Tim Webster.
Thank you, Michael. Thank you. And thank you guys all for coming. I'm sure you are as disappointed as I am that Professor Waters is not able to make it. She's a brilliant and wonderful person. But today, as Michael just mentioned, the panel is going to look at deterring the use of child pirates. We have an eminent and distinguished transnational body of experts here assembled to inform us about these issues. And this issue itself, the issue of child piracy, is, if I can use a bad pun, still in its infancy. Over the past 20 or 50 or 20 years, the prescription of child soldiers has really taken on a life of its own. And so the open question for us is, how are we going to develop a legal framework, or even are we going to develop a legal framework for deterring the use and the prescription of child pirates? We've talked about a number of different models. Our speakers will also highlight some of those models that they have written about in their own writings, both for this conference and outside of it. But a couple of the questions I think they will want to grapple with or will want to grapple with in this session is, to what extent can that international law of child soldiers be applied to the problem of child pirates? Is that a good building block that we need to expand on? Is it something we should toss away and try to recreate anew? Sandy mentioned this morning about tribunal fatigue. Is there an international law child fatigue that may actually slow down the efforts of child piracy? So these are, the efficacy or the commensurability of the child soldier model, I think, is something that we'll want to discuss. We've also talked about the piracy model. To what extent do juveniles or child pirates fit into that? We've talked about, Ash Roach this morning was talking about the various conventions that can also be used to supplement UNCLOS and the piracy model as it's been memorialized in international law. To what extent can the piracy model also be used to talk about the child piracy model? We also talked about the Mauritius model, which is to pass comprehensive legislation on a particular issue. Is any state likely to pursue a similar model to deal with the issue of child pirates? And finally, in Professor Drumble's piece, which I recommend to all of you, he calls for a flexible model, saying, look, we don't need to set all these things down into stone. We need to look at each case contextually and determine what that particular pirate may or may not need. So those are some of the different models, some of the themes we'll be discussing over the next hour and 15 minutes. I'd now like to turn to our distinguished group of panelists. On my left, we have Professor Shelley Whitman, who's joining us here from Dalhousie University in Halifax, where she is the project director of the Romeo Dallaire Child Soldiers Initiative. She's also the deputy director of the Center for Foreign Policy Studies up there in Halifax, Nova Scotia. Like all of our speakers, she has a distinguished and brilliant transnational career. She has taught, she teaches currently at Dalhousie. She's also taught at the University of Botswana in Africa, and has worked for UN bodies as well, spanning all over the world. So we're lucky to have someone of her expertise and someone of her broad background speaking to us this morning. To her right is Professor Mark Drumble, who is the class of 1975 alumni professor at Washington and Lee Law School in Lexington, Virginia. Professor Drumble's most recent book, aptly enough, is called Reimagining Child Soldiers. We've lost the cover art, which is beautiful, but you can at least see this book here has really, I think it's fair to say, revolutionized the discourse and the thinking about child soldiers. Mark has written extensively about this issue and a number of other issues in the field of international criminal law, and I know he has some interesting remarks to make about the issue of child pirates as well. So I personally look forward to his comments forthcoming. Finally, at the right extreme, though not the politically right extreme, of the panel, we have my good friend, Milena Stereo, who, as many of you know, teaches down the street, Cleveland State University. Professor Stereo has her own book, not specifically about children, but about the right to self-determination under international law that just came out earlier this year or last year, or
Late last year.
Late last year, hot off the press. Professor Stereo also has the dubious distinction of teaching me. Before she began her brilliant career at Cleveland State, she was an adjunct professor at Cornell, where I had, she had to deal with the likes of me in her international war crimes seminar. So, without further ado, I will hand it over to Shelley Whitman. You guys all have about 15, 16 minutes to make your presentations.
Yeah,
Okay?
You give me the time.
I think you guys are the timekeepers. Yeah. So look out, and they will tell you where you are. Thank you.
Oh, sorry. I thought it was such a recognizable face that everyone would know. Thank you very much for having us here today, and thank you, Michael. Last year we met, I was part of the Dalhousie Marine Piracy Project and leader of the socioeconomic section of that report. I had that opportunity to meet Michael, and we started to discuss about future plans here at Case Western. So I'm pleased to be here, my first time to Cleveland, and thank you for the warm welcome. Today, what I want to talk about is the use of children in maritime piracy. If you do a Google search and you put in child pirates, you're going to come up with all kinds of Halloween pictures. And so when we started to do this work, it was very important that we said, well, it's not, we need to have some qualifiers here so that we make it very clear for people. I'm hoping that some of the work that we've been creating means the Google searches are changing a bit and actually having some impact as well on this particular issue. As part of the Dalhousie Marine Piracy Project, looking at the socioeconomic factors, this was one of the major pieces that came out from it, was the use of children in marine piracy and how it's really an underlooked issue. I am not a lawyer by training, so I want to let you know that this is not going to be a legal discussion. This is going to be one that's going to be far more about setting the stage of how children are used and recruited, and about the impacts that that has overall in terms of piracy, and what are some of the practical ways we could try to address this problem. I'll leave the legal dimensions to the lawyers who are sitting to the right of me on the panel. So if we look broadly at why this issue needs to be addressed, 6 of the countries most affected by piracy are among the 15 most fragile in the world. And we need to look at root causes that was talked about in the previous panel and the human factors that are related to piracy if we're going to really look at developing a solution. So laws are great, wonderful, but there are root cause elements we have to address. And increasingly, there's been evidence to suggest that children and youth are being recruited by pirate gangs. And most definitely, we need to have a more systematic collection of data on this particular issue. However, collecting data means, first of all, you have to get people to be aware that it is an issue to collect data upon. And that's one of the things that we're going to talk about, is the fact that actually we need greater awareness amongst everybody who is trying to combat this issue, from the lawyers to the navies to the private security companies to the shipping to the child protection workers, to those looking at it from judicial authorities in countries that are addressing it, from Kenya, Seychelles, and now to West Africa and other particular contexts. Who is a child pirate? We have developed a definition based on the Paris Principles definition of a child soldier. The UN Convention of the Rights of the Child declares that a child is anyone under the age of 18 years. I know that Professor Drumble certainly has a viewpoint on this issue and about what problems that creates. However, in light of what exists currently, this is the definition that the UN and the world has seemed to grapple onto. Paris Principles definition really looked at all of the multiple roles that children play when it comes to their use in armed conflict. And I think that's very important in this context of child piracy, that it's not just about the kid with a gun who boards a ship. There are all kinds of support functions and roles that children can undertake that are critical to the success of a piracy operation. So in terms of the definition we have put up there, we talk about it being any person below 18 years of age who is or has been recruited or used by a pirate gang in any capacity, but not limited to children, boys and girls, used in as gunmen in boarding parties, hostage guards, negotiators, ship's captains, messengers, spies, or for sexual purposes. It's not only referring to a child who has taken a direct part in kinetic criminal operations. This is important because stigmas exist about what the imagery is related to child soldiers as well as with piracy. And we've been talking about empathy here. There seems to be a lot more empathy in the world for children who are used in armed conflict, but when we talk about children who are used in marine piracy, the empathy isn't there, and it might go back to the history of the definition of piracy being its, as an enemy, everyone's enemy, right? And so part of that is very important for us to break down if we're going to try to address how this is unique in terms of the use of children. So in terms of the rationale for the use of children in maritime piracy, some people might question, so why are they used or how are they used? Much like the use of children in armed groups, children are vulnerable and easy to manipulate. They're fearless and often unaware of the consequences of their actions. I have 4 boys at home that range from the age of 2 up until 20. I know that they do things all of the time that make me cringe that I would never do, and that I ask questions to them like, why would you do that? And they say, I don't know, I was bored, or whatever it might be, right? And so the characteristics of children are very important for you to consider in terms of what is manipulated and why they're viewed as valuable. If you couple that with drug use or alcohol use, intimidation, other things related to poverty, and in a lot of the places we're talking about, boredom is a huge factor, right? In Afghanistan, in Somalia, why children are used, part of it is because what else do they have to do in a lot of those instances? They are cheap. You may not have to pay them at all, and feeding them is generally less than feeding an adult soldier, for example, or in this case, maybe pirates. Plentiful often in many of the developing countries we're talking about. In Somalia, indicators show that the numbers of children below the age of 15 is 50% in terms of the demographics of that country. So the human resource that exists is often young, and so it's therefore not a crazy thought to think that when you need young people to do this type of work, that they're plentiful. They're small in stature and therefore nimble. So there can be times when the small stature is a negative aspect. There could be times when it's very beneficial. Easily indoctrinated as well. It's not difficult to tell them that this is how the world works and present a worldview to them, and they may believe in that. You tell them that this are the kinds of benefits they will get out of participating in this, right? Money, weapons, access to certain types of activities, drugs, and they will very much believe that that is the case. So the socioeconomic factors that put children at high risk of recruitment and use by armed groups also exist in those countries most affected by piracy. In Sri Lanka, there's a perfect example with the LTTE, where they use child soldiers and also use those child soldiers in piracy operations. So we have other examples around the world where this has existed. I'm putting up this slide about the recruitment of child soldiers in 2012. These are official numbers that have emerged from the UN's SRSG on children in armed conflict. So these are the reported numbers. It could be much different because there could be a lot of unreported cases that we don't have unsubstantiated. But what's significant about this graph is Somalia and the numbers of children that had been recruited in 2012. I'm relaying this point because what I'm going to get across to you is that I think we need to take a look at the fact that when we have times of conflict, children can be used in a particular way, such as in armed conflict, child soldiers on the front line, spies, messengers, all of those types of things that they take on. There's a skill set that they develop. You might think it's a negative skill set, but it's a skill set. And when armed conflict ends, that skill set doesn't go away. And oftentimes there are vacuums and voids that are created in which we need to be really looking at the fact that they can also be manipulated and used if we don't have good rehabilitation, demobilization programs, and that goes across into other types of international or criminal activities that we need to address. When we first started to look at this issue, in terms of getting a handle on the numbers, we looked at the number of pirates on trial up until 2011 at this point. And in terms of the numbers on trial and the numbers of those who were under the age of 18, these were the numbers that we could find. So a significant number that have been put on trial and captured. These are the ones we know of. We don't know how many more may have been just dropped off on the coast or who may have been released after certain procedures took place, and on a national level if there might have been other measures taken. The use of children in terms of marine piracy qualifies under the ILO's term the worst forms of child labor. I'm highlighting this because we talked in the previous panel about the need to look at other mechanisms for how we might deal with piracy. So the ILO and its Convention 182 related to this issue is something that hasn't been explored fully, and we need to look at that as potential as well, so that it's also about the use of children in terms of the worst forms of child labor. I'm putting up this graphic here because what I want to show to you is that we are trying to get across about how children can go across the different dimensions in terms of wartime and peacetime. So much like the idea of factories that in peacetime they may create automobiles and in wartime tanks, we have similar viewpoints here when it comes to the use of child trafficking, child soldiering, and criminality, and how this applies to piracy, is that the same individuals who, or not the same, but similar types of individuals who can be shadow facilitators can create the context in which in a peacetime children can be used as pirates. The same skills as I explained can also be transferred to the use in armed conflict. I'm bringing this up in particular because right now you will hear a lot of people saying, well, why would you be concerned with piracy off the coast of Somalia? It's been reduced so greatly, and look at all of the wonderful efforts in terms of naval patrols and in terms of how to address this from a legal perspective. And I think it is good that we've had all of those potential dynamics come together in this context. However, if we don't address it, and if we simply think that we get to ourselves to a point where it's we've managed it and the problem is over, and then the money that is being poured into that context to address it moves away because now it's bigger on the west coast of Africa, or attention goes elsewhere. If we don't address this from this root cause perspective, all we do is create a situation where currently Al-Shabaab, who is using a lot of children, and the piracy networks are still in place on the west or the east coast of Africa, can merely be taken from one form or use and be re-employed again into the piracy. And we have seen kids who have left and crossed across those borders, who have gone from Al-Shabaab to being used in piracy. And I'm not sure about the backward movement, but it's a possibility that exists as well right now. So we need to look at preventative action, and we need to look at how this is really critical in terms of addressing piracy overall. In terms of the counter-piracy operations, the use of children is important in terms of both the operational and legal responses. So different legal responses are needed, different operational responses are required. There are some moral and ethical dilemmas that appear. And we have to look at how we need to be innovative and create ideas related to strategic complementarity across different sectors. For example, I spoke with Rosamel last night, and she was saying how even child protection actors within the East African region are saying, we don't want anything to do with this issue. So when you're trying to find those who should be advocates of children, even those who are, they're not aware of why they should pay attention to this issue and how we need to address it differently. I said about the operational and legal dynamics, so it's very important that we look in terms of security sector training, naval forces, but also in terms of the private armed guards that we talked about as well. This has an impact on them too, both in terms of the post-traumatic stress disorder that can be created, as well as the fact that we saw how if they are not trained on evidentiary procedures, or if they're not reporting in terms of disaggregating data, that it will have an impact on us being able to address it from this perspective. The last few things I want to just relay is that it's important that we look at community engagement, community level dialogue, media campaigns, looking at prevention. Very interesting that this former pirate head is being used to go into communities or to talk to children about the dangers of it. These are the types of things that we need to start a dialogue on, is about how we raise awareness about the danger of it and engage communities on it. Before I get booted off the stage, I will just tell you that in terms of holistic solutions, we really, as I said, need to look at the legal, the operational, the community level, the child protection agents, and the fact that we have to try to address the demand for piratical activity if we're going to have any impact on the use of children, and how the use of children has a direct impact on the prevalence as well of the use of, prevalence of piracy around the world. My very last point is just that a lot of discussion has been brought up about West Africa. West Africa, what I can tell you in West Africa is the extent and use of children in several armed conflicts in West Africa will have an impact on those who are ready and available to be used in piracy activities in West Africa as well. So if we don't want to pay attention in this instance, I want to say it here and now that it will be an issue that will rear its head on the West Coast as well. Thank you very much.
Thank you, Shelley.
Oh, thanks.
Also hailing from Canada is Professor Mark Drumble, who will be speaking to us about child piracy and specifically legal mechanisms to deal with that. Thank you.
Well, good morning, everyone. It's a real joy to be here. It is probably my, fourth or fifth time to Cleveland. All my trips to Cleveland have only been because of Michael Scharf and because of Case. So I guess it's fairer to say it's my fourth or fifth time to Case rather than Cleveland. But I do have the opportunity to see some of Cleveland along the way. I would like to talk to you today about rehabilitating and reintegrating child pirates and the existing legal framework that exists for that. Shelley made a great point in opening up, which is if you do Google search child pirates, you do see a broad array of costumes, and you all will be comforted to know you will also see increasingly a lot of references to the work that she and the Dalhousie University is doing on this particular issue. So there is some diversification, at least on web searches. Where there's not yet a diversification is in popular culture. So my 4-year-old son, about 2 weeks ago, was invited to a pirate-themed birthday party. And of course, we had to get pirate stuff for him for the pirate-themed birthday party. And it was very odd. He was at the party, I dropped him off, I left, I went to the office, and I started to write on the real child pirates in the world while other people were playing pirate. And at the end of the day, I think a conference such as this that highlights these issues is incredibly valuable. I would like to make 3 major arguments here today and share them with you. First, I think when we think of child pirates, there is a lot to learn from how we think about child soldiers. There's also a lot to learn from the way we fall short in thinking of child soldiers. Second, I would like to emphasize that the emerging paradigm to deal with child pirates is a criminal law paradigm. We can celebrate the criminalization of piracy and the emergence of criminal law frameworks for this. But what I feel has been lost in that shuffle and in that celebration is a good accounting of what the place should be of juveniles within that framework. And I believe there has been a lack of attention focused to international children's rights within this emergent criminal framework. And to me, that is relevant because there have been juveniles, persons under the age of 18, caught up in criminal trials at the national level in the countries indicated on the prior slide, and also, I believe, in more countries than just that, and I can talk about some of those cases a little bit later. The final point that I would like to make is I believe that in looking ahead, the way we ought to approach child piracy and the rehabilitation of child pirates is neither through a criminal law model nor through this capture and release, you're all innocent, you're all used, and you're all abused model. I believe both of those models fall short, and instead I would argue for a model that focused on restorative justice mechanisms in which pirates who are youths implicated in piracy come forward, seek forgiveness, have conversations with victims, contemplate a broader form of reintegration that comes with responsibility, obligation, as well as societal and international obligation to maximize the best interests of former child pirates. Now, let me start off with the child soldier, child piracy analogy. Child pirates are not child soldiers unless they are members of a national armed force or an armed group that is in the process of engaging in armed conflict. And that is simple juxtaposition of the core definition of what is a child soldier. Okay. Another important point to recognize is, however, that there are analogies and similarities within the process by which young people become enmeshed in pirate gangs. My greatest source of frustration with discourse and dialogue on child soldiers is that it basically breaks down into two binaries. There's two images that float out there when we think of the child soldier. The dominant image is the child soldier as a faultless, passive victim, helpless, hapless, used and abused, having no responsibility for what happens in times of armed conflict and no responsibility for how he or she ended up in situations of armed conflict. That image, at least, is motored by a spirit of compassion. The other image that's out there with child soldiers is the image of the child soldier as a demon and a bandit, incorrigible, a Clockwork Orange style imagery. And that image views the child soldier as unsalvageable and irredeemable, something to be very frightened of and something that cannot, in many ways, be rehabilitated. And I use language like something because a lot of the discourse about child soldiers can actually be deeply depersonalized and dehumanized when it comes to seeing former child soldiers in this image. These are the two images. They're both incorrect in terms of not being attuned to the actual realities of child soldiering, and they're both counterproductive in many ways. What I find frustrating is that in the small emerging discourse that's starting, that's picking up speed on child pirates, I see a replication of both of those images and both of those metaphors in the context of child pirates. On the one hand, there are some groups that borrow from the helpless imagery of the faultless passive victim, and there are others that view child pirates as incorrigible criminals to be prosecuted regardless of their age. Shelley is absolutely right. I think there is more of the demon and bandit image attached to child pirates than actually has been attached to child soldiers in the past. And I find that very interesting as to how that framework came to be. I see an analogy between child pirates in this regard and child terrorists, because within the framework of young people that commit acts of violence that could constitute international crimes, child terrorists don't benefit from the same benevolent viewpoint that child soldiers do in terms of being viewed as faultless passive victims. And I think our own national discourse here over individuals such as Omar Khadr, or individuals, young people who engage in suicide attacks or in terroristic violence, we don't view those individuals as helpless kids. We view them in many ways as deluded, menacing adults. And I see to some degree the child pirate being viewed in a similar sense than the way we view the child terrorists, minus some of the histrionics that often accompany conversations about terrorism. So, point one, there is an imagery that is associated with child soldiers. It's being imported into the child piracy context, and I think it's counterproductive. This has led to the whole-scale adoption of criminal models to deal with captured child pirates, or, on the other hand, immediate capture, release, and amnesty. And in many ways, the immediate capture and release of former child pirates, in my opinion, simply risks recidivism. It simply risks that youth returning to criminal activity, whether piracy or whether some other form of criminal activity. On the other hand, penal law, sanction, and punishment, with its goals of retribution and deterrence, I believe are not well suited for young people caught up in acts of piracy. The language of the criminal law, in particular international criminal law, is often ill-suited at dealing with themes such as restoration, rehabilitation, reparation, making amends, and reinsertion into society. Therefore, I would say that in order to move forward in a deeply constructive way, we ought to be considering a third path, a path of restorative justice. You can't have that path, though, if you use as your predicate the notion that all young people in piracy gangs are there because they're forced to be there. I think it is very important to explore the motivations that lead young people to enter piracy gangs. Yeah, this is because of poverty. Yeah, this is because of poor opportunity. Yeah, this is because in some instances family members, neighbors, friends are engaging in this and people just follow this in a path dependency. But young people are not shorn of agency, authorship, input, or all forms of autonomy. And at the end of the day, we have to recognize that these factors may pull young people into acts of piracy, but it's often a logical calculus. It's often making the best of a bad situation. It's often maximizing the handful of opportunities that you may have that actually draws young people into situations of piracy. And I don't think you can remediate that without acknowledging that there is a level of authorship, agency, and activity that motors people to join pirate gangs. I also believe it's very important when we talk about any form of international criminality in which young people are involved to not invest so much in the chronological marker of the age of 18 or 15 or whatever chronological marker you want to use. The fact remains that approximately, and this is very anecdotal, approximately 1/3 of pirates that sometimes are captured in raids tend to be under the age of 18. But an awful lot of them are also in their early 20s. And very, very few are very, very young. And at the end of the day, I think we need to view age as something on a continuum and not a bright line. Because when we take it as a bright line, we have the same problem that we have with the child soldiers. Everybody under the age of that, the benchmark age, 18, is viewed indulgently as having no authorship or responsibility and being able to discharge no obligation. But everyone over the age of 18 is not given the benefit of the doubt, is not given any excuse. Yet we know that when you're 19, 20 years old, you are also in a process of cognitive and neurobiological evolution. And at the end of the day, when the law draws a bright line, it falls down hard on those just over it, while it indulges those right under it. So I think that's another very important point to bear in mind, and an important point for us to recognize when we talk about this. That said, international human rights law, as presently formulated, does fixate on the law on the age of 18. And look, we're lawyers, you have to apply the law as it is. And international humanitarian law and international human rights law in particular stipulates that upon apprehension and detention, if you're under the age of 18, you have to be treated in a certain way. You have to be segregated from an adult population of defendants and detainees, that you have to remain separated from that particular constituency. And the Convention on the Rights of the Child, it doesn't say that minors cannot be prosecuted for criminal offenses. It doesn't say that. It precludes the death penalty, and it precludes life imprisonment without parole. Fine. But it doesn't say that minors cannot be charged criminally or prosecuted. But it does say that some accounting must be made of minority status in that particular process. And when we have a situation where persons under the age of 18 are mixed up willy-nilly and indiscriminately with adult defendants and prosecuted in a group equally without justification for why the minor is included in that group, that begins to flirt with impermissibility under international human rights law. Therefore, I would strongly encourage states that are in the process of enacting national regulation and criminalizing piracy nationally to have account of the age of the person in the kinds of procedures that are set up, and for juveniles to be treated differently within the framework of the criminal law. All states have national ages below which persons are not capable of having penal responsibility. That sort of generally ranges between the ages of 7 and 14 under national law, if you did a survey. But at the end of the day, between the 14 and 18 bracket, account still needs to be had in this regard. I have a minute left, and I'm going to wrap up on the following note. There's a lot to learn from what we did and what we're doing with child soldiers. You can make an analogy with child pirates. My takeaway from the analogy and looking ahead would be to develop a middle ground between the neglect and carelessness of capture and perfunctory release and what I think is the excessive and ill-fitting retributive approach of criminal trials when it comes to youth engaged in piratical activities. The only way we can reach the middle ground, though, is to strip ourselves of the rhetoric that dominates the intersection of children and international law. A rhetoric that either sees young people as troublemakers or young people as innocent souls used always by evil adults. We need a middle ground that recognizes the humanity, dignity, autonomy, agency, and vivacity of youth, the fact that with rights comes responsibilities, and durable reintegration. And to this I would say not only of persons under the age of 18, but also of low-ranking pirates over the age of 18, many of whom may first have entered piratical activity as minors, requires the investment of effort and time in restorative justice mechanisms. And let's talk about one group we haven't yet talked about necessarily all that much in this framework, and that is this. Piracy not only costs money and costs lives, it also creates a broad array of victims. And victims of piratical attacks also ought to have some form of justice. But their demands for justice and the need for stability in international maritime and public orders requires us to think much more creatively and assertively. And to date, our focus on penal law and our congratulations to ourselves for penalization ought to come with a little asterisk. And the little asterisk ought to be that the criminal law can only take us so far. And when it comes to rebuilding societies from where pirates depart as a point of origin, there is also something to learn from broader transitional justice frameworks, and those broader transitional justice frameworks suggest a need for this sort of creativity. Thank you very much for the opportunity to be here and for your time.
Great. Well, thank you, Mark, for those very enlightened comments. I'm sure we'll have a lot of discussion afterwards about some of the comments you made. The last speaker is, I'll grab your name tag. So, our last speaker is Professor Milena Stereo from Cleveland State.
Thanks, Tim. It is also a pleasure to be here for the third or fourth time, and I hope I will not disappoint you by basically mostly agreeing with Shelley and Mark, so there will not be any controversial dispute here going on among the panelists. But let me just take this opportunity to build on some of their remarks. And what I will do here is focus mostly on the specific legal obligations coming from international law that follow the states that apprehend and prosecute pirates. And then more specifically, I will focus on, in a concrete situation when a state apprehends a group of pirates and then either brings them to its own courts or transfers them to a third state for prosecution purposes. What are those states supposed to do? What kinds of concrete measures can they undertake in order to respect their international legal obligations with respect to the treatment of juvenile pirates? And even though I do not disagree with Mark in his point about the fact that having this bright line rule that says that, you know, anybody under 18 is a juvenile, anybody over 18 is not, and the fact that we maybe need to rethink that in my remarks today, I will basically assume that everybody under the age of 18 is a juvenile, anybody over the age of 18 is not. So for the purposes of today, let's just assume that when I speak of the treatment of juvenile suspects of piracy, I mean those who are under the age of 18. So Shelley had already put up some numbers in terms of pirates, suspected pirates, that have been apprehended or prosecuted and who have been juveniles. So let me just follow up on some of those numbers, give you a few additional numbers. So for example, in March of 2011, an Indian vessel, naval vessel, apprehended a group of 61 pirates. In that group of 61 pirates, 25 were under the age of 15 and 4 were under the age of 11. In France, and this was on Shelley's slide, 1 out of 6 prosecuted pirates was a juvenile. In Germany, 3 out of 10. In Malaysia, 5 out of 7. And we even had a case in the Southern District of New York here in the United States where the defendant alleged to be a suspect, and the judge ultimately ended up basically refusing to treat that defendant as a juvenile and determined that the defendant was an adult. So that case, we don't have a clear conclusion as to how old that defendant was. Shelley has already talked about, and Mark as well, they've both talked about the root causes of juvenile piracy. Why do young Somali boys engage in piracy? Probably because of poverty, lack of better things to do, displacement, separation from their families, limited social and educational opportunities, exposure to violence and armed conflict. Now, when a naval fleet or any kind of a law enforcement officer of a country detains a group of suspected pirates, what happens then if one of those pirates or suspected pirates looks to be a juvenile, or what happens if one of those suspected pirates claims that he is a juvenile? And to paraphrase Judge Duncan Gaswaga, who was the piracy judge in the Seychelles, who unfortunately couldn't be here today, what do you do when you have a grown man with a beard who tells you he's 12? Do you take his word for that, or do you have to do something about that? So first, let me briefly speak about the international law on the treatment of juveniles, and then let me briefly tell you about some of the things that states can do in order to respect those obligations. So under international human rights law, the International Covenant on Civil and Political Rights has 2 specific articles that deal with juveniles. So Article 10 of the ICCPR basically says that accused juvenile persons shall be separated from adults and brought as speedily as possible for adjudication. So the obligation to separate juveniles from the adult population to bring them to trial as speedily as possible. And then Article 14 says that procedure shall be such when we deal with juvenile suspects as will take account of their age and the desirability of promoting their rehabilitation. So anytime you're dealing with juveniles, you have to take into account their age and also think about the desirability of promoting their rehabilitation. The second treaty that I will mention here that Mark has already mentioned is the Convention on the Rights of the Child. And Mark is correct when he says that the convention does not prohibit the criminal prosecution of a juvenile suspect, but the convention does say that basically the arrest, detention, or imprisonment of a child shall be in conformity with the law and shall be used only as a measure of last resort and for the shortest appropriate period of time. And then it also says things like juvenile suspects should be separated from the adult population. They should never be sentenced to the death penalty or life imprisonment without the possibility of parole. They should have the right to contact their family members. They should be brought to trial as speedily as possible, and that measures shall be taken to basically take into account their age and also provide for educational rehabilitation type opportunities for the juvenile suspects and possibly those who are then convicted. Now, those are the major international human rights treaties that speak about the treatment of juvenile suspects. Now, what about international criminal law? And so Mark has already spoken about the parallel between child soldiers and child pirates. And here, let me just take a brief moment to look at the practices of the international criminal tribunals. And obviously, we have not had any piracy prosecutions in the international criminal tribunals, but because at least some scholars have talked about the possibility of either bringing the crime of piracy within the statute of the International Criminal Court or of establishing a specialized ad hoc international piracy tribunal, I think the parallel here is very, very important. So the statute of the International Criminal Court says that the court does not have jurisdiction over anybody who is under 18. So in the ICC, the current ICC system, anybody who's under 18 could not be prosecuted. But the ad hoc tribunals for the former Yugoslavia and Rwanda did not have any such specification, and so presumably a juvenile defendant could have been prosecuted in those tribunals. In the Special Court for Sierra Leone, nobody who is under 15 can be prosecuted, leaving the possibility that those who are between 15 and 18 could be prosecuted, although the prosecutor there has said basically that the tribunal would not prosecute anybody who is under the age of 18. The Cambodia Tribunal does not have any mention of a minimum age of international criminal responsibility, but it does incorporate Article 14 of the International Covenant on Civil and Political Rights, which basically states that procedures in case of juvenile defendants should take account of the defendant's age and the desirability of promoting the defendant's rehabilitation. So while there's certainly no consensus in international criminal law about the age of minimum age of international criminal responsibility, I do think that there is some consensus about the fact that any time we're dealing with juvenile defendants, that they ought to be treated differently, distinctly. Somehow that they ought to be treated better than the adult defendants. So taking all of that into consideration, what is the state supposed to do when it apprehends a group of pirates, and again, when there's somebody in that group who either looks to be very young or who claims to be very young? In the first instance, I think it would be relatively easy for the apprehending, capturing nation to separate all those who look to be young or who claim to be young from the rest of the apprehended pirates. For the most part, suspected pirates will spend days or weeks on board the vessel of the capturing nation. They will not spend years or decades in captivity there, and so it seems to be relatively easy to separate those who appear or claim to be juveniles from the rest of the detained pirates. So that part is relatively easy. Now, what happens when that group of pirates is then transferred to the prosecuting nation? And here it can either be the same country, or in many instances the pirates are transferred to a third country for prosecution purposes. What happens then? What should that nation do? So one thing that we all, I think, need to agree on is that that nation does not necessarily have to take the word of the suspected pirate that they are 12 or they're 15. So again, when you have a grown man with a beard claiming to be 12, obviously you do not have to believe that person. The difficulty here is that apprehended pirates do not travel with passports or national identity cards, and so, and many of them, frankly, might not even know exactly when they were born, so they might not even know their age. When interviewed, many of them might claim to be younger than 18, realizing that this will somehow result in a better treatment and result in a lighter sentence. There are medical scientific procedures that the prosecuting nation can use in order to determine the suspect's age. So for example, we do have DNA examinations, x-rays, dental examinations. All those things, if conducted by a specialist, can lead towards not necessarily, determination that the defendant was born on May 1st, 1990, but some kind of a determination of a possible age range. And keeping in mind, by the way, that here we might be talking about slightly skewed results because somebody who grew up in an impoverished country with a lack of proper nutrition might, appear to be much younger than they actually are. So, but nonetheless, the exam, the scientific or medical exam, can lead us to some conclusion about the person's age. And I think conducting a medical scientific exam is a much more appropriate procedure in light of these international human rights standards than simply saying, you know what, we're not going to believe you, right? We're going to treat you as an adult suspect. And here we actually have an example from a U.S. case. So in the Southern District of New York, one of the suspected pirates who was prosecuted back in 2009 claimed to be 15. so basically claimed the right to be treated as a juvenile, and the judge in that instance refused to conduct a medical or scientific examination. Instead, the judge interviewed this pirate suspect, interviewed some other claimed to be friends or family members, and determined that the suspect was an adult, treated the suspect as an adult, and handed out a 34-year sentence. So in light of international human rights standards, probably not the best procedure, to be followed. In some other cases, in some other states, judges have ordered medical scientific exams, or have simply treated suspects as juveniles if they appear to look as juveniles. So let me just mention another Judge Gaswaga case from the Seychelles from the summer of 2012, so slightly a year ago, where a group of pirates was apprehended, prosecuted in the Seychelles. The adult pirates were sentenced to 30 years in prison. A 16 and a 17-year-old pirates were sentenced to 2.5 years in prison. And then a 12-year-old defendant was sent back to Somalia, where Judge Gaswaga simply determined that this suspect could not face any kind of criminal responsibility. And apparently an effort was made to locate that suspect's family members in Somalia, so when he was transferred back to Somalia, he wasn't simply released on the streets of Mogadishu. Instead, family members were contacted and the pirate was handed over to those family members. Now, that catch and release attitude when we're dealing with juvenile suspects, I would agree with Mark Jumble, is not the ideal solution either. And so I have to agree with Mark here that the ideal solution does seem to be some kind of penalty combined with rehabilitation, education, retraining. And of course, the difficult question, the elephant in the room, might be, well, if juvenile pirates are prosecuted in the courts of a country that is a member of major international human rights treaties, basically then it is the obligation of that state to provide for those opportunities, which might be very, very expensive and which might entitle then the juvenile pirate to stay there indefinitely. Because under major human rights treaties, it would be a violation to simply send that kind of a juvenile pirate back to Somalia if we suspect that the person will then be mistreated or would not be provided with these opportunities. So just to conclude, I'm running out of time and I would love to have time for questions and answers. States have the obligation to treat juvenile suspects differently from the adult suspects. They do have the obligation to attempt to determine the person's age, and they do have the obligation to provide some kind of rehabilitation, educational opportunity for the juvenile suspects. But I sincerely hope that because those things might be very, very expensive and time-consuming, I sincerely hope that that will not be something that will turn off states like the United States or Western European states from taking on juvenile piracy cases. I think the best thing that can probably happen to juvenile pirates is to end up in some kind of a juvenile detention facility in France or England or Norway or the United States with educational rehabilitation opportunities. Thank you, and thank you more questions.
Great. Well, thank you, Professor Steria, for those comments. We have 7 minutes by my reckoning to ask questions. We have a question already, so I don't need to exercise my moderator's privilege. Please.
I didn't hear either of you discuss whether or not any investigation is done into the willingness of the juveniles to participate in that activity. They may be the victims of intimidation, kidnapping, or other force to coerce them to participate. What is done there to, one, find out if that is the case, and two, how are they treated differently if that is the case?
If I can say a few remarks about that. I mean, I think that was one of the things I was trying to highlight, is that there are different circumstances to how children are used than to how adults are used. Now, I think what Mark has been talking about is about the need to look at each individual case and understand that you can't just have a blanket prescription for everyone. I agree that that is important for us to have an approach to this that we have to refine as opposed to what we've dealt with previously. However, that's one of the key problems is determining. How would you determine whether or not they have been coerced, or how would you determine whether or not they have been forcibly recruited into it? Because that's why there's been an approach previously to simply say that if you are used in that particular manner, no matter how you were brought into the context, you are a child, and therefore the ability for you to make clear decisions about joining or participating in that type of activity is difficult for you to have full knowledge to be able to determine that. So that is why a lot of child protection and human rights activists have taken that type of approach, because determining that is often very difficult to determine. And lastly, a lot of these children who are indoctrinated, they may tell you after 8 years with an armed group that they are willing participants, but at the age of whatever it might have been, 7, 8, or older ages, as they become more ingrained within that context, it gets blurred. The vision gets blurred about whether or not this is something that they had wanted to do. And so there's a lot of nuances related to this issue in the discussion, which are cloudy, they're not clear. The difficulty comes with the legal prescriptions and how you apply it. The rehabilitation model has been one where it doesn't matter whether you voluntarily joined or whether you were forcibly recruited, that it is adults who have used you and done it illegally, and therefore you are all deserving of treatment and rehabilitation.
Can I jump in on that? Look, with child soldiers, worldwide, only a minority of child soldiers are forcibly recruited, abducted, kidnapped, compelled, all right? That image has become generalized, but it actually only affects and only reflects the lives of a minority of child soldiers. I would argue when it comes to child piracy that the level of volunteerism is probably higher than it is in the case of child soldiers. There are lots and lots of children that live destitute in poverty-stricken regions. Only very few become child pirates. Some are duped, some are press-ganged. Of course, we need to have individual assessments. But I think it's very important not to overestimate the amplitude of compulsion and not to underestimate the level of a youth's ability to make affirmative choices that may not seem all that illogical in the context in which that particular person is making them. And I believe that that is the first step in terms of honestly and candidly looking at the involvement of young people in violence and in crime, and is a prerequisite to moving beyond that in terms of adequate reparation and, more importantly, adequate rehabilitation and reintegration.
Let me just very, very, very briefly. If one possibility, if, for example, a group of pirates is apprehended, detained, in many instances, then those pirates are prosecuted together. One possibility is if in that group there is a juvenile pirate, that a judge, when sentencing, might basically give a harsher sentence to all the adult pirates because there was a juvenile present on board. And that doesn't necessarily mean that those were the individuals that now forced that juvenile pirate, but it is a way of saying, look, you were with the juvenile, you ought to know better, right?
Sure.
So.
Great. I think we have time for one more question, so if you could make it brief, thank you.
Sure. Would it be useful to use the model of statutory rape where a child is incapable of giving legal consent, for instance, to have sexual relations with an older person, just as a child might be legally incapable of agreeing, even if in the child's mind he is more than willing to do so, he cannot, in legal terms, agree to take part in a criminal enterprise like that?
Yeah, I mean, I think that sounds great, but when we're dealing with societies where 50% of the population is under a certain age bracket, then I think that just becomes unrealistic and ill-fitting to some degree, even though I think it's a good idea. Also, the fact remains, whatever you have for law, whatever may be illegal in terms of recruitment, you're still going to have young people that come forward and end up in this stuff. It's been the case with child soldiers. So I think we can't just rely on the prohibitions and the law to make the problem go away, right? We're still going to have to deal with the realities that young people end up in these situations and they follow a diversity of paths. Certainly we can criminalize the adult for recruitment. Yeah, sure. We do that in the case of child soldiers. There the cutoff is 15 under customary international law. But the fact remains that I think in order to move forward, we have to not generalize and not essentialize. And I think we have to become comfortable with the reality that young people that do bad things or are caught up in tough situations are not all there only because of adult manipulation and malevolence.
On that happy note, Melina or Shelley, would you like to conclude? No.
I
please.
just quickly, I don't want to get into, I think you make a good argument about how we have addressed an issue like that and how there could be some look into that applicability in the same instance. And but I just want to make the point that what I've always been worried about is if we start to make distinctions about whether you've chosen or whether or not you've been forced into the situation, it's two things. One, that children who may have chosen may not tell you that if they know that it makes a difference in terms of how they get off on the law. Secondly, that there's a lot of stigma that is created around the use of child soldiers, and after war, I've dealt with a lot of former child soldiers, not yet with the pirates, but something that we're looking into. And one of the key problems is moving forward because of the history of the past that they've, the things that they have done. So when Mark talks about the need for restorative justice processes, I agree. But one of my problems is that, you know, if we start making those distinctions, I'm worried that it won't be helpful. It might actually hinder the process of them moving forward.
Melina? You're good. Okay. Well, thank you, Shelley, Mark, and Melina for terrific presentations and a wonderful discussion. Please join me in thanking them. That was great. You guys are doing amazing.
And I talked to Dave. I talked to Dave yesterday. He's definitely coming too. So he said, well, I don't have anything on my calendar, so I guess I'll come over. It's gonna be fun. I have it here. Sure. It didn't go away. There's my radio guy. Just about ready? I'll call you down. First I'll warm them up for you, and then you didn't eat? So is he gonna faint? That would be bad. You know what? Wow, it looks like we have a critical mass. Everybody's early. You're getting the spirit of the case way. So, all right, we'll go ahead and get started then, since everybody's in here. This is, for me, a very exciting time because I get to introduce to you the recipient of this year's Cox Center Humanitarian Award. Now, this award was established 10 years ago. And since it was established, it has been given to the foremost people that have contributed to advancing global justice. So last year, we had Fatou Bensouda, the chief prosecutor of the International Criminal Court. I have the list in front of me. I just need to name these other people. A lot of you have been here to watch them during their speeches. But we started out with Hans Corell, who was the UN legal advisor. Then we had Philippe Kirsch, who was the first president and also the chairman of the drafting committee of the International Criminal Court. We had Luis Moreno Ocampo, who was the first prosecutor of the International Criminal Court. Robert Petit, who was the international prosecutor of the Cambodia Khmer Rouge Genocide Tribunal. We had Navi Pillay, the UN High Commissioner for Human Rights. We had Brenda Hollis, the prosecutor of the Special Court for Sierra Leone, and Stephen Rapp, the US Ambassador at Large for War Crimes Issues. Now, this is a first because all of these folks are lawyers, and this is a law school. The general has done many things in his life, but he didn't go to law school. Yet, I was on a panel with him at Dalhousie last summer, which you've heard about, and I found him to be legally very sharp, very creative, and best of all, extremely down to earth. And I felt like I really bonded with him, and I said, that's the guy I want to nominate for this award. He has done so much to deserve the award, and so our faculty, which votes every year, and picks this award, which has now been called the Cleveland version of the Nobel Peace Prize. Unanimously selected General Dallaire. Now, yeah. Now, General Dallaire, as seen in some portrait that I stole from the internet, is there probably in his glory when he was force commander in Rwanda. And anybody, well, let me ask, who here saw the movie Hotel Rwanda? A lot, like everybody almost. If you haven't seen it, just go on YouTube, you can watch it. Nick Nolte, who is not as good looking as General Dallaire, played the general, and he did amazing in the part. And you got a sense, I think, of what the general was facing during the genocide in Rwanda, when the international community would not answer his call to give him the authority to stop the bloodshed. Now, since then, he has left the military, and he is now a senator from Canada, so I should be calling Senator Dallaire. And he's also a best-selling author. His 2 books, one is Shake Hands with the Devil, and that is sort of an international indictment of the international community's failure to stop the bloodshed in Rwanda and other places around the world. We say never again, but it's really ever and ever again, and that's why people like General Dallaire are so important to keep reminding us of that. And then his most recent book is They Fight Like Soldiers, They Die Like Children, and this is his contribution to the dialogue on child soldiers. And you've heard that he's created the Child Soldiers Initiative, and Shelley works with him on that, and it's literally changing the perception of this issue of child soldiers, so much so that you don't only see costumes on the internet, I understand, but you see serious discussion about this issue. Well, last year, that discussion morphed into also a discussion of child pirates. And you had a warm-up act by this panel, but I think General Dallaire will be returning to that theme as well. Can you come on up and so we can present you with the 2013 Cox Center Humanitarian Award for Advancing Global Justice. And I'm told I have to face the camera when I present this to you. And now we're going to have a speech by General Dallaire. I don't know, are you going to also have some question and answer at the end? Or?
Absolutely.
Fantastic. Do you want to speak from up here?
Yes.
Then it's time for you to do so. There's a bottle of water and the audience is yours.
Good. Well, thank you very much. Imagine telling a politician to face the camera. I'm always a bit tongue-in-cheek. I laugh when people ask me if they can take a picture with me, and I said, what politician do you know that doesn't want his picture taken? And so I'm flattered for that opportunity, and also for those who are watching us streaming on the web. First, thank you very much for, one, the invitation to be able to address you as a layperson and not from the legal background, although I have chaired a number of court-martials and thrown a bunch of people in jail in my time, but as a commander and not necessarily from the pure JAG side of the House or Judge Advocate General or legal side. And secondly, thank you very much for the Frederick K. Cox International Center Award and also the funds that are so attached that are going directly into our research work at Dalhousie. And so thank you very much for permitting us to continue to do our work. I think that if I may, I'll try to watch the clock so that we do have time for question and answers. And I probably would like to stay longer, but our leader here has got us lined up with NPR, so I don't think we'll be able to play with those timings. So I think that, first of all, I'd like to say that I consider it quite risky for an American institution to invite so many Canucks or Canadians down here, particularly in this time frame when we are in Canada celebrating the War of 1812, and you are commemorating it. We know we won it, so we don't have much problems with that, but we don't really like rubbing the noses of our friendly colleagues on that. It adds an interesting link, though, to the discussions or today, because there was quite a naval component to that war, if you remember, mostly on the Great Lakes. And there was some piracy done, of course, by your side, not ours. And so I tend to like some of the anecdotal history of the War of 1812, because, as an example, the farthest north you actually made it was to attack and burn a fort called York, which ultimately is Toronto. I'm from Montreal, that doesn't bother me much. But we thought we'd do you a favor and come down south, and we found this town built on a swamp, and it was hot and it was humid and there was lots of mosquitoes, and so we thought we'd burn it down and do you a favor, and what you do, you rebuild it. It's Washington. So we're not too sure who really understood how to win a complex war even in that era. I'm here also in a scenario that is not totally foreign to me in regards to trying to establish some naval credentials. I am an artillery officer by my profession of arms, but I am a graduate of your U.S. Marine Corps Staff College, and so I spent a year with Marines and afloat, and have served with a number of them over the years. It was interesting that during my year there in my syndicate, there was a naval P-3 pilot, you know, the anti-submarine aircraft that you have, and we have the same one, who wrote a paper on how to bring naval gunfire back into the diplomatic arena by creating lightweight 8-inch guns on destroyers. And so it was interesting to see a pilot pull that out, and that made me quite warm to him, because as an artillery officer, I was also trained on naval gunfire. However, since we've gotten rid of the big guns, I think that's been quite a downer for us who love the Navy and respect that tradition and that service significantly. Back home, we call it the senior service, and it rightly deserves that title. Because we're talking child pirates and child soldiers, I decided to wear my a bit gaudy tie, which is my UNICEF tie today, as UNICEF is one of those frontline NGOs very much involved in this arena, as they are included also in Somalia, where we're doing some work with them, and have been heavily involved on the child soldier, but on the demobilization, rehabilitation, reintegration side of the house, which I will argue is a way of handling the problem, but it is not necessarily reducing its impact. Picking up the pieces afterwards is not necessarily stopping its use. And so I will get into where I think we can be far more effective in the preventive side of the house, which ultimately, I hope, takes away a weapons platform from the inventory of conflict, or use in other realms, including, as an example, piracy, banditry, and similar activities. I nearly forgot that two of my children are in the Naval Reserve, but I'm saved by the fact that my eldest son is in the infantry. But so we'll continue. In regards to today, I'm going to be a bit constrained by two factors. The first one is I'm not using PowerPoint, or for those who are more modern, with Apple Keynote. And the second one is I was asked to be relatively brief, and brevity is not the strength of retired generals nor politicians, particularly if you want time for questions, which I hope we will have a dynamic exercise in so doing. I also want to tell you that I come from a country that is at times talking from both sides of its mouth, which makes it rather difficult to be credible here at this podium and many others in the international sphere in these days, because on the one hand, Canada was leading, as with the United States, in moving the optional protocol on child rights, as an example, in regards to child soldiers and the recognition thereof. But on the other hand, refused to repatriate a child soldier from Guantanamo Bay who was Canadian and in fact was ultimately dumped in Canada after he was tried in Guantanamo and is now in a Canadian jail. And it was interesting, we just fleetingly touched upon one of our speakers on child terrorism, and there was a heated debate back home on whether or not this 15-year-old who had been taken to Afghanistan by his dad, who was very close to the Al-Qaeda hierarchy, 4 years indoctrinated over there, and at the age of 15 ended up in a firefight, and in so doing was accused of killing an American soldier. He was shot twice in the back, 2 years held in prison, where some of the people who imprisoned him were ultimately court-martialed for having killed other prisoners, and then held in 7 years without trial, and then did a plea bargaining to 8 more years of jail in maximum jail back home in Canada, finally. And so there was significant debate whether or not Omar Khadr was a child soldier or was he a child terrorist, and does that change all the rules of the exercise? And I have been quite adamant in that throwing the catalyst of terrorism to a 15-year-old engaged in a conflict does not override the optional protocol on child rights. And I still consider that individual a child soldier, and I'd be happy to see if the debate is as interesting down here as it has been up north. Now, there has been, as establishing some of the parameters that we've discussed this morning, and particularly with the last panel, a significant debate on age, a significant debate on voluntarism and so on, and we've shared panels, Mark, before on this fund, and I want to bring an angle to this discussion. And I want to bring the angle to the question of not the age, because it's a reference point, and it's interesting that we in our military do not permit people to be recruited, trained, and particularly used in operations under the age of 18, although our military academies do recruit under 18, but they don't deploy under 18, and yet we have problems accepting that that is a criteria that can be used in other countries for youths who are engaged in conflicts. But it's the voluntarism side. And the link I make comes from my Rwandan experience as the force commander. At one point, there were elements of my force that were very much engaged, if I can use that term, in fraternization with the locals. And Rwanda was a country that was imploding. Rwanda was a country that was in conflict and ultimately went into a civil war and genocide. And so this country in conflict, you had these foreign troops coming in and fraternizing with the locals. And the question was, does that actually stand a test of ethical responsiveness by military or forces coming into a conflict zone? Should fraternization be accepted? And so a debate, a very short one, I must say, because within the military we don't have to debate too long. So the debate was, well, they're sort of voluntarily, these women are presenting themselves to these soldiers. And so, yes, the fraternization can be recognized as possible and acceptable. I, however, came down and said, there is no such thing as fraternization in a conflict zone. Women do not voluntarily give themselves to men of foreign forces or coming in because they're fallen in love. They're doing it because they need security, they're doing it because they need money, they need food, they need protection, and so there are a whole series of parameters that surround, that create the atmosphere that have permitted this action to happen. And so I put a whole bunch of places out of bounds, and I prevented and took action against those who did fraternize in Rwanda with either side. I look at child soldiers and I say, is it possible that you can actually argue volunteerism in a country in conflict, in an imploding nation, with youths? Is there really that free atmosphere permitting them to actually define volunteerism the same way we do under the context of where we are here, where we volunteer to join the forces, we volunteer to join an organization? Is it the same? And I would argue that it's not. And I would go as far as to argue that no matter how they get into the recruitment of whatever the force, be it a national body, be it a non-state actor, or be it a belligerent of whatever type, including piracy gangs and so on, that youth do not volunteer in those nations where we know the whole atmosphere is one of a failing state where rule of law probably doesn't even, is not even applied, let alone the sense of security that the families or the individuals find themselves in. And I will argue that also that it is still a vulnerable body that's there within the youth, even at 16 and 17, that can be induced into the extremes. And the example I would like to use is the example not of Sierra Leone, and of course knowing that that war was fought by, on all sides, youths and the exactations that they conducted and so on. And I applaud the International Tribunal of Sierra Leone that did not prosecute child soldiers. But I will bring you back again, if I may, to Rwanda. I mean, we're in the 20th anniversary year of that genocide. And how a political party used the radio, and a great radio station, great music, great attachment was created by this radio station that was funded by this political party, how it brought in a youth movement within its party. It gave them uniforms, it organized soccer games, it organized Sunday activities for them. It gave them a sense of a certain empowerment and joining a club and so on. And how they, in less than a year, were able to change that group from being a youth movement of fraternity and collegiality and learning and esprit de corps and so on, into the primary weapon system used in the genocide, into a militia that with machetes slaughtered the bulk of the Rwandans in that genocide. And they were under 18, a lot of them, not even counting those who were part of the two fighting forces that had under 18 child soldiers on both sides fighting in the conflict. But then you had the Interamwe, as they were called, behind the lines, conducting all the slaughtering under orders, under influence by that same extremist political party, the CDR, that ultimately was held accountable in the International Tribunal. So we're talking very much of still an entity that can be maneuvered, and can be maneuvered to incredible extremes, and be used very effectively. And so that is why I, apart from the fact that I had a child soldier AK-47 stuffed up one of my nostrils with his finger on the trigger, and the only reason to this day I believe he didn't pull the trigger is he saw the chocolate bar in my hand. Apart from that, I feel that this child soldier dimension, this introduction of youths into piracy, as we're doing, and other endeavors as we're seeing youth being engaged in, is, in my opinion, a dimension of conflict that is of our era, particularly as it came extensively with the Mozambique conflict in the late 80s, came available because of massive availability or proliferation of small arms that also helped at the end of the Cold War. We didn't destroy all those weapons. We sold them off, and they're readily available. But it came, in my opinion, as an introduction of not a social economic problem in conflicts, but in fact as a new weapon system. And so I argue that in fact we've seen the introduction of a new weapon system that is the primary weapon system in many conflicts around the world. So it's not just your drummer boy of the 19th century or your press gang youth on naval ships, in also the 19th century. It's not a sort of an extreme scenario as the Hitler Youth were used at the end of the World War II campaign, and we've seen them used at different scenarios, and we saw Cambodia and so on. But we are talking about children, youth being used as the primary weapon system that adults are using to conduct their conflict and their campaigns. And as such, I have looked at child soldiers and the work we're doing as, in fact, how do you not pick up the pieces afterwards? That is to say, how do you demobilize them? And how do you rehabilitate them? And how do you reintegrate them as such? Well, I'll come back to that. But look at how do you stop them being used? How do you neutralize this weapon system in the conflict? How do you make child soldiers, now child pirates, a liability to the adults so that they won't recruit them and they won't use them? And how, as you are facing them in these conflicts, that you look at them as a security problem, and as such your security forces, working with NGOs and development people, are able to bring together solutions in trying to neutralize them without slaughtering them. For the doctrines of all forces out there, and when I started my work when I was at the Kennedy School in 2004, we did an extensive survey of all military forces, developed countries and non-developed countries, in their doctrine in regards to child soldiers. And nobody had anything except my good friends, the U.S. Marine Corps. And what they had was one slide on one course in regards to if they are deployed as a force, and should they by chance meet up with child soldiers or youths armed as part of the belligerent forces, that they should do everything to avoid confrontation. That was the doctrine. Well, how do you do that when the primary enemy force is child soldiers? And how do you end up doing anything else than ultimately trying to prevent their effectiveness, trying also to protect yourself and your mission, and ultimately using the fundamental law of self-defense in blowing them away? And so that's what's out there. That's what was out there. And in so doing, has not, in my opinion, attenuated the use of children. It has simply tried to attenuate the impact of the use of children subsequently. Meaning that the emphasis up until we started to treat this as a weapon system, and ultimately how do we prevent them from being recruited in the first place, that the emphasis being on demobilizing them, rehabilitating, reintegrating them, simply did nothing to reduce the scale or the numbers. It simply found ways of hopefully picking up the pieces and attempting to bring them back to a certain normalcy. But even there, we saw that that did not necessarily achieve the aim, because what is more precious than a child soldier in many of these conflicts? It is a child soldier veteran. The re-recruitment of child soldiers. In the piracy scenario, we're trying to pick up the metrics of how many times these kids are going back into the process. An experienced child soldier is worth a fortune. And so we're into the children who are being moved between countries. As we saw, a number of Sierra Leone ex-child soldiers find themselves all of a sudden in Côte d'Ivoire fighting. A number from Liberia also ended up in Côte d'Ivoire. We've seen some who have even been moved into the Mali operations not that long ago. And so re-recruitment is a concern because they are very effective. They've experienced and they are worth their weight in gold to those who use them. But then as you bring your attention to preventing re-recruitment, of course, there is one angle that has not been touched on. And this is the child soldier leader. So far, we've spent a lot of time discussing that adults are actually giving the orders and running these youths in whatever operations they're doing. But there are a significant number of child soldier leaders. This is the 14, 15-year-old going on 25, who's already been in operations for 3 years, who's commanded up to 50 kids, who youths older than him show deference to him or her, and in so doing has gained this incredible experience and also this strength of prestance or presence in the individual's own ability to lead, the empowerment it has, that they cannot simply be demobilized and thrown in with the rest of the kids to go back to grade 1 with the rest of them as he's 14 or 15 and learn Dick and Jane when this kid has been running operations for the last couple of years. And so what happens to them? They become very rapidly disenchanted with the opportunities and what they are getting, the treatment they're getting. They don't have any of the advantages that they did have even as leaders. And so they go and influence those same other kids and haul them right back into the field. And you have the source of a continuum of the conflict by continuing to keep this system going. And ultimately, if the conflict is over, there's nothing that prevents them from going to banditry and God knows what other means. And so why have we not looked at this child soldier leader and built a program, as we do in our schools, in our high schools? We have high schools, a number of them, who have in their motto leadership, right? Leaders of tomorrow, and so on. Right outside this building, it's influencing the leaders, right? So why not create these types of schools in a conflict zone? Take Sierra Leone with the thousands that were used. There may have been maybe 300-400 at most of child soldier leaders differently. Why not create a school? Give them a 4-year program. Re-indoctrinate them to become leaders for the nation, to maximize that extraordinary potential that they've already been exercising and shift it to moving the country forward instead of leaving it fester there and ultimately haul the whole system back down, and all those investments in rehabilitation, reintegration are for naught. So with that being said, the question is how do we handle this scenario of the child soldier, the piracy situation? And I'm very much looking at not just the child pirate who's being blown away on the water, but I'm very much looking at the child pirate on land, where they're being recruited, where they're being trained, where they're being influenced, where the families are engaged or not, and where they are being influenced. I'm looking at that side as I'm looking at other conflict zones, as we've recently come back from the eastern Congo, the Kivu, the Ituri, northern Congo, the South Sudan, and the Central African Republic, where with the U.S. forces out of AFRICOM, we're in there looking at how they're handling CONI and how they're handling that whole concept of use of children. And one of the angles that caught us quite by surprise as we were doing our assessment on the ground and meeting with commanders and browbeating some of these rebel commanders into near insulting scenarios, where I remember taking on one very pretentious commander, a Mau Mau, who to the question I asked, Well, do you have child soldiers? No, no, we don't recruit child soldiers. Do you have girls amongst your organization? Young girls who are used as porters or whatever? Oh, no, no, we don't use girls. Knowing full well that about 40% of all child soldiers are girls. And when I was in Sierra Leone in 2001, I was demobilizing 10 boys for every girl, because girls are far more useful than boys. They're not only up front doing exactly what the boys are doing, and very capably doing that, but in those male-dominated societies, they're also running all the bivouacs and all the logistics, and they're the sex slaves and bushwives of the commanders. So they're far more precious to these guys than the boys are. But in going into the field and meeting this commander, and so at the end of the discussion with this commander who said he didn't have him, and then we showed him that we saw some of his forces that were used, that he was using in the Kivu area against the ex-Rwandan extremists. And we said, you're using him, there, look at this. And then he would sort of acknowledge it. But then, as an ex-commander, I turned to him and I said, how is it that you need kids to fight your fight? How is it that you can't recruit adults to fight your fight? How is it that you can actually consider yourself a commander by having children, youth, do your fighting for you? And by browbeating and insulting, you have two options that end up at the end of that. One, you get your head blown off, or the other one, that you might have influenced him enough to bring him down from his pretentious position, insulted enough to maybe undermine his command, and if you're lucky, then again, you might be able to sneak out, and hopefully he's not being replaced by somebody who will continue to recruit him. So in the realm of this world of use of children, the essence, in my belief, in regards to, so what do? We keep it going? It is not necessarily, and I would argue, and this is very risky for me, being the first recipient of the Cleveland Nobel Peace Prize, and not being a lawyer, to tell a whole room of legal people that maybe your answer ain't enough. And I think that was raised also earlier on, that it's just not enough. Because what have we seen so extensively? If we don't account for all the NGO work done on demobilization, rehabilitation, and so on, what else have we seen? We have seen a lot of work done at the UN with special representatives on war-affected children. We've seen the naming and shaming of countries. We've seen going into countries and holding some of the national bodies accountable for the use of. We've seen a lot of that. But we haven't really seen the forces that are deployable and being deployed actually influencing the battle, actually influencing the scenario. Meaning, there are over 100,000 peacekeepers now deployed around the world in conflict zones where extensive use of child soldiers does exist. And so, what are they getting as training? How are they being prepared to face child soldiers? How are they looking at that problematic? What are the mandates that these missions are getting regarding child soldiers? What are, in fact, the concepts of operations that the military are to use, that the police are to use? How much are they working with the NGOs that are locally there who have enormous amount of information in regards to solving not this social economic problem, although it is a component of it, but this security problem? And that's where we are still horrifically deficient, in the training of those forces to be more proactive, to be able to anticipate facing it, to discern where the recruitment is going on, and how do you actually assist in preventing that recruitment, and how do you attenuate the impact of these child soldiers in the conflict zone by bringing together these multidisciplinary structures, or multidisciplinary structures of military, of police, the security side, the NGO side, the diplomats, the politicians, both the national ones and the foreign ones that are deployed, like the UN ones, in making the eradication of the use of children in the conflict of this weapon system as a primary focus of the mandate. We've gone through mandates way back. And only recently are we starting to see words that speak of child soldiers, even though the child soldiers are the dominant forces being deployed by often the non-state actors. And so I would argue that as we're working down trying to attrit the recruitment, the use of child soldiers, that on the one hand, more and more research information, more and more metrics, not all the anecdotal stuff that we're getting, which is so dominated, and the NGO world is so powerful in its anecdotal information. But you don't get policy changes from anecdotal information. You might get some advocacy and you might get a friendly political gesture, but you don't get fundamental policy from anecdotal. You need solid metrics. And that's why we brought this whole program into a university context where we'll get that intellectual rigor. We'll get that peer review of the data. So one of the things is go and find out exactly what they're doing, how they're doing it, and how we can actually curtail it. So how do we counteract this weapon system? How do we neutralize it? I spent 4 years as the head of the Army Capital Acquisition Program. Bought billions of dollars worth of equipment. It was nearly simple compared to this because it was easy to identify what the countermeasure would have to be to face another weapon system. It was a tank, it's an anti-tank system, which might be another tank, it might be, God knows, a missile, but at least you could do that. What is the countermeasure to a child soldier? That is other than simply killing him, destroying him. Not to say, as I'm ebbing with the time available, not to say that in extremis, even though I am a firm belief in the rights-based concepts of solutioning and evolving in the international sphere, I do accept the fact that in extremis we may find ourselves having to kill, destroy some children to achieve the mission. When you go around some of these extreme non-state actors and look at the ones that they've got around them and how their brains have been literally fried, how they are non-existent as human, they're humanoids, and the fanatism around them, you will never get at that adult leadership without having to get through those kids. So in extremists, yeah, maybe we will have to. However, there are many other means of countermeasures. So one is getting hard data in countermeasures and then getting that data into policy and into mandates and then ultimately into operational concepts that can be used. Multidisciplinary by missions, by countries, alliances, be it the African Union or any of the sub-regions of the Africa or others, into the field. The second part of it is training. And I add education, particularly for the officer corps. Training and education of the security forces, particularly. Both the national ones, the ones coming in order to know what this threat is and discern and build the doctrinal basis needed to counteract it without having to use extreme force. And that training is extraordinarily rewarding because there's none going on. And when we go, as we are now been mandated for a 5-year program by the President of Sierra Leone to retrain his whole army, retrain all his police force, retrain his prison guards who have children in their prisons. They don't know how to handle them. We even are mandated to go into the education system and to educate the youth on how to prevent being recruited, that you don't want to be a child soldier, that it's not a big ego trip and it's not empowerment, but it is in fact a probable sign of being destroyed. Well, that's to us the way to go about it, is moving that education and training into those nations where we've seen and seem to see that there is a cultural or facility maybe to use children and to make that abhorrent. And so I end by saying that my ultimate aim is to eradicate the use of youths as weapons of conflict, of war, piracy, drug wars in the favelas. When I was in Rio, I was in the favelas in Rio, and I saw as much fighting and as much conflict with those kids in those favelas, in those slums in Rio, that I saw in Africa. And so what we're doing there, we know we're going to be able to transfer into some of those drug war scenarios, be it Colombia, be it in Brazil and other places. And I'll indicate that I believe that we can even push it to another level in our own gang wars. We have been working with police and how they're handling the gang wars in North America and in Europe, and whether there's stuff that we can extract from that. But there is a fear, as an example, closer to home. The Aboriginal community. The Aboriginal community, as an example in our country, is the fastest growing community in the country. They are massively disenfranchised. What they have now that they didn't have before is the social communications media to be able to coalesce. Why they've never been effective is because they've never been able to get together. They now have that tool. And there's enough of them educated, and there are enough weapons around this continent, and I say continent because we're just as bad, or nearly, in enough of these weapons available for them to become a force that could become a security problem. We've already had an insurrection in Canada in 1990. There's nothing that would prevent it as we see their demands not being met. And so, ladies and gentlemen, we have an ability to ultimately stop the use of a weapon system and neutralize it and make it a liability. The question is, do we want to look at it that way, or do we want to continue to find ways of simply picking up those pieces afterwards and hope that maybe the social economic side of the house will ultimately pick up, and that there will not be a scenario in which insecurity and the implosion of the nation and the vulnerability of the nation would make the requirement for recruiting children necessary in either state or non-state actors. And I believe we can achieve it. Might take 30 years. So what? What's 30 years if we can eliminate that from the world of conflict? Thank you very much.
Take 3 quick questions.
Yes, well, now that they've had their 2-minute break, we can do that. Certainly. I must forewarn you that brevity is not my strength either in responses, so we'll see how far we get. Anyone on any subject? I was on national news this morning on Syria, but that's another exercise. Sir.
Is the problem that you're talking about with children in Africa and so forth any different than the problem that we have in this country with bringing kids up from starting with preschool and education, and so that they don't become members of gangs in this country? Isn't that really the same? Isn't this the same type of issue? And shouldn't it be approached from the bottom up rather than from the top down?
In fact, permit me to respond with this example. I was in Edmonton, and I'll use, if I may, the Aboriginal community that's been fairly integrated there. And I went to a youth center, drop-in center, and all ages, 7, 8 years old, including 15, 16, 17-year-olds. And it was wintertime, and it can be pretty cold up there as it is here. And I was asked to stay a little longer after meeting with different youth groups and what they do and so on, because these 4 members of a youth gang wanted to meet with me. And so I waited, and they came in, and these 4 guys, they looked like they had been, defensive linemen out of the New England Patriots. I mean, they were humongous. And they were 15, 16. And so we sat down. And their question to me was, how do we get out of this? How do we get out of having to be in these gangs? How do we get out of being suckered in and then not being able to extract ourselves. How do we get out of it in trying to protect our sisters who are being used as prostitutes downtown, and we're protecting them against them being overly abused, if I can use the term, and the like. And so there is here at home a need for that consciousness of disenfranchisement will lead to recruitment into groups that can be cohesive, give them a sense of cohesion and even protection, or simply sucker them into that sense of empowerment, and ultimately they can't find a way out. In the favelas in Rio, the youth that I met, the last day I was there 5 days. And the last day I met with these youths, and they told me, you know, there's only two ways of getting out of this sort of drug gang scenario. First, you got to recognize that the life expectancy is on average about 3 years in it. Secondly, however, to get out of it, there's two ways, either in a wood box or in fact with the Bible. And it was interesting that all of a sudden this whole dimension of spirituality came into play. And that the evangelicals have been doing enormous amount of work in hauling them out and protecting them. And so in our research, we've discovered that the spiritual side, the whole sort of voodoo and all the dimensions of the social cultural side of how they've used that to influence the kids, that they can be protected from being killed by they can walk into bullets because they're carrying such and such an artifact and so on. That has enormous amount of power. But it was interesting, there's not just power on the kids, it was the parents who also believed in this stuff. And so how do you shift the cultural dimension is important. So in our own society, we've got a learning curve in certain areas where there are so many youth still disenfranchised, and that is an exit for them. And it can be fatal. Too often it is.
One last question.
Oh, come on now. Thanks. Yes, ma'am.
For children who have for any reason become child soldiers but cannot, to use your words, extract themselves, how helpful is an understanding of the factors in the Stockholm syndrome in helping to formulate? Shall I repeat the whole thing? Okay. For children who have for any reason become child soldiers but cannot extract themselves, how helpful is an understanding of the factors in the Stockholm syndrome in helping to formulate a plan to rehabilitate child soldiers?
You opened the door for me to nearly be flippant and not pejoratively by saying I recommend my second book. However, when I argue that the child, the youth, although through all the indoctrination and so on, generally is not destroyed, that the youth is still there, and that there is a means of getting at that youth to pull them out of that near sort of virtual incarceration, be it willingly or not, whatever terminology and indoctrination, that you can actually go at that. I argue that we can, in fact, break down that sort of isolated and in sort of encompassed in the group by fairly simple means, in fact, radio stations, to make them feel that they are not in that lock-in, but in fact that there is an outside world that can get into them, and that they can, in fact, extract themselves out of it. And so in many of those countries, there's not much TV and so on, but the radios are prevalent and doing extensive work through the radios. They tend to find ways of picking up the message. and a message of how to extract themselves, when, where, and so on. And there's not enough jamming capabilities in any of these forces to stop that. And so what we're looking at is organizations that do help us punch that message out there and tell them where they can be safe and where they can become safe. In northern Congo, in the Ituri area, the best radio stations are run by the Catholic Church. In fact, they're the only government really in that area. But they are continuously blasting out messages and children finding ways of extracting themselves because of the information that's being provided to them that way. That's as close as I can get to it. Thank you very much.
We have to get you down for a 2:30 slot at NPR. So we're going to end there. Please join me one more time in thanking. And we'll take a 10-minute break, and then we're going to begin right at 2 o'clock with our next panel. Tim Webster is going to be the master of ceremonies while I'm gone, but I'll be back shortly.
Yeah.
Ready to hear our third panel of the day. I will send icy glares to those of you who are not sitting down and being quiet. Okay, great. So over the course of the day, too loud. Thanks. So many different audiences to please. We've talked about the big fish and the little fish, and there's been a conspicuous emphasis on the idea that child soldiers, child pirates, and so forth are at the bottom of a very long and dense chain that goes all the way up to the top to banks and financiers. And so this panel will help address what kind of enforcement mechanisms, what kind of methods are out there to go after the people who are really pulling the strings from banks or from other areas, who are not out there doing the work of child piracy or child soldiers, but are profiting from it. So we have 3 distinguished panelists and my colleague, Juscelino Collares, to start it all off. Thank you.
Tim is about a foot taller than me, so. Conference participants, dear colleagues and students, remaining members of the audience. My name is Juscelino Collares. I'm a professor here, and I'm thrilled to be with you this afternoon to have the chance to introduce your panelists, Yaram Gottlieb, Hugh Williamson, and my esteemed colleague, Richard Gordon. First, let me allow you to tell you a bit about how we'll proceed before I introduce each of them to you individually, and I would also like to make some brief remarks after my initial comments on how they will and who these people are. Yaram Gottlieb is a senior counsel at the Office of Legal Affairs at Interpol. He attended law school in both the United States and Israel. Yaram is a member of the New York and Israeli bars and a visiting professor at Université Jean Moulin Law School, where he teaches a course on the protection of cultural property under international law. Hugh Williamson is a law professor at Dalhousie University, where he is also lead investigator and manager of their marine piracy project. He's one of the world's most prominent authorities on maritime legal issues dealing with fisheries and ocean management, and of course, piracy. Finally, Richard Gordon is our resident expert on legal matters involving financial sector regulation, money laundering, and terrorist financing. Besides being an accomplished expert in these areas, Rich is a graduate of Harvard Law School, an expert on development, a world traveler, speaker of several languages, and the best cook in the Cleveland area.
I'd also like to note that, like Juscelino, I'm on sabbatical, so I'm now going to remove my tie, and I want you to know that I do own one.
Just stop there.
I'm doing that too. I'm on sabbatical too.
I didn't sit in the front row.
Later. I'll follow your lead, Richard. All right. So, and so we are very finally, we used to work at the firm in DC, and we are finally very happy to be working at the same law school. All right. So to my remarks, very brief ones. On the allocation of talent, implications for piracy preemption. When they are free to choose among careers, people choose occupations that offer them the highest returns on their abilities. The ablest member among us tend to choose occupations that exhibit increasing returns to ability, since increasing returns allow superstars to earn extraordinary returns on their talent. LeBron James is infamous in Cleveland. I'm going to take my talents to South Beach and join the Miami Heat. Shows that players are willing to forego even direct compensation, he took a pay cut, to grab higher indirect revenues from playing in a better team, let alone winning NBA titles. I'm not saying anything about the cities, though, Miami Beach and Cleveland. Of course, some people have strong comparative advantages from natural talent for particular activities, such as singing, Formula One racing, Ayrton Senna comes to mind, and basketball playing. But others who may not have these great specialized abilities, yet are lucky to grow up in the right environment, possess great intelligence, or are other generally valued traits, can become the best in many occupations. They can become entrepreneurs, government officials, speculators, clerics, and of course, pirates. The environment where they grow matters a lot. In different countries and time periods, talented people have chosen occupations in which it was the most attractive to be a superstar. When markets in a country are large and the institutions that surround them operate within set rules and efficiently, talented people can easily organize firms and keep their profits by becoming entrepreneurs. This is the case in the United States, Great Britain, Japan, etc. In many other countries, talented people do not become entrepreneurs, but join the government bureaucracy, army, organized religion, and other rent-seeking activities because these sectors offer the highest prizes, or they leave. This is the case in much of Latin America, Africa, Asia, and Europe, up to the 19th century. This is the case in failing states. The vacuum left by the absence of a functioning government, a hierarchical army, and the powerlessness of other institutions induces the most talented, at times, among those who have not left to pursue criminal activity. These examples show that talent is often general rather than occupation specific, and that its allocation is therefore governed not just by comparative advantage in cultural backgrounds, but also by returns to absolute advantage in different sectors within a given society. Take the United States as an example. The flow of some of the most talented people into the financial services industry in the past 2 decades followed the higher returns this sector had in comparison to other productive sectors. Big, The general point remains, talent and leadership will go to activities with the highest private returns, which need not have the highest social returns. There, I managed to link pirates to Wall Street financiers in the same speech. Thus, if rent-seeking and productive entrepreneurship are in fact competing for the very same people who are the ablest in a society, we know piracy, preemption, not just punishment, will require a deep level of cooperation to be accomplished. We will leave this room wiser after we hear what our experts have to say. We'll start with Yaron.
Thank you very much, Mr. Chair, for the kind introduction. We have to go through this. Good afternoon, ladies and gentlemen present here, and also I'll take the opportunity to say good morning or good evening, depending on the time zone of those watching us through the webcasting of the conference, and with hopes that it's working also at the other side of the ocean in France, where I come from. Then I would assume that the most difficult question that I will have to face at the end of this presentation would come from my dear wife and 2 daughters currently watching us, hopefully, over dinner, which in itself is not very welcome in France. TV dinners and webcast dinner, let alone, are not very popular there. Nonetheless, very glad to be here today and to participate in this very interesting conference. I've already learned a lot from the previous discussions. My presentation this afternoon will focus on international cooperation and information sharing in combating maritime piracy, and I'll also mention a number of challenges that we are facing in that regard at Interpol. And I'd like to take first a few minutes very shortly to mention a few words about Interpol, really in a nutshell, since I'm here for the first time. Interpol, the International Criminal Police Organization, was created in 1923, and as of today we have 190 member countries, practically universal membership. Our constitution from 1956 provided Interpol has been created for the purpose of promoting international police cooperation. Therefore, we are an international organization promoting police cooperation. We are not an international law enforcement agency. Those of you that have eagerly read Da Vinci Code and watched Lord of War and similar Hollywood movies, I'm very sorry to disappoint you. It is fiction. It is fiction, but nonetheless, we do provide support to our member countries in police matters. That's what we do, and we do it by developing a number of tools and services, such as the communication networks that connect all our member countries. It's called I-24/7, and millions of messages are exchanged each year between police forces around the world, also in reference, of course, to piracy. We've put in place a number of criminal databases, such as DNA, fingerprints, and so on. We have a SLTD database, that's stolen lost travel document. One thing in common, by the way, between the Navy and the police is a common use of abbreviation and acronyms. We feel very operational when we do that. Whether or not it's a case, it's a different question. And I'll mention only one more acronym that we use in Interpol, and that's called an IRT, Incident Response Team. Interpol does not have executive powers to investigate in national jurisdiction, but upon the request of countries, we do engage in a criminal investigation in member countries if we're invited to do so, and we do it by dispatching these IRTs, a group of experts that goes to a particular country, and we have done so already a number of times also in the context of maritime piracy. For example, gathering evidence after the release of boats, after the ransom has been paid, and again in collaboration with local police forces. In January 2010, we have created the Maritime Piracy Task Force, a dedicated task force to address the growing problem of growing threat and risk of piracy. And as of last year, we've also put in place a database specifically dedicated to maritime piracy. We already have quite a lot of information in this database from our member country. And the main purpose of this database is to identify and to try and have enough information to put together that will assist us to identify the kingpins, those that are ordering and are leading the criminal networks that lead to the piracy attacks. And we have to bear in mind that in modern piracy, unlike what it used to be maybe 200, 300 years ago, those that attack at sea are the low-level piracy. And that's why we're talking also about juvenile pirates so often. 14 years old, 15 years old are sent to sea, but those that order and lead the groups are at shore, and therefore we're trying to go after them. And one other thing that we do with this Maritime Piracy Task Force is to provide training and capacity building to our member countries, and we should not underestimate the importance of doing so. Police around the world, and in particular in some countries in East Africa and West Africa as well, they don't have the tools and they don't have the know-how sometimes of what to do with these piracy incidents. We have cases of cell phones confiscated from pirates and held by the police, but they didn't know how to exploit the SIM card. As simple as that. And how much information can we obtain for these SIM cards? That's the type of thing that we do through the capacity building. Going back to our constitution, an interesting legal question, since we're here in law school, arose at the very first stages of our engagement in combating maritime piracy, and it concerns Article 3 of our Constitution, according to which Interpol must not engage in any activity of political, military, religious, or racial character. And the question that we had to address at the Office of Legal Affairs, where I work at Interpol, was, can we work and cooperate with the navies? Can we cooperate with organizations such as NATO, which by the very definition and purpose have some objectives of military or political character? And we had to assess this question based on our constitution, our understanding of our rules, and we implement what we call a functional interpretation of Article 3 of our constitution, based on which we look at the nature and purpose of the foreseen cooperation. And we said that by the end of the day, we're talking here about cooperation for the purpose of law enforcement. Exchanging information on fingerprints, for example, is not Navy information, it's not military information. It's information that is meant for prosecution later on down the road. And as long as we focus on this type of exchange with the navies, with NATO, with other organizations, in such cases, Article 3 is not a legal obstacle for our involvement. And based on that, we gave a green light to our Maritime Piracy Task Force to engage in such activities. So that's about Interpol really in a nutshell. And if you have further questions, I will be very glad to take it later on. And then to move to international cooperation. Now, we all know that the legal framework for combating piracy is found in the UN Convention on the Law of the Sea, Article 100 to 107. And most of the discussion so far has focused on Article 101, that's the definition of piracy, and the operational, so to speak, provision of the piracy section, notably Article 105. And in my opinion, relatively less focus was given to Article 100. And Article 100 of the piracy section provides for the duty to cooperate in the repression of piracy. And I would submit that it's not a coincidence that the piracy section starts with this article, with Article 100. It's a driving force behind the whole piracy section. It sets a tone It's the only provision in UNCLOS whose title is the duty to cooperate. It uses the strongest terms that you can find in UNCLOS to the fullest possible extent. Article 100 does not detail the specific obligations, but nonetheless, we're not prevented from reaching some conclusion of this duty to cooperate. And one conclusion that I have reached, and there's more discussion in my paper, is that I believe that the standard to be used when we look at Article 100 and when we assess whether states are compliant with the obligation under national law is a due diligence principle under international law. And specifically, we need to look into whether states have exercised the best efforts, that is, concerted, sincere, and proactive efforts to combat maritime piracy. I also propose that the substantive provisions, such as Article 105, be interpreted in light of the duty to cooperate in Article 100. There's more in my paper, and if I'm not mistaken, the chairman would be interested in asking me a particular question after that, so I will leave this point for further discussion later on. Now, to be clear on that, I'm not suggesting that we have an absolute duty to cooperate. Of course, it can be qualified in certain instances. But by the end of the day, this is a general duty. This is the way we need to look at international cooperation. And here I would quote Professor Wolfram, the former president of the International Tribunal of the Law of the Sea, who stated that turning a blind eye to the activities of pirates is in itself an act of piracy. In itself an act of piracy. It's a very strong statement. I don't know if we need to go that far, but I believe we can convey this message of the importance to cooperate. The next point concerns sharing of information, and again, very briefly, because there's more discussion in my paper, Article 100, as I mentioned, does not specify the specific duties to cooperate, but nonetheless, one which is very clear is a duty to share information. It also derives from other instruments, such as the SUA Convention mentioned earlier today, Security Council resolution, and even decision of the International Court of Justice, such as in the Corfu Channel case, the duty to forewarn that's found in this case. In other words, if you have relevant information, share it internationally with other states, with international organizations. If you wish to impose restrictions, such as based on national security, do it on an exceptional basis and not as a standard procedure. So that's very briefly about the duty to share information, and having established the duty to cooperate and the duty to share information, the next point I would like to make is about the nature of cooperation when we talk about combating piracy. Because typically a criminal activity is dealt with by the police, but here we have to recognize the need to integrate other entities. Of course, we have the Navy, we have the shipping industry, we have the police, and we have, of course, the judiciary later on. And that's why I call this type of cooperation, specifically in combating maritime piracy, interdisciplinary cooperation, because the various entities come from very different disciplines, again, shipping industry, Navy, and military, and police. And that's a paradigm that we have to implement in combating maritime piracy. But this is not without difficulties. For example, if this conference was held here 4 or 5 years ago, I would not have been here, most probably, because at the first response to the piracy off the coast of Somalia was to dispatch the navies and thinking that that would be enough. And then only later on, countries realized there's a missing link between the navies and the prosecution. And that's the role of the law enforcement. That's also why I'm here today. We had other difficulties we still face from time to time because, again, these entities from different disciplines are not used to working together. Just a few examples with the shipping industry. A typical situation would be that after a boat has been hijacked by pirates, and after it is released, the seafarers, what would be the first thing they would do as good seafarers? They would clean the boat. That's what they have been educated for years, which is the right thing to do, except that from a law enforcement standpoint, it's a sheer catastrophe. We're talking about destruction of the crime scene. Not deliberately, but that's the outcome. So we had to sensitize the shipping industry of the importance to contact first as the local police or Interpol in some cases in order to gather the evidence before the boat is being cleaned. So simple and yet so important for the purpose of investigation. With the Navy, we had a different type of difficulty, and that is a tendency of the Navy to classify every information that it collects in the context of naval operation. But again, when we talk about combating piracy, it doesn't make sense because this information has to go to the law enforcement community and then, of course, to prosecution. So we had to explain to the Navy that it's better not to classify this information in the first place, or if it has been classified, it should be declassified so we can use it further on. One last difficulty with regard to sharing of information that I would like to highlight, and that's something we continue to face, it is the proliferation of information networks and platforms that are created on the international level, on the regional level, to collect information and to circulate it. And the difficulty here that we have is that, first of all, sometimes it's simply a waste of resources. If you already have good structures in place, why create a new network? But more importantly, most of these networks very often tend to work in closed circuit. In fact, in a silo. So there could be very important information circulating in one network which is not available to the other network, for example, to us at Interpol. And there might be exactly that, might be the missing piece that we are looking for our puzzle to put together to connect the dot, which is circulated somewhere else. And that's why it is important to identify, if we can, a single information sharing mechanism. And this, in fact, was done by Working Group 5 that working on financial flaws under the auspices of the contact group. And the shipping industry very early on in this Working Group 5 said we need to have one contact point. We can't share information with everyone around the world and so many networks. And so we have identified this mechanism, which is in fact two-layered. First, we have one contact point in each country, and then we have one contact point on the international level, and that has been Interpol for the purpose of the private industry. And so just to conclude on this point, in order to streamline the flow of information, we need to centralize it, or alternatively, at least to have interconnection between the various networks. Very important for our success. Just to conclude, therefore, on the points I made here, first and foremost, the importance of cooperation and sharing of information as a legal duty under international law. As a legal duty, that's my argument. The shift in the mindset from the traditional paradigm of combating crime to an interdisciplinary cooperation paradigm. And finally, and here I am, this is the last point just to capture what I would like to convey here. This panel is called New Ideas to Fight Piracy, but here I would like to be a bit traditional and say there's no need to reinvent the wheel. First look to existing structures, existing networks, and only if you need, create new ones. And with that, Mr. Chairman, I will finish my comments for today, and thank you for your attention.
All right. Good afternoon, or good morning, good evening, depending on those who are watching us over the internet. First of all, thanks. Michael is not here, but thanks to Michael Sharp of the Case Western University for, first of all, participating in our intersectoral working group on piracy at Dalhousie University last year, and then for extending the invitation to be part of their network here at Case Western as well. Again, as has been emphasized many times, the cooperation in the fight against piracy is the critical thing. I think it was maybe a bit presumptuous of me to get this idea of new thinking in the fight against piracy, financing and plunder, preempting piracy before prevention becomes necessary. That this is maybe sort of fairly grandiose, but in actual fact, that's one of the areas that we're going to try and look at, and that is it's easier to stop piracy if you can keep it from actually occurring rather than trying to deal with it after the fact. My outline, I'm going to look at just very, very briefly, the definitional problem. I have a law degree and an MBA, but I'm going to talk as an MBA today, so law students, this is going to be business style, not so much citation and the legal side. Looking at some of the issues and why that has become important in our study, a little bit on contemporary piracy, and then I'm going to get into piracy cycle, a business model, indicators model that we've been working at, and identifying some possible outbreaks and a preemptive strategy. So this is going to be looking at the application rather than the theory behind it necessarily. I decided I would consult with an expert on piracy who's been hanging around Halifax for a number of years to see if he could tell me what financing and plunder were all about. That's at our Maritime Museum. That's how they used to treat pirates in Halifax 200 years ago on what is a very popular public beach known as Hangman's Beach for obvious reasons. The financing of piracy, I'm taking a broader view. The financing is the investment in piracy. And that includes human resources, logistic equipment, support bases, everything else, not just the money involved. And the plunder is the economic reward. And it's economic, but it's not necessarily just money. So we had a problem, and we spent a lot of time going around in circles and iterations. What do we mean by piracy? We all knew what piracy was, but if you took the legal definition, you were going to get yourself in a lot of difficulty because you're going to be narrowing your scope too much. So we took a look at a practical, what we call a practical definition. We knew what we wanted to talk about. We wanted to talk about a actual potential, a deliberate criminal act interfering with the rights and freedoms of the seas so that we could incorporate a number of different types of activities, targeting marine crafts and persons, and again, it was for economic gain. And one of the discussions we had, it's the purpose of piracy is for economic gain. The motivation of the individual pirate is not necessarily economic, and that is one of the distinctions that has to be made. So we got into what is not piracy, and I guess here, what the discussions yesterday destroys my third slide, in that the Ninth Circuit Court apparently disagrees with me that environmental activism is piracy in there. We took a look that piracy did not include IUU fishing, pirate radio, terrorism, environmental activism. That's the Farley mode. That is the Sea Shepherd Society that they were referring to, going out and ramming whaling ships, drug smuggling, slavery, mutiny, and downloading songs from the internet. And as I've had to explain a number of times when people call up, I said, you deal with music piracy, and as I told U.S. Customs coming in, I said, no, I deal with real piracy. If they download in a boat, call me. If they're on land, it's not my concern. So, what is plunder? Well, piracy evolves. Piracy emerges. The piracy we've seen around the world is not the same crime in the same area by the same people at the same time. There's a number of different outbreaks, and we'll be looking at that. But what are they after? Well, depending on the pirate gang, you have a number of different objectives. In Somalia, the model was ship's cargo and crew for hostage or for ransom. Some places they take the ship and the cargo as booty. They're looking to dispose of the ship and the cargo. The Straits of Malacca piracy originally was just break and enter on ships. They were after the money in the master's safe and whatever valuables they could take. Some of it was strictly a cargo motivation. Others, for example, in the Caribbean drug-related piracy, they were trying to get yachts for ships to use for muling drugs in the United States, or they're trying to get fishing boats to use as motherships to further activities. So there's a wide variety of different motivations for carrying it out, but the fundamental thing is it's a business. They're in it for profit, they're not in it for political gain or to make a political statement. Now, we were looking at at least seven major piracy outbreaks in the last 30 some odd years, scattered around the world. And we didn't focus on Somalia, and we intentionally didn't focus on Somalia. We were looking at the broader scheme of where are all these different piracies and what did they involve. And so if you take a look at it, you see that there was a wide variety of different perpetrators in a wide variety of different areas. These were all different. They occurred independently, and they had almost no relation with each other. There might have been some, hey, it's a good idea, maybe we should try it, but there was not the old style of a pirate moving from one area to the other. These are all independent people. The Caribbean Basin piracy, starting in about the 1970s, tended to be, at that time, hijacking of yachts for drug vessels. There is currently a piracy going on the coast of Guyana involving fishing vessels. You won't find out about it unless you read the Guyanese press, but they actually have a government piracy compensation fund to compensate their fishermen for losses due to what they're calling piracy. It's mostly inshore, so it wouldn't fit the classical legal UNCLOS definition of piracy, but it's the same type of guys doing the same type of thing in the same kind of water. Gulf of Thailand was the most serious of the modern piracy in terms of human life. Started 1970s with the exodus of the boat people, the ethnic Chinese leaving Vietnam. When you're a refugee, you don't have much. What you have, you've got with you. And so it became an opportunistic crime by Thai fishermen. The fisheries had collapsed. They started going out and attacking these refugee boats. If you've ever seen the boat people, 200, 300 people on a vessel. It was bloody. 500, 600, 700 people killed in a year on the bad years. 2,000, 3,000 serious assaults and sexual assaults. It was a very, very serious piracy, but it didn't attack big commercial vessels, so it didn't attract an awful lot of international attention because it was not of major economic consequence. It was dealt with finally by the Thai police going into the villages where the pirates came from and doing some fairly high-level prosecutions. The refugee floods stopped, and that essentially decreased the piracy. Straits of Malacca was initially the break and enter on ships. Ships slowing down to go through the straits between Indonesia, Singapore, and Malaysia. The pirates were sort of local gangs who would hop on board at night, tie up the master, rob the safe, and then get off. They weren't interested in the vessel or the cargo. They were just interested in what they could grab. South China Sea was better organized, and there was a tendency to, sometimes it appeared to be a hijack for a specifically targeted vessel. There were a few attacks which were taking cigarette-carrying ships out of Hong Kong. There seemed to be collusion involved, but it was something which involved taking a specific cargo or a ship. There's tugs were being taken to be sold on the market, repainted and flagged. So again, different pirates doing different things in a different area, but it's still piracy. West Africa coast, we've been saying, and we've been tracking that one for about 3 years now. It's making the press in the last 3 to 4 months. 2 years ago, the local gangs shut down the Nigerian trawler fisheries because they were attacking so many of the trawlers. This did not make the international press, and no one was concerned. It was only when they started taking tankers and big vessels that there was an international concern there. So this was one of the things we were looking at. Now, East Africa, Red Sea, Horn of Africa, that one has been fairly well talked about and has been, I think almost, I won't say dissected to death, but it's been very, very well looked at. And that is the one that's made most of the press. Why? Because it's the one that's costing the global economy $12 to $17 billion. And the Bay of Bengal, and one of the ironic things is Bay of Bengal on the northern side of Indian Ocean. I was at a meeting where the IMO and IMB stood up and said there have been no piracy attacks in the Indian Ocean in the last 3 months. And then I stood up and said there were 50 attacks on small fishing vessels off of Bangladesh last week. It made the press when 36 of them were tied up and thrown over the side and drowned. That one got attention. But the fact, and as a matter of fact, the Bangladesh government got annoyed with me for saying that because they don't want it to be called piracy because they don't want the insurance rates to go up. So there's a lot of piracy out there, but it's quite different. So what we were looking at is what we call the piracy cycle. And the piracy cycle, we said it's a business model, and what happens is by the time you notice it, by the time it makes the press, you'll recognize the business cycle in hindsight. You'll see where it started, but in actual fact, they never pick it up beforehand. It starts off with precursor activities. There are things that are taking place which you can say, here's where we're beginning to see lawlessness begin to take place in the maritime environment. It evolves then into an opportunistic type of piracy. And the opportunistic type of piracy is a fisherman, a smuggler, could be even a Coast Guard. So he's out there on the water being paid to do something else and making his profit. But he comes across an opportunity that's just too good to resist. And so he starts getting involved in making a little bit of extra profit by doing piracy. Now, when he starts realizing that he can make more money in piracy than he can in doing his regular job, then the piracy evolves into an organized business model. And eventually, as the organized business model becomes quite a sophisticated criminal enterprise, it turns into a sophisticated culture and business system, which is when it becomes very, very firmly entrenched. And you can see a parallel model in the drug trade, where they've gone from some guy carrying a few pounds of whatever in his backpack up to the fact that now you've got entire countries being ruled by narcotics gangs. And so in actual fact we see this. There may actually be a final stage to this that we've been sort of looking at, and the final stage would be the pirate gangs move on to something else because either piracy has become too risky and they're not making enough profit. And oddly enough, we're now seeing some reports that some of the Somali pirate gangs are now providing security to some of the illegal fishing activity that's going on in there. So they've gone from basically poacher to gamekeeper back to poacher again, and in a bit of a cycle. But that is essentially the cycle we look at. Now, the piracy business model itself, when we look at it, when you get to become a business, it requires a business model and it requires a lot of logistics to support it. You need food, fuel, storage. You need to recruit and train a crew. You need to get weapons. You need to get a support base. You need to have some kind of a financial transfer system, probably an informal value transfer system, some way to move your money around. You've got to maybe dispose of your cargo. So you require a lot of logistics to do it, and it's a pretty organized activity to run. Now, one of the things we said is when piracy begins to evolve, when it becomes from precursor to opportunistic, you've got a chance to attack the activities. When it's shifting from an opportunistic piracy to organized, there's another opportunity because that's their most vulnerable point to begin to look at them. So we looked and said, in the terms of the business model, what are the activities that, and where could they be the most vulnerable? And the one thing is, which are the obvious crimes? Which are the criminal activities they're doing? Well, obtaining weapons in most places, that's a major criminal activity. Opportunistic piracy tends to be quite often bush knives and machetes, maybe a small pistol or something like that. What maybe changed things off Somalia was they had RPGs and AK-47s and assault rifles. They were able to go after big targets because they had big weapons. That one is a requirement of organized crime, similar to what we're seeing in the drug gangs now. The corruption of local officials. Organized crime needs a corruption of the bureaucracy. They've got to be able to operate in an environment that is suitable. And this is one of the strange things that we've seen about piracy. Piracy does better in a weak state than it does in either a strong state or a failed state. In Somalia, it's in Puntland, not Somaliland or Somalia. In Somaliland, the government's too strong, they can suppress it. In Somalia, it's a total basket case. They can't keep the other pirates from stealing their stuff. They can't buy food, they can't get stores, they can't organize things. What they need is a state that's just strong enough, give them banks, access to stores, various things to keep the business running, but weak enough that it can't do anything about them. And that is one of the things that we look around for, is where they're likely to basically be able to set up because they've got the infrastructure they need. Now, on the recruiting and training of crew, I talk about criminalize. That's what we think is one of the critical weaknesses, and that's what General Dallaire and the others have talked about. If a third of their human resources are made up of kids, if you can stop them from recruiting the kids in there, and if you can criminalize that activity, you can start making it very expensive and very difficult for the organized piracy to keep its human resources going. If every time they go out on a pirate raid, you take a third of their manpower, especially some of the trained ones, they're going to have a difficulty in keeping going. So the criminalization of the recruitment may be a critical thing. And again, transfer and payment of money. When they start getting big money, then they start getting vulnerable. So these are some of the things that we were looking at from the point of view of where can we actually make an impact on piracy. Now, what we did is we had some of our people who are in the School of Business and deal with risk management to look at an indicators model. Is there anything you can find out there which may give you a hint that piracy is likely to break out? And so what they did is they came up with a model. They said, you've got, piracy goes through some stages. You've got no piracy indicators or precursors, nothing's happening. Then you begin to get precursor events taking place. So that is the period where you might be able to do preemption. A piracy event is one piracy attack. That is when piracy begins to occur, but a piracy outbreak for the statistical analysis was over 20 attacks. So what you had is a number of variables, and you can read this in the paper, which we reference there, but what we found was piracy outbreaks occur in relatively poor countries, high corruption level, low on the Human Development Index, faced with medium and severe socioeconomic impact. But the interesting thing was the one major correlation was the human flight and brain drain significance. We don't know why it's there, but when you get a lot of people moving out, it could be because of the refugees, it could be because that you're losing opportunity for people to have legitimate jobs, but that was one of the indicators, which then leads us to looking at where do we think piracy is at a risk. The purple areas are the ones that already have piracy. Brazil's an interesting anomaly in there. It could be because of the northern area around Guyana and the problems that they're having there. But when you looked at the countries that are at severe risk, of the countries that we had identified, 4 or 5 of them since the study have already had severe piracy attacks taking place, including Papua New Guinea, so something may be going on. Now, the serious refugee problems right now, we're looking at Syria. Syria right now is the serious refugee one, 2 million refugees. Are they leaving by sea? If they're leaving by sea, you've got human flight by sea. That might be a piracy vulnerability, which nobody, as I can tell right now, is looking at. So what is your preemptive strategy? Preemptive strategy is simply identify likely outbreaks early. If you can spot them early, you might be able to stop opportunistic piracy from taking place. Second thing is work cooperatively with other agencies. Now, what's important there is the tools, as has been said, are already out there. The agencies and the information are already out there. The problem is it's not their problem. And so what happens is you get the stovepiping. UNCLOS 101 and 100 say cooperate. That's for states. Try to get the bureaucracies in the states to cooperating among themselves. That's the trick to dealing with it. If you're going to reduce precursor events and aggravating situations, you can probably decrease the outbreaks of piracy, but it's going to require an integrated approach. Now, just quickly, I'll go through this. There's a new code for West Africa. If you take a look at what's happened, the Djibouti Code dealt with piracy and armed robbery against ships. The Djibouti Code, or the West African Code, which just came out last month, they've got money laundering, illegal arms trade, crude oil theft, human trafficking. They've got the whole spectrum of maritime security issues that they're going to be dealing with, and that is the integrated approach. So, how to deal with it? My conclusion? Specific anti-piracy actions don't occur until piracy is officially noticed. So the government won't do anything until it's been brought to their attention by a serious attack on a major vessel, okay? So if you share information, you'll be aware earlier, okay? You want to preempt organized opportunistic piracy by early intervention. If you can start spotting the problems on the water, then you take early action. And by reducing the profitability of the business model, then you prevent opportunistic piracy from becoming organized piracy. And I think that's what's going to happen off Somalia right now. They're now organized is dropped back, but if they don't do anything about it, the opportunistic piracy is going to start again because they're still there, they still have the same situations, nothing has changed. So, quickly, you'll see some of the faces around here. This is our team from the Piracy Research Project at Dalhousie University, and I guess questions of later, so thank you very much.
Hugh, thanks very much. This is going to be a very difficult act to follow. I don't have any slides. As I mentioned, anything that goes wrong today, I blame on the fact that I am currently on sabbatical. So thank you. Except for my throat, which is something to do with the pollen around here in Cleveland. So what I'm going to do actually is following on Hugh's presentation is look at one of the vulnerabilities that you noted, which is the profits, the money, to a certain extent, the financing. I'm doing that primarily because that's my field. But so as Hugh has just mentioned, there are really kind of different types of piracy depending on the objectives of the pirates and on the geographical area in which the piracy occurs. And if you remember looking at one of the slides there, I think it was slide table 2, you had that nice matrix showing the different types of piracy, the locations, et cetera. So I'm just going to sum that up to say that sort of the pirates in the East Africa, Red Sea, Indian Ocean area, they tend to grab the ship and its crew in order to ransom them back. While sort of all the other pirates pretty much, they grab the ship, they're looking for the stuff that's on board, they want to keep it, they want to sell it, something along those lines. And from the perspective of looking at finance as a vulnerability, these two types provide kind of different challenges. So I would say that the typical East African pirate group, the folks who are doing the seizing ships and crew for ransom, what they would do is, obviously, first they'd grab the ship. They would call the owner. The owner would typically speak to the insurance provider, figure out how much the boat was insured for, and say, we've got to do something about this. The insurance provider would then contact some kind of negotiator. I've never been called to do that before, but I'm available if anybody wants to call me. And then a negotiation would ensue. They agree upon a price. Apparently prices have gone between $1.5 million up to $35 million, although I guess because of the reduction in piracy in this particular part of the world, I'm not quite sure what's happened. This is statistics from managed to dig up from 2010 and 2011. And then a drop-off point typically would be agreed upon. So the insurer would go to its bank and withdraw a whole you-know-what load of money, typically in a mix of $100 bills, $50 bills, and 20s, and then they would drop it off. So then the pirates would get this money, typically an airdrop, and they would keep some of the cash in the jurisdiction, wherever it is, whatever country or nearby countries in which they're located, and they would use some of that cash to live on, to pay off locals that they need to pay off, including government officials and perhaps terrorist organizations that are also active in the area. But if they are in this for a business, as Hugh is discussing and as we've heard earlier today, and they're doing really well, there would be a whole lot of cash left over, a lot more than they could spend in the area. So what are they going to do? Well, they're not going to be able to invest it locally. Some of it may be, but what they want to do is to get it out of that jurisdiction and invest it in some place where they know the returns are going to be good and somebody won't steal it from them, right? So good way of doing this is to get it out and get it to a major jurisdiction, a central financial area where perhaps they can deposit it in a bank or where they can buy shares, big houses, perhaps in Mayfair, who knows. How do you get the money out? Well, there are two obvious ways. You can either transfer it out physically, or you can move it through the financial system. Now, apparently, at least, again, figures from 2010, there is a suggestion that probably about 40% of the ransom in the East African style of piracy was spirited out of the country in order to invest, and also probably to pay off occasionally investors in the piracy operations, at least at the beginning of this most recent bout of significant piracy activity there. What about the other types of piracy? Well, as we know, they might seize the boat because they want a boat. They might seize the boat because that's all they have, and then they want to sell the boat, or what we call fencing the boat. That's kind of similar to what petty criminals do, or even, I suppose, less than petty, more major criminals. If they steal property that they can't use or don't want to use, they sell it for cash. And then again, if you have cash, either from selling the property because you managed to steal it from the safe, you're stuck with doing exactly what the pirates who are doing the ransom for money are involved in, which is what do you do with the excess cash you can't use? You spend some of it, and then perhaps you want to get it out of the jurisdiction, and in that event, get it into a place where you can invest it and where it's safe. So why focus on money? Well, first, criminals have had a long, shall we say, primary interest in cash or its equivalent. It's because it can be moved easily, it can be converted into whatever good of service you want at the moment, and it can be invested and used later. So if criminals like it, you can guarantee that law enforcement is going to like to follow it too. What happens? Well, by doing so, they can perhaps find the perpetrator's confederates. They can use the trail of cash and the actual cash that they might seize as evidence in a prosecution. And of course, they might be able to confiscate the cash, which is the best of all, right? Because they get to keep the money. And of course, there is nothing like taking away the proceeds of crime when it comes to reducing incentives to commit a crime itself. So not surprisingly, criminals have long tried to hide their cash. And when they can't hide it, to hide their personal connection to it. And even best of all, any suggestion that the origins of this cash are of criminal activity. In other words, proceeds of crime. And the act of doing that is what we all call money laundering, which is one of the crimes that have been brought to the fore, particularly in agreements in the eastern part of Africa. So I will say, fortunately for those of us who are law-abiding citizens, or maybe for those of us who know a little bit about the rules and might be able to sell our services to not law-abiding citizens, over the past 40 years, anti-money laundering rules have become, I think, the most followed global governance standards in the world. The standards were developed and are continuing to be refined pretty much on a yearly basis by this group called the Financial Action Task Force. It's not an international organization. It is a task force. It was originally convened primarily by the US, the UK, and France back in the late 1980s. Since then, it's brought in the entire OECD and other major jurisdictions with financial centers like India and Russia and China and now South Africa. And they have produced something called the 40 Recommendations on Money Laundering. And since then, it included terrorism financing and also weapons of mass destruction and proliferation finance, excuse me. And I should say, even though they're called recommendations, they aren't recommendations at all. They are mandatory, which is something I'm going to talk about in a few minutes. So where did the anti-money laundering rules come from? As I say, really it was the US bringing this issue to the fore about 35, 40 years ago. So why did this happen? So basically it had to do with suppressing the drug trade, and particularly cannabis, which I get a big kick out of given that it's becoming increasingly legal in the United States, but eventually also cocaine, crack, and everything you can think of that is illegal narcotics. So why do you go after money laundering? Well, number one, as a general rule, people pay for narcotics with cash. They tend not to use checks, credit cards, or wire transfers. Obviously, the principal reason is that you have records. Records are not good if you're trying to hide your connection to the cache, or the possibility that the cache might have criminal origins, so that also there might be seized. But also, if you're selling drugs, you don't have to worry about bad checks or stolen credit cards and stuff like that. Illegal activity is for the other guy, not for you, I should say. Or for you, not for the other guy, I should say. The problem was that unlike the cash or cash value realized by sort of petty criminals, folks who steal cars and then fence them, or silverware or computers, kind of like during Prohibition days, the returns on illegal narcotics sale or trafficking were really great, right? Tons of cash. So what do you do with all this cash? Well, buying small ticket items might be okay. You go to the store and buy something, go to the garage and get your car fixed, maybe even buying a car. But at least in New York and Los Angeles in the 1970s, and then later on, if you show up to buy a really nice big Ferrari, the kind of things that drug dealers like to own, or a really big house in Bel Air, and you carry big bundles of cash, somebody might notice, right? It looks a little dodgy. And if you try to go in and buy stocks from your stockbroker, they might even drop a dime. Good old expression before there were cell phones. You might even drop a dime to the FBI. Now, why is that? Because in the 1970s, in the United States and major cities also in other developed countries, people just weren't using cash like that anymore. Maybe for small items, again, there could be stores like 7-Elevens that were still taking a lot of cash. But by and large, people were using the formal financial system. So I'm going to take 2 seconds. Some of you already know about this from me, have taken my banking law course, but with the exception of weird things like Bitcoin, which I won't go into, the formal financial system is the cashless system that is based on banks, okay? So essentially, as countries move toward a formal financial system, the formal, what we call the payment system, you're effectively withdrawing cash from the economy and replacing it with a system based on, I have a claim against my bank. And instead of transferring cash or gold bars or something, what you're really doing is you're transferring claims among different people against their banks. So just very briefly, if I open up a bank account with cash, I give cash to the bank. What I'm really doing is I am investing in the bank and I'm getting an unsecured claim against the bank, which I can then transfer to somebody else. And people can transfer their claims against their banks to me. So that when I get my paltry check from Case Western Reserve University while I'm being on sabbatical, which means I'm on half wages, but that's another issue, I don't actually get cash, right? What happens is that Case Western has a claim against its bank, and it transferred some of that claim to my claim against my bank. That's what happened. So why is this very useful? Why is it better than hauling big bags of cash around? Well, obviously, it's a whole lot more efficient. It's really fast, particularly once you have electronic banking. And it protects those big bags of cash from being stolen by highwaymen, highwaywomen, or of course, pirates as well. So, in order not to stick out in places like New York, London, Paris, and Tokyo, at least back in the 1970s, you need to get your money into the formal financial system. Because if you don't, people are going to be curious why you're carrying big tons of cash around. So what is the first major anti-money laundering rule? What it is? Very obvious. It is if somebody shows up with a whole lot of cash and tries to make a deposit into the bank, which is the sole entry into the formal financial system, you tell the bank to fill out a little piece of paper and send it to the government. Somebody's putting a lot of cash in here. And that's, of course, what happened. A $10,000 cash reporting requirement was instituted in the United States, the first major anti-money laundering rule. So if you're a criminal, what are you going to do? $9,999. That gets to be a real pain. Eventually, the government says, well, if it's close, you should add this up. What you do is you open up a whole lot of bank accounts for $5,000, right? The only problem is there's only one of you. So you have to start using a lot of assumed names. So what do you think the next rule was? Banks are required to identify who you are. You really are. Not just show up and open up. I am John Big Booty, John Little Booty, John Tri Booty, or something like that, right? So that was the second step. So what's the next thing the bank is going, what's the next thing criminals are going to do? They set up not accounts of real persons, but physical persons, but corporations, legal persons. So pretty soon you have ABC Corporation, ABCD, ABCDEFG, et cetera, at different banks. You're avoiding the cash reporting requirement. And of course, meanwhile, the government has figured out there are these companies that actually genuinely do, as part of the legitimate business, get a lot of cash. So they've come up with exceptions to the cash reporting requirement for them that are tied up with this new anti-money laundering rule, which is banks don't have to just identify who you are or identify who the corporate client is, because it's very easy to create any kind of corporation, but they have to figure out what the legitimate activity is of that company. If it's legitimate and we expect you to get all this cash, then it's okay, file no report. If it isn't, you have to file a report. All right, so these standards have since become globalized, pretty much in effect everywhere in the world, because if a jurisdiction has not implemented them, then what happens? It means that companies, I should say, financial institutions, banks in jurisdictions that have, meaning the developed world, cannot do business with companies, banks that are located in jurisdictions that have not implemented these rules. So they become pretty much globalized. So how can we use these rules to try to go after pirates in particular, as opposed to just drug dealers or other criminals? Well, looking at the piracy involving ransoms. You have all of this cash. You have to either put it in a bank in the local jurisdiction or get it out of the country by courier or by informal means into a bank in a developed country jurisdiction. The problem is that the banks in local jurisdictions often don't implement these anti-money laundering laws because they're difficult to do and they're expensive. So often, if you get the money into those jurisdictions, you still have to get them transferred out through the international financial system. So to get it into a jurisdiction like the United States where you can make an investment, put it into a bank there where it's safe. So at that point, you need to get sufficient information either to the extent that the local jurisdiction is enforcing these anti-money laundering rules, to the extent it isn't, and it's going to a place like New York or the United Arab Emirates. Get them enough information so that they know that these cash proceeds are not the proceeds of legal activity, but illegal. And what would be the best way to do that? Well, these insurance companies are withdrawing huge amounts of cash. If they can report this, and it gets around to all the financial institutions in the world, this will really help banks in places like New York, et cetera, to identify transactions from the piracy jurisdiction into accounts in the developed country jurisdiction as coming from ransom. That's my one idea.
Well, we had great interventions from our panelists. I would like to ask a brief question to one each, and then later, I'll open after the answer the floor to the audience for Q&A. So, Yaram, in your article, you indicate the current practice of naval forces to hand suspected pirates to regional states face trial has raised some criticism. The practice that the Navy of country X apprehends pirates in the ship, and then you basically surrender, these individuals to be tried, say, by the courts of country Y. UNCLOS Article 105 establishes that, quote, on the high seas, every state may seize a pirate ship or aircraft, and adds that, quote, the courts of the state which carried out the seizure may decide upon the penalties to be imposed, end quote. Critics have interpreted this language to require any apprehended pirates to be tried in the courts of the seizing country. Obviously, this is a clear challenge to the jurisdiction of Kenyan courts over the Sussex, for example. You and others have rejected this jurisdictional defense with the argument that, quote, the strong duty of cooperation in regard to piracy, as articulated in Article 100, would include and condone exactly this type of cooperation. While I'm no pirate hugger, I am not sure Article 105's grant of jurisdictional authority to, and I quote, the courts of the state which carried out the seizure can benefit from such a broad interpretation. So 2 questions. 1, aren't jurisdictional statutes generally narrowly interpreted? And 2, don't the rule of lenity and the in dubio mitius principle require adoption of a narrower interpretation than what you and your sources propose?
Thank you for the question. Very good. So somebody has read my paper so far. That's a good sign. It is a very good question. And this morning you've heard from one of the panelists very early on stating that the law of piracy is revisited by countries, and that's part of it. We are now in times where national jurisdiction have to address this type of question. And I believe to answer this question, it depends on the overall approach that we take to the piracy section and whether we want to adopt a broad interpretation or narrow interpretation. Naturally, coming from the law enforcement angle, I would advocate for the broad one. But that also corresponds to the overarching principle of UNCLOS, which is to ensure the freedom of navigation on the high seas. And we've seen this type of question not only with regard to Article 105 and the question of transfer, we've seen this with regard to the definition of piracy, ecoterrorism, the discussions that we had yesterday, and Hugh raised a question on this. Article 101C, still with the question of the definition of piracy, does it cover on-land piracy? Not all of these questions. There's a main question we ask ourselves: should we adopt a general and a broad interpretation of the piracy section? And I believe the answer should be yes, despite the fact that jurisdictions tend to sometimes approach it from a pure criminal procedure standpoint to adopt a narrow approach. Here we're talking, by the end of the day, of a crime that originates from international law. And we have also to bear in mind the fact that under international laws, as a general principle, and all of the law students here, I'm sure, have learned about it, coming from an old decision of the Permanent Court of Justice in another maritime incident between France and Turkey, according to which whatever is not explicitly forbidden under international law is allowed for countries. And Article 105 does not forbid the transfer of suspects for the purpose of facing trial in a different jurisdiction. So that would be my argument, and may or may not be convincing. We'll have to see what national jurisdiction decide on that. And in my paper, by the way, without knowing at the time on the list of speakers, I quoted to support my argument a distinguished speaker that spoke here before, and that's Mr. Roach, and I quoted his article saying that it is, in his opinion, and in my opinion as well, would be inconsistent to argue that Article 105 does not allow the transfer of pirates to face trial in a third country, inconsistent with a strong duty to cooperate under Article 100. So I hope this is convincing. We'll see whether national jurisdiction are convinced by that.
Questions for you now? Hugh, page 11 of your piece, you indicate a timeline that illustrates the evolution of the phenomenon of piracy from its absence to its outbreak. It seems to me that the biggest bang for the buck in terms of piracy prevention, of a piracy prevention strategy, which you call preemption actually in your paper, might occur at the stage in which one detects precursor events. You did go into some of that in your presentation, but could you go into more detail on what these events are, what specifically these events are, and what current efforts by international institutions have been deployed in this particular portion of the spectrum?
Well, again, looking at the kind of precursor events, there was some debate about whether attacks on fishing vessels were in actual fact a precursor event or in actual fact piracy. And the shipping industry thinks they're precursors because they don't think piracy takes place until you actually take one of the big ones. But also, for example, in the Somali situation, the illegal reported fishing, the reported dumping of toxic waste, a number of incidents which had taken place, all of which combined with the breakdown of the Somali government, could all be precursor events when you're looking to a functional government falling down into a weakened state situation. So the kind of precursor events which we would be looking at would, for example, be, in my opinion, like Syria. You've now got a refugee crisis in Syria. That is a potential precursor event that we've seen piracy follow refugees in Somalia. We've seen it in the Gulf of Thailand. We've seen it in other places. So now we've got Syria with the refugee crisis. If I were in anti-piracy business, I would be looking at that very, very carefully to see what's going to happen, because I don't think that you're going to see pirate gangs coming out of Syria attacking commercial vessels. What I do think you're going to probably see is going to be individuals around that area, for example, beginning to target the refugees and beginning to rob the refugees as they leave. So that's the kind of precursor event you want to look at. You want to look at where there's a breakdown, because the capabilities to deal with these things, you've got Department of Fisheries, you've got Coast Guard, you've got environmental patrols, you've got all kinds of people out there looking for their problem. What we have to do is we have to get those people out there looking for other people's problem as well. Because when you start to identify, yes, I'm out there doing fisheries patrols, but boy, I've noticed an awful lot of smuggling going around here. Well, that may well be a kind of precursor activity. And it's something when I was teaching enforcement, we always used to remind the customs officers in a lot of jurisdictions. A customs officer by law is a fisheries officer in a lot of jurisdictions. His customs jurisdiction goes out to 12 miles or 24 miles to the edge of the contiguous zone for doing customs law. His authority as a fisheries officer goes out to 200 miles. He needs no excuse or no reasonable cause to board a fishing vessel to do an inspection to see whether they've got a license in doing illegal fishing. So don't say I said to do it, but if you happen to be out there and you see some ratty old fishing boat proceeding along the way and you're suspicious, you put on your fisheries officer's hat, go on board and say, where's your fishing license and your gear? He says, I have none. Okay, into port. We'll do a detailed inspection. That's when you find the guns and the drugs. Okay? He hasn't violated any laws because he's doing it as a fisheries officer. And this is the problem when I said cooperation among states for piracy is really good. Cooperation among the bureaucracies within the state to suppress piracy is where a lot of the work has to be done. And that is why we don't need more law, we need more effective use of the ones that we already have, which is echoing what my previous speaker said as well.
And my final question to Richard. Cesare Beccaria, the great Italian criminalist, had the insight that two criminals.
Ancora il suo nome?
Cesare Beccaria.
Grazie molto.
To criminals, the length of prison terms matters less than the actual probability of getting caught. If punishment is very severe, but the likelihood of getting caught is low, potential criminals will decide to commit crime. So authorities now focus more than ever on influencing the probability side, hence the greater monitoring, NSA spying, stop and frisk measures in New York City, and the reduction of crime in general. Your discussion talks about methods of detection through the financial system. They seem tried and ineffective. Yet informal systems like hawalas remain a challenge. If criminals react to these methods, how useful are they going to be in the long term if hawalas allow them to bypass the official banking system?
I'll answer the hawala question first. The thing about hawalas is that they're not part of the formal financial system. So the way hawala works is that, I have my cousin who lives in London, and there are people who want to send money to the US to the UK, the UK to the US, and so because I can trust my cousin, well, okay, not my cousin, my friend who is in London. And so somebody will give me some money, I pick up the phone and I say, okay, take the equivalent amount of money cash and give it to the recipient over there and vice versa. At the end of the month or maybe the week, we're going to have to consolidate and figure out, net out the transfers one way or the other, and probably we'll actually have to use a bank, typically hawalas do. So use a bank or could even be a courier of cash, because if it turns out that more money was sent to London than here, there's going to have to be a little, in consolidating the accounts, a little ship of cash over there. But it's still outside of the formal financial system. So if you're say with pirates again, particularly the ones who were making so much money out of ransoming on the Somali side of things, if you have excess cash that you can't just carry around in valises, and then invest that or buy something in Mayfair or in London, you still need to get it into the formal financial system, and a hawala will not do that for you. So there has been an enormous amount of attention to hawalas, which I think is, including by me back when I worked for the IMF, but I think it may have been overdone. The focus should be on where you can really grab cash in the formal financial system, which is the formal financial system, and not outside of it. And that's what anti-money laundering rules were designed to do. To try to pretend that they're doing something else effectively, I think is wrong. And going to your first point about probabilities of being caught, and that's absolutely right. I actually wrote a book chapter on that very topic before any of you were, in grade school. It was so long ago, but I think the point is still correct. And there have been a lot of people who have written, including me, on the relative ineffectiveness of anti-money laundering laws when it comes to very sophisticated criminal schemes. My question here is, I don't think what's going on right now in piracy is particularly sophisticated with respect to the financing part, or the getting the cash out. It's huge amounts of cash. And what's happened is the very simple rules have simply not been enforced. Number one, with respect to initial entry of the cash into the banking system, if it is in if it's in Kenya, and I've actually worked on anti-money laundering in Kenya, they have not a bad system. But locally, it's very expensive for banks to implement these rules, and it's very difficult and expensive for local governments to enforce them. So giving more attention, and I would say more technical assistance, simply more cash for countries where the pirates are located, they're giving them more cash to help to enforce these rules is really what you need to do.
Thank you. Thank you, three, for your wonderful answers, and now I open the floor to the audience. Professor Nanda.
Well, thank you very much.
Yes, it's all.
Professor Gottlieb, you responded that maybe you ought to look at that broadly, because whatever is not, that article broadly, because whatever is not prohibited is permitted. Now, that is the old positivist notion. I think I would not probably go there. But I would argue that anything you look at the law of treaties, whether it's the Vienna Convention or otherwise, you look at the object and purpose of the treaty. And if you look at the object and purpose of the treaty, then I think you don't need to construe that article very, very narrowly.
Agreed.
We have 1.5 more minutes, so next is Dowse.
Hi, I think it was Mr. Williamson. You said you were talking about the risk indicators.
Yes.
Human flight, and if I read correctly, brain drain.
Yeah.
I understand the human flight, but could you please explain the brain drain, what that is? And
The brain drain component, this is part of the Human Development Index, is when the entrepreneur or the smartest and the brightest leave the country. And what we think might be the fact there is if your bright entrepreneurial types leave the country, what's left behind are less economic opportunities for people to be employed. So you're going to increase the unemployment, you're going to increase the the breakdown of the country, which again leads to a fertile environment for piracy. You've got unemployed youth who are looking around for something to happen. I've always figured, I've been waiting for something to happen in Haiti. I think Haiti is the Western Hemisphere prime candidate for piracy. I think maybe the earthquake saved us in that so much humanitarian aid went in as a result that all the other festering factors haven't come to fruition. But as the aid and as the international attention pulls out, you've still got poverty, you've still got access to the sea, you've still got a high amount of unemployment, and you've got access to the boats and the equipment. So that would be, for example, someplace that I would be keeping a very, very close eye on to see, because where are the brightest and the best Haitians right now? They're not in Haiti. They've all left, and so you have to get into the solution to piracy is always ashore. If you want to stop a pirate attack, you do it at sea. If you want to stop piracy, you have to have a stable government ashore. And so building up some of these basket case states into a case where they can start functioning again and providing economic opportunity is the solution.
Well, this was the last question. I think our guests are going to be here a little bit more, but we have to wrap it up. A round of applause to them. Thank you. Thank you.
and thanks to you, Jusalim, as well for your initial comments. We're break for about 15 minutes, and then we will reconvene here at 3:30 for the final session. Thank you.
Thank you. I was hoping you were actually going to get into the whole wallet thing in a little bit more detail, because that was something we actually had a... I didn't get to introduce myself.
Thank you.
Thanks so much.
Yeah, okay.
Hi. Are there any...
As a lawyer, I should read it, but I...
Slides too?
Okay.
No more presentations just yet.
The 6th.
As long as you can read knowledge,
Okay. Well, it's a little past 3:30. All of our panelists are here. Is that correct?
Correct.
We're all here. Okay, good. Our final panel of the conference will address the issues involving legal and operational issues in dealing with piracy. We have 5 very distinguished panelists, and I will leave all of the important details to Professor Greg Noon. Professor Noon.
Hi, thank you, and good afternoon for the last panel of the day. As you can see, the last panel of the day is done a little bit differently, and we'll talk about that in a moment. But first and foremost, we want to thank Case Western Reserve University. Particularly, we want to thank Michael Scharf, we want to thank Nancy, we want to thank Tim and all the guys doing all the audio. We want to thank all the students who give up their time and give up their Friday in helping out put this on. Definitely a decidedly Canadian flavor throughout the day, and so and I was good with that as someone who has done my training at the Canadian Forces College, and I have a master's from the Royal Military College of Canada, so I was good with that until General Dallaire, who I admire and respect very much, brought up 1812. So of course that evoked 1993, which was the last time a Canadian team has won the Stanley Cup. So it's the 20th. Boston Bruins fans are tough. And then the general told me he was a Montreal Canadiens fan, so it just went downhill from there. And to kind of lighten the mood and get your mind going a little bit here, we are essentially batting cleanup. We want you to pose any questions right away. We're not going to wait and leave an allotted time at the end. We have a number of questions that I'm going to ask the panel, but please, we would like you to interject with any of your thoughts. There were conversations about pirate costumes and pirate parties throughout the day. For some of you who weren't here, people were talking about their 4-year-old going to a pirate party and this, that, and the other thing. My 10-year-old, her favorite joke involves pirates. And so it goes something like this, and I promised my Virginia I would tell this joke. What is a pirate's favorite place to eat? Arby's. Okay? I know. Hey, hey, you're groaning at my 10-year-old. All right? So just back off. And then the rest of her soliloquy goes something like this: what is a pirate's favorite state? Arkansas. And what is a pirate's favorite country? Djibouti. Yeah. I don't let my daughter say words like that in my house. It's Argentina. And what's a pirate's favorite baseball team? The Pirates, of course. So she is destined for Saturday Night Live. All right, so let me introduce my esteemed colleagues here to give you an idea of our backgrounds so that you understand who is speaking. You have their full bio in your books. But Simon Barker hails from the UK. He's been focused on transportation and insurance-related matters and on the marine industry in particular. In 2012, the Canadian federal government appointed him as a transportation appeal to the Transportation Appeal Tribunal of Canada. As Simon was explaining to me last night, it's almost like an administrative law judge, but we don't use that phrase in Canada, I guess. He's also worked as a mediator with the United Nations in Cyprus and held a number of other positions and done a number of other things for the UN. We have a Navy-heavy panel. Simon is not in the Navy, but it must be noted that his wife's name is Seaborn. So it's all true. It's all true. Lori Blank, a dear friend and colleague, is the director of the International Humanitarian Law Clinic at Emory University School of Law. She's the co-author of this book here, The International Law and Armed Conflict, Fundamental Principles and Contemporary Challenges in the Law of War. This book just came out in March and is doing a brisk business. I was fortunate enough to be her co-author on this book. If you look at the spine of the book, it has our 2 names. It says blank, and then it says Noon, which some people thought said no one. So they wondered why 2 people needed to write this book anonymously. What was so imperative that they keep their identities secret? And then, of course, friends of mine thought they had bleeped out the expletive that precedes my name. So you have this book here, so if anyone would like to take a look when we're done. Some copies to... Sure. For a small fee, Ved, we can do anything. All right. Lori also, when she was, prior to going to Emory, was at the U.S. Institute of Peace, where she was the director of a multi-year project on military training programs and the law of war, and the co-author of another book called The Law of War Training, Resources for Military and Civilian Leaders, with another guy named Noon. And she directed the experts working group on international humanitarian law while at USIP. All in all, Lori's a prolific writer. She produces articles at a faster rate than I can read them. Mark Sloan is retired Royal Navy. He's a research fellow at Dalhousie University Center for Foreign Policy Studies and is the team leader for the Operational Responses module of the Dalhousie Marine Piracy Project. He served for 34 years in Her Majesty's Navy and was in command of 2 frigates, which is a fairly significant achievement. John Huggins is joined the One Earth Future Foundation in Denver, Colorado as the director of the Oceans Beyond Piracy project, which focuses on promoting multi-stakeholder cooperation between industry, governments, and civil society as the most effective and sustainable way to fight piracy. John is also retired, but United States Navy, and served as NATO's operational liaison officer to the European Union in Brussels, as well as on the operational staff at NATO headquarters. During his career in the U.S. Navy as a P-3 pilot, he served as a mission commander for P-3 surveillance planes over the Pacific, the Middle East, and Afghanistan, and has acted as a fellow at the Atlantic Council of the United States. So that's a brief summary of our panel, and thank you for picking up my pieces of paper there. That's a brief summary of our panel, and as I said, we want you to for some of you have been here all day, some of you are just coming in at the latter half of the day. We want you to join in as quickly as possible. We're going to try to kind of tie up loose ends as best as we can. So one of the first things that we wanted to talk about, and I wanted to put to the group, and I'll start with Simon, because he's on my immediate right here. What is a pirate? The definitional issues that we face in pursuing this course of inquiry. So we'll start very simply there.
Which allows me to ask you a question, right? Who here has seen the first Johnny Depp movie, Pirates of the Caribbean? Okay. And so everyone is well aware of the love story between Will and Elizabeth, right? And so as a parent of a 15-year-old daughter, I could feel for the father of Elizabeth Swann at the end when he says, "But he's a blacksmith," to which she replies, "No, he's a pirate." The problem that I have had with piracy since I first started looking at the Third Law of the Sea Convention back in the 80s was that piracy is very simply defined. And yet I've heard constantly today and in other sessions that there's some doubt about the definition. Piracy, as I understand it, as it reads in the 58 Convention and the 82 Convention, international piracy is 2 ships outside the 12-mile limit on the high seas involving violence against persons or property. Right? And I think there's a 5th one of private ends. So when I read, and I should put this caveat out here, I don't know U.S. law. I know nothing about U.S. law, but I'm quite comfortable for the next hour and a half talking about U.S. law. Right? So take what I say with that caveat. The recent decision of the Ninth Circuit with the Sea Shepherd, I think the judge got it bang on. I don't see the problem with the legal definition. What has happened over the years and the decades is that we have taken a populist term or a populist view of the word pirate and we put it into lots of different meanings. And I'll give you one quick example before I pass the microphone down and get some other comments. Blogs seem to be the way of the world, right? Every day there's a blog about something from somebody. And piracy blogs come out all the time. And a couple of days ago, there was a piracy blog, and I looked at it in light of what is a pirate definition. And I thought to myself, well, attacking a ship in the Suez Canal, which was on the piracy blog, is not piracy, because the Suez Canal is not in the high seas. When I looked at the reference in there to the fact that 7 Somalis were sentenced in Malaysia, that was not piracy, because they weren't sentenced under the piracy. They were sentenced for shooting at a Malaysian troops that were boarding a Malaysian ship at the time. I looked at the phrase about capacity building in West Africa, and that was written in the context of ship hijacking. And ship hijacking, we know, is not piracy. The only reference that I found in that blog to piracy was a reference to funding the Somaliland Coast Guard in their fight against piracy and pirates. So I think what we have to do when we have this conversation is think that the word pirate has 2 meanings. It has a populist meaning that Elizabeth Swann used so beautifully, although I think actually in her case she was actually correct, because he was a pirate, because he was operating in the high seas. And there's the legal definition, which is narrower than the populist meaning.
Mark, do you want to jump in there?
Yes, I'd like to. I think Hugh put the slide up in the last panel of the business model, and I very much adopt the business model approach to piracy, and I draw the land parallel. The getaway car driver is as much a criminal as the bank robber. Therefore, why is the supplier of boats, engines, fuel, water, information, and any other aspect that's supporting the actual physical act of piracy on the high seas not equally liable to be tried for a supporting crime? And I think the business model, for me, has crystallized that perspective. And it's not just the thug in a boat with a rifle. It's actually the supporting cast which provides him with the infrastructure that actually allows him to conduct the crime in the first place. So whether you actually say they're pirates or accessories to piracy, I think is a moot legal point, and I wouldn't dare to go there. But I think the principle is that they're all involved with the same crime.
So let me just expand on that just a little bit more. So how can we kind of exploit this idea of what you're saying? How do we make it better in the future then? Using this idea that
I
you
think
just put forward.
101 Charlie gives us the way in there from a practitioner's point of view, and it gives you the wherewithal to go after the money launderers or the ransom demanders, the ransom negotiators, the providers of engines. Where in that business model is the vulnerability? Actually, interdicting the pirates at sea is a massively intensive operation, and you might find that there are parts of that business model that you can break more easily than the seagoing bit. And once you've broken it, you've either disrupted the ability to conduct piracy, which gives you a breathing space to put something else in place to address the motive and means piece, or it might just end the piracy completely. Of course, the danger is it will actually change the business model, and you're then always playing catch up. And then how do you solve that one? Because a pirate is an adaptive foe, just the same as any other form of organised crime. They will adapt to the pressure. But I think the key thing is if you adopt a business model approach, you can try to identify where the vulnerabilities are, or it's not necessarily true that the most vulnerable point will have the greatest impact on the pirates. So where do you put your effort? Where is the most effective way of putting that effort in order to stop the crime overall, accepting the fact that the solution to piracy is rule of law on land. That's and socio-economic measures and all the rest of it to break the motive, means, opportunity trinity.
I think there's one thing, and Mark sort of picked up on the word, is that it's business. It's a good business. I mean, we've heard today that if you want to be a pirate in Somalia, you're going to get a nice house, you're going to drive a Mercedes, right? You're going to have a whack of cash. I mean, one of the World Bank's comments in 2011 was that $150 million came out of the business. That's 15% of the gross domestic product of that country in 2011. So it's a good earner. The occupational hazard, you might get caught. The out is you're unlikely to serve any time for it. So there's no downside to it, and there's a lot of upsides to it. Piracy has been described by some as the world's the 3rd oldest profession on the globe. Medicine's the 2nd, right? So there's a long history of piracy, and it's a good money earner, so why would you not do it, right?
think being a lawyer is the first, right? Okay, all right. I knew there was something involved in there. So John, let me change course a little bit. How long must the international navies and the industries follow this best management practices? How long do they must be in place to be successful in combating piracy?
Yeah, I think the first thing is to define what do we call a successful end to this game. If you ask nations and international organizations, I think the answer is once you have some established maritime security. So we talk about arresting pirates at sea, moving into arresting facilitators, and then finally bringing some governance ashore that would not allow piracy to happen. And I think Hugh talked about it earlier. You need just enough governance to break this business model, and he was talking about the different areas, and I've heard it called the Goldilocks model, where as far as chaos, there's not enough chaos in Somaliland, there's too much chaos in South Central, but Puntland is just right for piracy. So we need to have areas that look a little more like the northwest coast of Somalia with just enough governance there. But industry, I think, has a different view. One of the things we do is meet with many groups of people, and industry told us that a successful end to piracy is we stop the attacks at sea and we can go back to security procedures that were there before 2005. I personally don't think that this is going to solve it. I think what we've seen over the last few years is the vulnerability of these ships at sea has been very well demonstrated. They're going slow for the most part to conserve fuel or for not making pollution. They have very small crews, maybe 12 to 14 guys, that doesn't allow them to respond on the vessel. So there's a lot of things that make these ships vulnerable. So I think the answer is going to be somewhere in between those two. I think there's going to be some procedures that the shipping industry is going to have to adopt on a more permanent basis. But I think you also need that little bit of governance ashore that's going to break that part of the business model.
And let me slow you down a bit. Assuming that we don't have a room full of mariners, what is pre-2005? As far as what procedures were in place in 2005 that the industry wants to get back to?
Right. Well, I think when we look at what happened after 2005, they started coming together as an industry and coming up with best management practices. And those have been mentioned before, but it's certain routing procedures, it's certain speeds that you want to maintain, it's extra watches on board the vessel, it is barbed wire in some cases it's the rigging of fire hoses. Another procedure which has been very effective is the installation of citadels on board these vessels, which is basically a safe room that gives the crew some hours protection from the pirates to allow a Navy response to happen. There's also been reporting in. There's the Maritime Security Center Horn of Africa, which was established by the European Union, where ships actually check in, which they didn't normally do, provide position reports, report vulnerabilities to the naval forces so that they could track these. So all those put together, though, is a very, very expensive operation. And in our reports, we calculated that it's somewhere between $4 and $5 billion a year for the industry. So they are anxious to go back to those procedures in place before 2005.
And let's talk about the biggest item in all of this, the addition of perhaps armed security, private security firms. Let's kind of go through that a little bit and see where that takes us. What are the rules? And Laura, I'd like you to chime in a little bit here maybe with respect to use of force. When we start adding another dimension of bring your own weapons to the gunfight, which I always recommend: bring a gun to a gunfight. Don't bring a knife. So go ahead.
Thank you. Well, I think I guess I want to introduce another set of players also, in addition to the private armed guards, when we're talking about using force, and that's the multinational task forces that are out working to protect shipping and combat piracy. So we have a bunch of different players out there who are armed and using force or have some guidelines and parameters for using force. And, so we have to look at what is the paradigm for that use of force. And here we can look both at legal frameworks, UNCLOS and other legal frameworks, but also what are the rules of engagement. The private armed guards are going to they have codes of conduct, they have best practices that has been developed. It's also been developed in the contractor scenario in terms of conflict zones, so on land, totally unrelated to piracy, but we see this developing across the board where you have situations where private entities are heavily armed and look a lot like militaries in some way, but are not part of militaries, and how do we control that use of force? And then how about the multinational forces and how they cooperate? You know, with regard to the counter-piracy operations, it's interesting, it falls a little bit in the middle. Normally, when you think about use of force outside of a conflict situation, we're thinking about law enforcement, and the parameters on the use of force are very, very strict indeed, which, as I often say, is good, because, you know, we don't want a world in which, you know, anybody is quick on the trigger. But in those cases, force can only be used where it's absolutely necessary as a last resort and must be proportional to the task of stopping the threat that that individual or situation poses. In the context of piracy, what the international law allows is the use of force to board, stop a ship, and arrest suspected pirates on board. So it goes a little bit beyond what we might think of as law enforcement outside of the piracy context. It's obviously not a wartime footing when the use of force is a first resort, but it does have its own unique place in terms of how we think about some of those concepts.
If I can chime in here on a couple of ones, because the rules of engagement are something I've given some thought to. The difficulty I think that we have in the marine world is that where the ship's at sea, it's a self-contained piece of land that's flying a flag out there in the middle of the ocean. And so the 6 crew members, the 12 crew members, the one thing about modern technology is that there are less crew now on a large ship than there used to be, because the machines are doing a lot of the work. So you have few people out there, and they're all alone. So when the master is looking out and he sees that small boat approaching him, he doesn't have his attorney standing on his left arm or his right arm, so he has to do it himself. And we've heard today from a number of different speakers about the need for training and education. Rules of engagement are something that military officers get taught about. My father was in the British Army for many years, subsequently passed away. And one of the things that one of the mementos that I have from him was the card that he was given when he was in Northern Ireland, which was a British Army war zone in the late 60s, early 70s. It was his rules of engagement for people with learning disabilities. Although the card is politically incorrect because it talks about deaf people, but you know, was now people with hearing disabilities, because what the British Army were finding was that when they were trying to disperse the crowds, they would shout to people, disperse, and the person with the hearing disability wasn't dispersing, and then was wondering why he had a large bruise on his butt because the rubber bullet had bounced off the ground and hit him because he wasn't dispersing fast enough. And so sign language became important as a rule of engagement for the British Army in crowd control. What we're saying to our naval officers, and what we're having a debate as a marine industry right now, is the world is changing. We can't, as much as ship owners want to go back to pre-2005 days, because that might save them a little bit of money, and freight rates are so high, so you can't go backwards. You have to look forwards. And so what we need to do is we need to be training captains, masters, crews, armed security guards, as to what it's like out there in the waterway and what they're likely to encounter. As a Coast Guard lawyer many years ago, I used to say to my clients, you don't want me out there on the ship, but nowadays with smartphones, satellite technology, you can call if you've got a problem, but I don't expect to hear from you. Handle it yourself. And that's what we're asking them to do. We're asking them to handle it themselves and deal with the pirates, or what they think of pirates, as the boat's coming towards them.
I think going back to the roots of the question, Greg, there are a couple of issues. First of all, private maritime security contractors are a defensive asset, whereas a government-operated vessel operating under rules of engagement rather than rules for the use of force, depending on what the rules of engagement are, can be an offensive asset as well. The rules of the use of force are therefore based on the principles of self-defense, and that's how they work through. The issue arose, and my particular position is that I think the industry was slow in accepting and recognizing, and then maybe accepting the fact that there are not enough warships in the world to patrol an area the size of the Indian Ocean and the Gulf of Guinea and the Straits of Malacca and the South China Seas and all the other areas against piracy. It's just not feasible anymore, especially with the technology that pirates are now deploying and the speed of the vessels they can use, the information that's available to them. All of those aspects have increased their ability. Therefore, the industry had to get itself to a position where it accepted a degree of responsibility for its own security. And the analogy I draw again is a land-based one. Just because there's a police force in your area doesn't mean that you don't lock your front door and lock your car when you leave them empty. You take a degree of responsibility for your own security. You act to reduce your vulnerability to a crime. And I think that now that we've moved forward down the PMSC route, and it is the fact at the moment that a lot of ships in the Indian Ocean that might have employed them over the last few years are not employing them because the threat has seemed to be reduced, but the principle has been established. The rules for the use of force were industry generated, not government generated. Well, there's a degree of industry self-regulation there, which I think is a concern, but at least it's plugging a gap as we move forward. And I think the key question is, okay, we've got past this particular problem, we've got a different problem in the Gulf of Guinea, where instead of the crimes being committed on the high seas, they're largely inside territorial waters, so the coastal nations have a different perspective on it for the use of arms. But what do we need to do? What lessons do we need to identify now so that they're in the hip pocket, so when we get another outbreak of piracy, whether it's a high seas outbreak or using a wider piracy definition, a territorial waters outbreak, what lessons can we pick up now to apply in the future, and how do we take this one forward with the industry?
And that's a great segue. So with respect to where we are in our food chain, what are some of the lessons that we've learned? What are some of the things that are good takeaways?
I think it's like most situations. I think the international community comes together to solve a crisis very well. In our foundation, we use the term phase one, which is suppression at sea. And you heard the three things that were most effective, and thanks for bringing those other two up, Lori. I think private security has been an absolute game changer out there. We know that. We know that this is deterring the pirates based on their tactics, for one. It used to be they would try to come out and intimidate the crew by firing their weapons. Now, they've been shot at so many times, they do what's called a soft approach. They'll come up, not show weapons, and if the security team shows them weapons, they'll wave and move on. So we know that there's an effect. The other two things are the coordinated Navy responses, of course, and then the best management practices, which we talked about. And I guess it's late in the day, we can be a little provocative here, but amongst those that we talk to that are actually fighting the problem, the one thing we're not hearing is that there has been an effective rule of law response, which we think should be the final way of solving this. And I think that, is anyone actually deterred by the prosecutions that have happened? Have we prosecuted anybody higher than a translator? Is there the international appetite to continue to go after these guys even when the numbers go down? Are we going to continue the investigations? We just heard that the International Code of Conduct, the Djibouti Code of Conduct is already winding down, the IMO, by the end of 2014. So we're starting to see people moving away from the problem. NATO and EU, they have to make a decision on whether to extend their mandate by the end of 2014. Will they do so? Will they stay engaged? So I'll leave that on the table for the other panelists.
There's a phrase that I learned a number of years ago that I've always liked, is that, and it's those that don't know history are doomed to repeat it, right? And the Canadian experience was that we embraced piracy long before we were a country. In the days of Newfoundland's, the island of Newfoundland, was a fishing community. There was a nice shipping lane right beside it that came from Europe into North America. English ships carrying furs, French ships carrying lots of goodies, Spanish ships carrying lots of goodies. And the Newfoundland fishing fleets, when they weren't fishing, thought, well, hey, let's go out and plunder some treasure, right? The piracy in those days, if you read the story of the fishing admirals in Newfoundland, piracy dropped quickly when the Royal Navy showed up, When they started to venture from the European side of the Atlantic into the colony side of the Atlantic, or the New World side of the Atlantic, the pirates thought, guys here have got guns, they've got cutlasses, they've got cannons. It's not as easy anymore, so we're going to go and find something else that's easy, because I think Mark was bang on, is criminals adapt, or people adapt, right? I think the biggest concern that you have, or we have today, is when the navies go back to Europe, and when the rest task force members go back, will it be business as usual? If the shipping industry goes back to its pre-2005 days, then it may well be business as usual, right? Because there'll be no incentive for the pirates not to go out there. So I think that if we follow the trends, we need to improve security practice, and if we improve security practices, and we have the occasional military presence, that will cause pirates, armed robbers at sea, ship hijackers, whatever we want to call them, from doing what they want to do.
John mentioned prosecution a moment ago with a lilt of cynicism in his voice, but have any of these prosecutions had an effect? Have they had a deterrence effect, or have they simply had the effect of there's X amount of people doing bad things that are no longer out there doing bad things? Have they had any effect beyond just getting rid of those particular guys?
I don't know.
I think that to think that there's a set number of pirates, just like there's a set number of insurgents, is difficult to put your finger on. So we've heard there's about 3,000 pirates, but I think it's a regenerating number. So if 200 are taken out, 200 are there. There is not too much else going on there economically. Like I said, I think the real game changer has been the use of armed guards, which allows a defense at the point of attack throughout the Indian Ocean. And I think that the pirates know that now. I think that they've gone on to other work. As far as whether it creates a deterrent, I think that Somalia is a difficult place. It's hard to go in there and do surveys and do different things to question people on what is actually deterring pirates. I think the UNODC is trying to do some of this work with those that are jailed in different places like Hargeisa and those types of prisons, but we don't have that information yet.
I think one of the, and I'm going to give you a slightly different perspective, because my wife has been telling me ever since I had my career change in October of 2012 that I need to start listening more and talking less. And I heard something today from one of my fellow speakers that I thought was quite interesting, is that in the piracy trials that we've had so far, when defense counsel showed up, it made the prosecution it made the prosecution's job more challenging. Well, that's the job of defense counsel, to make prosecution's job more challenging. And if the navies of this world and the police forces of this world, with all the assets that they have available, like Interpol and all the rest, if they do their job properly, and the person sitting in the dock is truly guilty, then that's the result that will come down the pipe. And what the judge will be asked to do is, after the finding of guilt, is listening to sentence pleas and figuring out if there were reasons to give the person 20 years, 25 years, 5 years, whether it's a juvenile and there should be another way of approaching it, whether someone should just be locked up forever, or ultimately, if the death penalty is on the books, whether or not that person should have the death penalty. So, there is a game that we as lawyers have set for ourselves. And what we ask is that those people that come into the game with the evidence, with a collection of the evidence, do their jobs properly, do the jobs to the best of their ability, and the person that is left at the end of the day with the tough decision is the person sitting at the front saying, I like the story, I don't like the story, I think the story has some merit. But if the charge is laid, and this is the point that I wanted to make, if the charge is laid under piracy and there's one ship involved, or the act takes place at the 11 nautical mile mark, that charge is not going to be successful because they have not met the elements of the offense. If someone comes into the room with a case of ship hijacking, or this gentleman was talking about sewer and hijacking conventions, if there is a more proper charge to be laid by the state, then the state should lay it. Don't call a pirate if they're not a pirate. If they're a ship hijacker or a sea robber, or there are, someone that's not using the banking system correctly, or there's corruption, there are plenty of other ways to attack the problem. And I think one of the things that we've learned from Somalia in the last round of piracy is that national laws need to be changed at times. Kenya's problem, and they're quite open about it, was that their penal code did not accommodate piracy as the international conventions talked about piracy. So they couldn't do it properly first time round. Second time round, they had gone back to the Parliament, they had changed the Merchant Shipping Act, they had amended it, and they started to get some success. But you can't ask a judge to make a decision based on inadequate law. Get the law right. We are lawyers. You're training as lawyers. Lawyers have the ability to interpret the law, but they also have the ability to write the law. Write the law the way you want it, write the law the way it can be used, and use it properly. And I think that's one of the lessons that I've learned personally out of the Somalia exercise.
I think when we talk about prosecutions, we've talked mostly about some of the challenges of making the case, but when you include in that scenario the use of armed guards on ships or the use of multinational military forces, additional challenges can come up with prosecution, which has to do with issues involving the rights of the accused in terms of how they were treated upon capture during the time they were detained, either on board the ship and then the transfer of that person to whichever state is going to prosecute them. And all the rules that govern the use of force in these contexts, whether it's the use of force in the context of capture or the use of excessive force, what does excessive force mean, the nature of the conditions of treatment during the time the person is being detained, those all come into play in prosecution and can make prosecution significantly more challenging if there are substantial defenses or challenges to fair trial rights on those grounds. So it's another reason why it's very important to have clear rules for what are the parameters for either the master of the ship or the armed guards or the multinational forces. What are the parameters of action they're allowed to take, and what does it mean to use acceptable force, excessive force, and so on?
Mark, I do want to go to you. You keep saying that they'll adapt, and I'll open it to everyone, but what do we see on the horizon for adaptation? Do you have any predictions? Take out your magic 8-ball and guess again.
I'm going to take the question back a step. I think one of the key things that pirates have available to them now is information, to a much greater extent than they've ever had in the past. There is so much open source information about shipping movements. Anybody here who's even had a trial subscription to the AIS system, which tracks ships through, will know just how much information there is available open source. Therefore, that pirates can prepare, if they think about the problem, to a much greater extent than they've been able to in the past. And I think that's one of the things that will drive their ability to adapt. If EU NAV4 starts to reduce its force levels in 2014 or changes its modus operandi, the pirates are going to learn about it the day after it happens, because it will be all over the world's press. So that they are informed to a much greater extent than they were before. They're not picking up their information in the bars of Kingston, Jamaica, as they were hundreds of years ago. The information given.
That's where I get my information.
Well, yes. The information is presented to them on a plate. So they've got that foundation to an extent that they haven't had before. And I think, as with any agile adversary, they will adapt to whatever is put up. I mean, I think there is a lot of thinking around at the moment that Somali piracy hasn't gone away. They're just in a tactical pause. Yeah. There's a breathing space now which we really need to capitalise on to sort the problem out on land, but we can't do that until the Somali security and stability situation sorts itself out. So if we're still in that situation next year, EU therefore starts to drop back, the focus shifts somewhere else, there will be nothing stopping those pirates stepping back up. So they will adapt to the circumstances of the time. The Gulf of Guinea, we've seen them adapting as they've gone through. They've gone from capture and transshipment, they've started demanding ransoms for hostages now, which they weren't doing earlier on. So they're adapting their methods of operation the whole time in response to pressure and opportunity. If you don't do anything, they'll adapt to fill them, to make the most of the opportunity.
I'm going to go out on a limb and say Somalia is probably going to be in the same state it is a year from now. I don't know that it's going to change all that much. So aside from tactical pause and more information, you noted in Guinea they're doing something different than what they were doing. Are there any other places in the world that you see them just completely changing their business model, so to speak, like they did in the Gulf of Guinea?
Picking up the hotspots, I think the Straits of Malacca and Southeast Asia, they're fairly contained. The problem is, I don't think that the problem of piracy is ever going to go away. I don't support the aim of eradicating piracy because I don't think it's a realistic aim. I think the aim is to reduce it to a level, as with any other crime, like on land, where actually you can go about your routine business at an acceptable level of risk of having your house burgled, being mugged on the way home from work, or whatever. So looking around the world, I think Straits of Malacca, South China Sea, it's probably reasonably well contained. There might be some changes there, but it doesn't seem to be happening. The targets there are the low, slow tugs, barges, and that sort of thing. It's robbery at anchorages, that type of activity. The Caribbean, it's much the same. Though if the pressure was removed from the Caribbean in terms of the anti-drug operations and the security focus was withdrawn from there, whether that would allow more piracy to come up into it. Because I personally have a view perhaps that in the Caribbean we're seeing piracy being suppressed by the level of security that's focused at the anti-drug smuggling. And Hugh mentioned Haiti as a possible next step. I actually don't agree with that because I think there's so much security in the area that it won't happen. But again, if that focus withdraws. The Indian Ocean, we're going to have to wait and see. We've seen them evolve. We've seen the use of motherships, which didn't start to use to extend the range. Are we going to see that in the Gulf of Guinea? If the problem gets driven further offshore, if ships are going further offshore to transship and they become targets further out, are we going to see the use of motherships out there? It's that type of adaptation I think we will probably see.
I think one of the thoughts that's been bouncing around the head is we talked a little bit earlier today about the root cause, and I think one of the root causes that we have is that the world is very quickly falling into two categories: those that have, and the bigger category, which is those that have not. And so piracy as an operational model has not changed over the years. It's a fast craft, it's a slow victim, it's a waterway that's easy to get to. And so when you look at a map of the world and the major highways, the major marine highways, they do go past the developing world. And when you have something going past your within arm's reach and you don't have it, there is a portion of your population that's going to go out and get it. And what we found from a highway traffic point of view is you might have one state trooper on the I-90 for 100 miles. But if he's sitting at a strategic location doing his paperwork, that makes people go slower. He's not arresting them, but he's there and he's a presence. If he's moving up the highway, and they tend to move on a regular basis because they don't need to do the paperwork all in the same place, and if they move, you don't know where they are. So you're always thinking, I better do the speed limit or close to it because I don't know where that state trooper is. If the world's navies in the developed world are out there doing their job, then pirates will think there might be a warship around. So I've got to think twice about this. That's the type of mentality that we've got to get out. And the difficulty we have is the NIMBY attitude, that is not in my backyard. The first question that came into minds in Canada was, why do we need to send Canadian warships to the Horn of Africa when Canadians are not involved? And we had to go through a discussion or a dialogue, which is, when you walk in to your supermarket and you see all those products on the shelf, how did they get there? And the answer is because containerization revolutionized the shipping world back in, the 60s? I think it was 60s. And a lot of goods that we see that we're wearing today, that we're sitting on, come by sea in a container. And those are the ships that are getting hijacked or are subject to piratical attacks. So it is our problem. Grotius, if I can go that far back, talked about the enemies of mankind. It's all of our problem. And if we sit here in the developed world and say, this is a developing world problem, we'll never solve it. But we have to say, it's part of our problem, or we're part of the solution, and we need to do something.
And I think it's been stated about 90% of the world's goods travel by sea at some point in their existence. And just in case you've never driven on the highways in Ohio, the state troopers are everywhere. So just so you know that. So just, yeah, that's the tip you need to know. John, let me ask you this. So we're talking about this onshore capacity building. What role can the industry play in this?
Well, one of the things I think we've seen from industry, based on the calculations we've done in our reports, so they're willing to spend around $5 billion a year to protect their own vessels. But they haven't been willing to move some of that money to something ashore that's going to develop a capacity or a longer-term solution. I think our latest figures, it was less than 1% was actually put into the capacity. The rest was spent on navies and the expensive things that they're doing. One of the things that we've done, we also work with a sister foundation, and we've actually been doing work in Somalia. And in the port of Berbera, for example, what we're trying to do now is encourage industry to use their expertise, to use their in-kind donations perhaps, and other things, to try to build up these port facilities that the Somalis feel are very important. They've identified 4 ports. So I think that's one thing that industry can do, is to get more involved in that. But I think too, in the longer run, as has been mentioned, I think that there are some things that they're going to have to adapt going forward. I don't think that they can go back to pre-2005 levels either. So I think they're going to have to understand that they make that commitment also to the seafarers, to train them, to bring them aware that they're going into a high-risk area. Those kind of things I think need to continue.
And extending the question slightly, I think it's a very complex problem, because in terms of industry involvement, you're talking about investment in the country, maybe a degree of capacity building, those types of things. The issue is that there are so many agencies involved in pockets of it, sometimes working towards the same end state, sometimes not necessarily being aware of the end state they're working towards, sometimes even working against each other. The bigger question is, how on earth do you coordinate all this activity, whether it's in Somalia or Nigeria or wherever it is? And I think that is, in some ways, almost the silver bullet to this problem, is coordination of this activity, so you really invest time, effort, money, everything else efficiently and effectively, rather than piecemeal and suboptimally.
Oh, feel free, any time you'd like to interject. I'll let Lori finish her comment, and then I'll become Phil Donahue.
One other challenge with rule of law building, which obviously is going to be essential here, is you need to have buy-in from the society to have effective rule of law building. We see that in lots of places where we engage in capacity building, which really is, I think, sort of a catch-all phrase for this. But here we have a slightly different situation, which is that the society where we want to see increased rule of law is not the location that is suffering the effects of the particular acts and crimes that are being committed. You take maybe a post-conflict society, you are able to tie together the need for the rule of law reforms, I think, much more effectively, because it's right there where people are dealing with the effects of organized crime or looting or continued conflict, whatever is going on. Here we have a total separation, because the attacks and the crimes that are being committed are, whether they're on the high seas or in the territorial waters, they are not in the location of where we want to see the rule of law built. So it does add a layer of complexity, I think, to the challenge of how you do it.
Well, thank you. I didn't want to interject until you started on that issue. What has really happened is that all day we have been talking about these legal operational problems. And one thing that we keep saying is that long-term issues are going to be in Somalia on the land. And then we keep saying that at the present time, since there is no governance there, it won't happen. Let us assume that Somalia becomes a country that, like many other developing countries, least developed countries, that it has got some rule of law, it's there. Then the question that I would ask is, where is at the present time the political will in the country to rebuild it? At the present time, the World Bank has said that the only answer to that question in Somalia is to take care of Somalia on land. And I have a question, because developed countries, time and again, have pledged to help countries to develop, give technology that is proper, and it has not happened. Every pledge that has been given time and again has not been given, not been realized. Those promises are broken. And a public-private partnership that John is saying that industry might do, and then the question raised how the coordination is going to happen with all these agencies. So I think it's a pretty grim prospect that the naval presence is going to go away. Armed security guards are pretty expensive. Accountability is not there, so we might have difficulty there. And then we talk about the land, and for land capacity building, we talk, all of us, but how much money is it going to be needed? How effective it's going to be on that land? That is the issue that I would like to see my experts, friends, to tell us.
Can I jump in there?
No, absolutely.
I think the solution is it's like a five-fingered hand. There's a little piece of the puzzle everywhere. I don't believe the Marine police would ever or should ever disappear. The ideal situation would be, as we know, one of the subjects on the agenda for the Dubai conference next week is funding the Somalia Coast Guard, right? Is that you want the coastal nation to step into the breach and look after its own territorial waters, and then leave the high seas, in effect, from the tropical limit out. Well, they call them different zones now, but it's the leave the high seas for freedom of navigation, and a warship of any nation can pull in a pirate if and when that's seen. So it's, I mean, that concept, I think, is out there. It's been out there for a very long time, and it should be allowed to work. So, you know, the question is capacity building for coastal authorities, coast guards, to look after their own robbers, pirates, right? Bad guys. I don't think it's correct to say that people are not going to these parts of the world to help. I mean, I know that the World Bank has various consultancy teams. Trade and logistics is one where they send people over there to help. I think that the hardest thing for a lot of these teams is they go there, they offer suggestions, some money is left, and then they leave, and then there's a question of sustainability, right? And I think that's where we have some problems, is not the going in and helping, it's the once you leave, and is that going to be sustained? I put it out there, I'm an optimist, I've always been an optimist, right? And I think that pirates are like any other criminal. They're just part of society, right? That we have a criminal justice system. We have an international criminal justice system. We have a domestic criminal justice system. I think that we as lawyers can write our laws better to achieve the purposes we want. I think we can teach our warships and our ship's master to collect evidence in a way that the prosecutors can use it. I think it's correct that Somali pirates are tried in the region and not brought out of the region because of cultural differences, cultural norms, what people feel to be right or wrong. But equally, I mean, I accept that if someone kills 4 Americans on a sailing vessel, that there's a need to repatriate those people to America to stand justice. Right? And then the question is, justice for who? Why would you charge Somalis with murder, bring them to Virginia, when you could have tried them easily in Mauritius or the Seychelles or in Kenya? Right? So I think the regional approach is correct from the justice point of view. And I think that a dollar spent wisely or focused can go a long way than $100 just thrown at someone. So I think there is hope. I don't think it's the dark picture that we've always said it's going to be, but I do think that we need as a society, as an international society, to say pirates at sea are symptomatic of a deeper problem. What is that deeper problem, and how best to attack it? Is that US aid? Is that Australian aid? Is that Canadian aid? Is that a mixture of all? Why can't we go to Africa and help? Right? Because if the ability is in the developed world, and the developing world are asking for it, take it. Partnerships do work. I'm not sure whether it's private sector or public sector, but international partnerships do work. That's why, I've been very impressed at just how much Case Western students go abroad, because pro bono and voluntary work seems to go a long way. What happens after the fact is the concern. Sustainability is a huge concern.
Yeah, I think, amazingly enough, I think there's opportunity. It's been since 1991, but I think that what has created the opportunity, strangely enough, is the piracy issue. It has focused international attention there, international effort, and it has it made it a sense of urgency. I think we've seen the first elected government that was elected in September. You've heard about the Dubai conference. The other thing we hope will happen, as of now it's on, is that all the regions of Somalia will sign up to an agreed maritime strategy, which I think is really important to end the problem we're talking about here. But I think that now is a time, I think, that we should take advantage of that. One thing, again, to be just a little provocative one more time, is historically, all of the aid and all of the decisions have been funneled through Mogadishu. Now, Mogadishu controls a very small part, or historically did, a very small part of that country. We ignored Somaliland, Puntland, Galmudug, some of these other places. So we have left them alone in a sense, and some people diplomatically are not even allowed to say the word Somaliland. So they'll say the northwest coast of Somalia appears to have no piracy and appears to be able to stop that. But we have not focused on that because the sole focus has been through Mogadishu. And if you believe some of the UN reports, up until last year, up to 80% of those funds were just disappearing. And yet we continued to ship money through there. So I think what's needed is kind of a different approach. We invest in small entrepreneurial companies, things like honey, jewelry manufacturers, Somali fair fishing. So these are some of the things that we've been doing to see if we have some scalable economies that we can invest in as a private sector rather than straight development aid.
Okay, let's take a question here.
Thank you very much. It's been fascinating. I think this might segue well with what Mr. Barker was just talking about. Oftentimes I discuss with my students at Baldwin Wallace the topic of climate refugees, and we frequently talk about the QDR, the Quadrennial Defense Review, and how the Pentagon is talking about, for instance, the rise of climate change being a threat to coastal communities, and really the lack of a legal framework internationally to deal with people who have been displaced by natural disasters, floods, droughts, famine, and so forth, whereas we do have systems in place to deal with people who have fled from conflicts, genocide, war crimes, and so forth. Going forward, if we are going to continue to see a rising threat along our coasts to all of these communities, do we expect to see a rise in piracy? And have we thought about what to do in that kind of situation too? Thank you very much.
If I pick up on it, and again, it reverts back to what Hugh Williamson was saying earlier, that one of the precursors of piracy is attacking refugees. And if we have environmental refugees, then that has the potential, not necessarily the actual, but certainly the potential, to provide an opportunity that the ill-disposed will exploit, whether it's ISIS piracy or armed robbery in territorial waters. So I think from that perspective, and this was again the Haiti example, yes, there would be a very real potential. I mean, we saw even in the Mediterranean, some of the refugees coming from forming Yugoslavia being attacked on the way through and things being stolen from them. So wherever there is that flow and there is opportunity, if someone's in the right position, they will exploit it. So yes.
First, I have to ask Professor Noon if his daughter has told him the pirate's favorite kind of socks. Argyle. I wonder, no extra charge. I wonder, Mr. Huggins and Mr. Sloan, given their naval backgrounds, if they're familiar with the World War I concept of Q ships, and if with a reduction in the international naval presence, that concept might be reintroduced and adapted.
Would you like to help a Q ship very briefly?
It looks like Captain Sloan remembers. Maybe he could tell us. I doubt that.
For those who didn't know, a Q ship was a merchant ship with its armaments disguised. The U-boat would surface, demand that he stop so that they could board and sink him. As he did so, the Q ship dropped the gunnels, the weapons were exposed, and they sank the U-boat. It was a scheme that worked quite well for a while. Would it work against Somali piracy?
Or anywhere.
Or any piracy? It could work, but I'm not sure it's a route we'd necessarily want to go down. And are there not better ways to solve this problem? Because again, it's addressing the symptom rather than the cause. And if you accept that, as with any organised crime, piracy is driven by motive, opportunity, and means, one of the ways of reducing opportunity is to reduce vulnerability in the potential targets. And that is probably an easier way than decking a ship out as a Q ship and taking the pirates on that way. I think would be my perspective on it. It's make a good movie, but I'm not sure it's one that I personally would see being particularly successful or desirable.
I would say you already have them. It's called private security teams. They approach the vessel, and it's not a fair fight. You have ex-special forces guys 40 feet high on a stable platform against a skiff. It's not very close, and I think that's why you've seen the tactics change. I think, too, the one thing you don't have, though, with private security, and we haven't really talked about, they're not there to arrest people. So the law enforcement aspect is not there if the navies pull out. So that's what you're missing. You're meeting force with force. And I agree with the Commodore that that's not the long-term solution that anybody's looking for.
I think the other issue too is why hide the guns? I mean the whole point of if the pirate, which is in a small boat, is going up against a big boat, right? The pirate knows that subterfuge is not going to work, and they're not going to be able to climb up that huge ship because no one's going to put a ladder down. And there's a guy at the top that's got a gun. Why go up there? The deterrent aspect of it, from the law enforcement point of view, is that the person's out there with a weapon. If the warship's out there or the policeman's out there, you're not going to want to go out there. So this is not. It's not a case of taking the war to the pirates. It's not a pirate war. Right? It's a law enforcement issue, and we should think of it as a law enforcement issue. And what we're seeing on the waterway is simply a symptom of something that is deeper that we need to address.
I actually think we go the other way. I think maybe mounting some fake guns might act as a deterrent than going the other way on that. Lori, and then I'm going to go to a question.
Just one point to follow up with regard to if the navies pull out. It's my understanding, and there needs to be, I think, much more development on this issue, that the master of the ship, even on a private vessel, has some authority with regard to, maybe law enforcement is too strong a word, but if somebody were to attack the vessel, they have some authority to detain, at least briefly, while they figure out what they need to do with this person. This is not something that has really been addressed, and I know there is some discussion, certainly in the piracy working group, to look at what is this power that the master of the ship has? Does it change if he or she has armed guards on board? What is the extent of it? How long does it last? And so on and so forth. So I think that may be something that comes into play eventually if the navies pull out, and there needs to essentially be some gap filling to kind of flesh this out and have some best practices that, of course, are in line with the existing legal framework, but since nobody's really pondering what that legal framework is, to try to build it out.
One of the weaknesses of the international justice system is that the ICC doesn't have a force to arrest people. It's got to depend on other people. Remember Yugoslavia and other scenarios. Without that capability, it's difficult for it to implement any sort of process in which it can bring people to court. But last year, I'm the deputy chair of the Defense Committee in the Senate. And last year, we passed legislation, what was called Shipwriter, in which Canadian police are on American Coast Guard ships and vice versa on the Great Lakes and on both coasts, so that if somebody is running through the border, we don't break off the chase, we keep on going. So this American ship, as long as it's got a Canadian policeman on board, can continue in Canadian waters and arrest and prosecute. So what about, because of the vacuum that potentially is going to arrive, is there not a capability of having the UN attempt to introduce a capability of that nature within the international sphere of having shipwriters, of having actual police type of force, not just the security guys, but an actual police, recognized international police person, a sort of a variant of Interpol or some damn thing, on those ships, so that, yeah, once they get them, they can arrest them and put them through the appropriate processes that are a grave concern.
Can I hold you, Simon, for a moment? And Ash has two fingers to add, and then I'll go.
It just so happens that the International Maritime Organization adopted a draft international instrument that does that very thing, that it would provide for what we call shipwriters in the various contexts to deal with law enforcement situations. And you could do that in this situation, but there's a draft out there. I wrote it. Based on what we've done in the context of with the Canadian one, which was the Canada-U.S. one that the general was just talking about, which was a follow-on to the stuff we did in the Caribbean over the last 20 years.
And did I not see something in the Code of Conduct for West Africa that says something similar?
Yeah, and it comes from that same experience.
I mean, I understand why it makes sense in a regional document, right? Because, and I forget the number now, but there is a lot of water on this planet, very little land, right? And the shipping lanes around the globe are well known, right? But the difficulty that you have with the shipwriters is Panamanian flags, Cypriot flags, Liberian flags. There are German ships, there are French ships, British ships. I mean, the nationalities are all out there. And so the concept of Article 100 and the concept of the law of the sea was, if you are out past the territorial waters, 12 miles and out, and you are engaging in political activities, or you have a flag flying your mast that's not a recognized national flag, like the Jolly Roger or whatever you want to call it, and you are in effect a stateless ship, then any warship of any nation on the globe can pull you in. And there doesn't have to be this jurisdictional link. That you can take that international crime and take it domestically to any country and try that person for that international crime. The difficulty I think that we have is, this is what the point I was trying to make when I started out, is I don't think there's a problem with the definition of piracy in the Law of the Sea Convention, because it's exactly the same in the 58 Convention, which the US has signed, and it's very similar to the one that we had back in 1920s with the League of Nations, other than the fact that we didn't have a reference in that document to the high seas. It was any sea crime we were talking about. The difficulty that we have today was the problem that Kenya identified, and other countries have identified is that people don't take. We sign the international conventions, we ratify the international conventions, we talk about embracing the international conventions and international customary law, but we then don't go the next step and put those words into our domestic legislation. And so when a judge is sitting in a Canadian courtroom or an American courtroom or a Kenyan courtroom, and the prosecutor is saying the law of piracy, the judge trained in domestic law goes, but it's not here. You're asking me to do something that I cannot do because the statute of the law of my land, our constitution, does not allow me to do it. Which is my point to all of the young law students here is you have the ability to interpret the law, you have the ability to read the law, but you also have the ability to write the law. Write it like Mauritius has done for a particular purpose and use it for that purpose, right? And don't try and put a round peg into a square hole.
John?
Yeah, I think one of the things I've heard mentioned is this concept of universal jurisdiction where anyone can prosecute has kind of turned into since anyone can prosecute, no one will prosecute. It's an expensive proposition. It is long-term. These are long sentences, and there's no guarantee that the person will go home at the end of the sentence. There might be some legal restrictions on that. I think, though, that the problem is detaining and arresting these people. No one really has an appetite to do that. I think a merchant vessel has no appetite to bring these dangerous people on board. It's also a very dangerous thing to do. 80% of those even that are captured by navies are cut loose on the shore. And this legal detachment kind of was a thing, and my colleague from Kenya might know more, but as we understood, there was a certain amount of time that you had to get this person before a magistrate. If you had a Kenyan arrest at sea, then you had to immediately leave the Navy patrol area, an entire vessel, to bring these suspects in. And I guess we could talk about that at cocktails if that's true. But it's a very difficult thing, and there's no great appetite to arrest.
Well, I will tell you one anecdotal story because it was told to me by a Canadian commander of one of our warships that was deployed off the Horn of Africa. When faced with a boatload of Somali pirates, his concern was not collecting evidence. It was not where did he send them to be prosecuted. It was they were hungry, so they should open the galley and give them some food. And how much gas did they have in the motor, because he was sending them back to shore, minus the weapons. They were going to keep the guns. But he did not want them to run out of gas between his ship and the shoreline, because then he would be tasked for search and rescue, and he'd have to go and help them and save them, right? So the concern for the commanders out at sea, the rules of engagement are, we're still dealing with human beings. Now, they're admittedly, they call themselves combatants, but they're humans. And, you know, when you have 12 of them sitting in the dock facing charges, justice is being performed. The question is for who? You know, so if someone has died out at sea or someone has been killed by a pirate, you can understand. Justice for the victim, justice for the pirate, justice for the country involved. I think the difficulty we have is because we're dealing with an international crime on the high seas, there is this de-link between our nation and that situation. That whether it's tenuous, or there's a complete de-link, and so if there's a de-link, we go back to the NIMBY, right? I don't want it. It's not my problem. I don't want to deal with it. But it is our problem because we all signed on to the Law of the Sea Convention in '58 in the high seas, or we signed on to the '82 one. We say it's our problem because we, as mankind, have made it our problem, right? And the difficulty is we don't want to then go the next step. Mauritius are going the next step, but they've done it in a very logical way. Is they saw the problem, they changed the law, and now they're prosecuting on the new law. Which makes you wonder, as a member of the judiciary, that's a foregone conclusion. Why not plead guilty and just throw away the key, right? Because the law has been written to put them away, right?
Let's go here to a question here.
Two things. First, I say with some trepidation, considering the jokes around here, September the 19th is International Talk Like a Pirate Day. So save it for September the 19th. Yes. Mark, you'll be on CBC for that one. But my more serious point is that we've concentrated a great deal on the threat to the international community from the pirates and in the weaker coastal states. But what we haven't looked at is one of the precursor events, and that is when you have a failed or failing state that cannot look after its 200-mile economic zone in coastal waters, there's a tendency for illegal fishing, illegal dumping, for the international community to go in there and start exploiting it. And that has been one of the major precursor events. So we've talked sometimes about an international mandate that maybe the United Nations Security Council has got to recognize in a Somalia or someplace like that, all right, if you can't look after it, we will send forces in there to keep not only the pirates from getting in there, but also to keep the illegal fishing, the illegal dumping, and all of the illegal activities that the international community will go in and take advantage of. And how you actually put that mechanism in place to avoid the piracy from taking place initially.
John?
This actually came up in several contact group meetings, and believe it or not, one of the messages back was, well, we might be fishing there, but since there's no EEZ, it is simply not illegal. And I thought, well, okay, maybe legally, but you know, is that really the way we want to do this? I mean, we'd love to see a commitment from nations that they will not fish in Somali waters until they declare their EEZ. And as difficult as that is, with all the different pieces of Somalia, the resource sharing and the EEZ is a very difficult issue, and it'll probably be many years before it's solved. So, you know, we'd love to see some commitment from the international community to protect that zone until it can be formally declared.
But I think it goes to first principles as well. It came up earlier on that one of the background reasons to Somali piracy was the reaction to toxic dumping in their waters and to illegal, unregulated fishing. Hindsight's a wonderful thing, but actually if the international community had recognized the problem then and stepped in to stop it, would we be where we are now? No, the answer is no, because the rationale for a lot of that early piracy would have been removed. Therefore, would it have escalated to the type of piracy we saw at the height of the Somali problem? I certainly think from an operational responses point of view, that there's actually a responsibility for the international community where a state fails and clearly cannot look after its own waters, just for the UN or an organization to step in under an international mandate and say, we will look after this for you while you get yourself sorted out, and then take it forward from there. Now, it's lovely in theory. The practice, as you say, might be a much greater challenge, but I think it is quite an important principle.
Okay, we have 5 minutes left, so we'll take one quick question, and before I turn the microphone over to Ash, after Ash goes and any response to his question, but I want the panelists to start thinking about where do you think we'll be, again, taking out your crystal ball, where do you think we'll be in 3 years, 5 years, 10 years? Not where do you hope we'll be, but realistically, where do you think we'll be?
Mine isn't a question. It's a reminder of something we haven't yet talked about. But two things with regard to the Somali pirates' excuses. The Secretary General of the UN had a report out not too long ago that cast great doubt on the realities of the, quote, illegal dumping and illegal fishing. So I think one has to be very careful about that. But on the illegal fishing, the FAO has done a very strong, basically a port state control on IOU fishing, to the extent that you have a fishing vessel that is engaged in IOU fishing anywhere, that the party to that is enabled, in fact required, to prevent the fish from being landed in that port. It takes away all the economic incentives associated with that. So there are things that are going on in that regard. And the other thing is, with regard to your question or comment with regard to what you heard at the contact group with regard to the EEZ, to me that's irrelevant, because there is a 1980 Somali law of a 200-mile territorial sea. And from the standpoint of the domestic law, how you look at it, it's illegal to fish at 200, regardless of whether you choose to characterize it as an EEZ, which the UN Security Council has done, or a TS. It's there. And you don't even have to worry about this new hidden 1989 line. So, I mean, I think that the combination of those two things are available as sources. And finally, just one comment. We haven't talked about, which is essential, is that increasing the capacity of the coastal states, whether it be in West Africa or whether it be in the Horn of Africa, of patrolling and providing law enforcement in their own waters and nearshore areas. A lot of that's going on, but that's the key, I think, once you do it.
Mark, let's start with John. Go ahead.
Yeah, first, just a quick response. If you notice in my response, I didn't say that the illegal fishing led to piracy. I'm just saying we shouldn't do it, which I think is any country's right. It's also in the best management practices that fishing boats should not approach within 200 nautical miles. Interestingly enough, it's one of the 4 mandates of the EU NAVFOR to monitor fishing. We've been asking for the stats for 4 years on what that is, but we haven't been able to get them. So, you know, someone is tasked to look at that. And I think I'll turn it over to Mark because I haven't had time to think about my next question.
We've been given the 2-minute sign, so there are 4 of you, so let me do the
Mark
math.
has a wrap-up
Divide by
speech.
9
I think
over
he's
the
getting
4,
ready
5.
for.
Okay, you get about 30 seconds each, so that's the way my math works out. So what's your prediction? What's your prediction where we're going to be?
I think that they will extend the NATO and EU mandates for another 2 years. I don't think that necessarily means that you're going to have that many ships because there's many missions that are under-resourced from NATO and EU. I think that you're still going to have, you have right now some privately trained Navy forces within Somalia. I don't think you're going to have any capability there or the capability of the region. So I think we're going to have to maintain BMP. We're going to have to maintain some Navy presence there over the next 2 years.
Okay, Mark?
I agree for the Indian Ocean. I think the Gulf of Guinea, I'm not sure what progress we're going to make there. It's a different problem because it is so complex in terms of the relationships between the coastal states. The levels of corruption are so high. I think Nigeria is still the most corrupt state in the world on the list. And until you solve those problems, you're not going to solve the piracy problem. There has to be political will, and there has to be an overall security strategy in order to sort the problems out.
Lori?
I think with regard to the multinational forces, we're going to see continued development of coordination on things like use of force, detention, transfer, as the need arises. We've seen that on the land version when we look at coalition forces in Afghanistan as conditions have changed, as states' appetite for being involved in different things has changed, we see, well, we're not detaining anymore, or this or that. So I think we're going to see some continued development of those
Simon, 30 seconds.
coordinations.
Caveat, I'm an optimist.
Now 25 seconds.
Okay, I see joint international Navy domestic Coast Guard operations in the territorial waters off the Horn of Africa. I see the Law of the Sea Convention as a package deal unamended. I don't think that Holy Grail will ever be touched. I see the U.S. Senate passing or making a decision to ratify the Law of the Sea Convention, or having done that. I see the Romeo Dallaire School for Children flourishing in Central Africa, and all of us going there to teach them about things that they shouldn't do to avoid piracy. Fun? With Hassan as a guest speaker. And I see problems around the world, piratical problems, sea robbers, hijackers still occurring. And I see a need for, and I see domestic legislators changing their laws to better reflect.
Yeah.
And an optimist.
And with
and
that
that's
said,
my future.
There you go, on time and under budget. If you can join me in thanking all of them.
And thank you, Greg, for the final panel that we do almost every conference is a roundtable, and it takes a rare talent to keep it going the way that Greg has, and so good job, and good job to all of you. Thank you. So 2-minute closing. I look around and I see a lot of exhausted faces. I feel exhausted. There's been a lot of brain food today, a lot to chomp on, and it's been terrific. So I took a little excursion with General Dallaire and the prosecutor and the judge and Melina Stereo to do a quick radio broadcast of Talking Foreign Policy. And we made it back in time for this panel, which was fantastic. And that Talking Foreign Policy broadcast, for your information, will be broadcast Tuesday evening at 8 o'clock on WCPN 90.3 FM here in Cleveland and worldwide over the internet. I want to also thank Nancy Pratt, who's never here when I thank her, but hopefully she's hearing over the monitor over her shoulder. Brian, who I see in the back of the room. Ray, who's probably running around setting things up. I want to thank our co-sponsoring organizations, especially the Wolf Family Foundation, our panelists, our panel chairs, and especially our keynote speaker for a really wonderful luncheon speech. Thank you. This morning, the Mauritius prosecutor, Reshma Bikari, said that we had entered a new legal era when it came to piracy. And I think that was a fascinating thing to launch us off on, that thought. And basically the resurgence of piracy in modern times has led to new law, a lot of new law. And the context of my recent book, it's a Grotian moment, really, for international law. We've heard today about how land-based acts are now covered in piracy. Nobody would have thought that, I think, until recently. Recently, there was a prosecution for the mere possession of piratical equipment under universal jurisdiction. New precedents that have really far-reaching implications. During our radio show, we talked about how the recruitment of child pirates may be prosecuted in the future as a crime against humanity, the way the ICC and the Special Court for Sierra Leone have been prosecuting the recruitment of child soldiers. That will be an interesting development. And then what we've heard in this last panel is the possibility of universal jurisdiction for reverse piracy, the excessive use of force, the mistaken use of force, dealing with the problems of the solution of piracy, especially when it came to the private contractors. Well, the title of our conference was Endgame. And I'm sorry to say, from listening to the final panel and all the other presentations, we're not quite there. It's not quite the end. But we're getting there. We've come so far since 2008, and especially, Simon, when I hear your very optimistic forecast for the future, I think we are getting closer. Notwithstanding the fact that I think that those ships are going to be drawn down, especially once the bombs start falling in Iraq, which are likely to happen. I mean, it's Syria. Thank you. No, not Iraq. Been there, done that, Syria. Well, we at CASE, my students, the professors, the academic consortium that involves many of you who were involved in our experts meeting yesterday, will continue to work with the UN, the foreign prosecutors, the Interpol, the international experts, and we will continue to wrestle with these issues and try to facilitate responses to slowly bring piracy to heel. So, one last round of applause for our panelists, please. And then an even bigger round of applause for you, the audience, who have sat through all of this and asked such great questions. For you, the audience, there is a reception immediately following this in the rotunda behind. For the speakers, you need to go and change because the bus boards for your dinner promptly at 5:30 p.m. And with that, I bring this conference to a close. Thank you.